Stream check. 1, 2. Stream check. 1, 2.
All right, let's go on the record. Good morning. Today is March 6, 2025. The time is 9:00 a.m. This is a continuation of the evidentiary hearing regarding Missouri American Water Company's request for a general rate increase for its water and sewer services. It's the commission file number WR-2024-0320. Before we get into evidence today, I do want to state on the record that the original hearing schedule had us taking up universal affordability tariff as the first issue today. We will not do that. We will take up revenue stabilization mechanism first. There's a possibility that universal affordability tariff may be part of a partial stipulation agreement, and there are also possibility that two other issues may also be part of that stipulation agreement. Am I stating that correctly?
I think probably one other issue
Okay.
at this point. But
Okay. All right. And let's see. The staff of the commission has a new counsel at their table, so if you would enter your appearance for the record.
Casey Aslan for commission staff.
All right, thank you. All right, so I would assume that the parties would like to make opening statements on revenue stabilization mechanism. So if the company would like to do that, you may proceed.
Thank you, Your Honor, and may it please the Commission. My name is Nicholas Kyle. I'm with the law firm of Barnes & Thornburg, and it's a pleasure to be here in Jefferson City with you today, this morning. My opening on the RSM will be brief because it really is a fairly straightforward issue. We have a statute, and I'm going to quote from it. A water corporation may make an application to approve rates authorizing periodic rate adjustments to ensure revenues billed equal the revenue requirement due to any revenue variation resulting from increases or decreases in usage. Now, admittedly, and I think everyone here would agree, you have the discretion whether to approve such an application. But we can't lose sight of the fact that the legislature has given you that power to approve that application. They didn't pass this statute intending it not to be used. The arguments that we hear against the proposed RSM are largely arguments against the statute. The standard for approval of an RSM is not whether the concept of an RSM is good or needed or appropriate. That question has already been answered by the legislature. The question is when and how you choose to use the power. The question is not whether the lack of an RSM resulted in insufficient funds to provide safe and adequate service or to earn a sufficient return on equity. That language is not in the statute. It is not a test that the legislature has passed. As I said, you have the discretion to approve or reject an application for an RSM when it is properly presented to the commission, but we must keep in mind that you have been given the power to approve that application. The other question that surrounds the RSM is should we offset for incremental production costs? We all know that for every gallon of water that is sold, there is a cost that is incurred to treat that gallon and to get it pumped to the customer. It usually consists, for the most part, of chemical costs and purchase power. The objective, and let's remember from the statute, the objective from such a mechanism is to assure the utility is recovering its revenue requirement which may vary based upon these variations in usage. If we don't recognize that there is an incremental cost of production of that variation in usage, then we are not going to be assuring recovery of that revenue requirement. And the parties have all focused on the scenario of what do we do if we actually sell more water than is assumed in the revenue requirement in this case. You know, how do we have a prudence review of that incremental production cost? Well, let's flip that around on the other side. And let's assume we sell less water than is assumed in the revenue requirement. The other parties would have us believe that we should only adjust the revenues and not factor into that the reality that we didn't incur the cost to produce those lost sales. And that wouldn't make any sense. The legislature wouldn't have enacted that sort of mechanism that would have us recover revenues without recognizing that we didn't incur costs. Well, that door has to swing both ways. And so for that reason, it is natural, it is critical to the workings of the statute, or to the workings of the mechanism, that we reflect the incremental change in production cost that relates to those changes in sales. I'm happy to answer questions, but we also have Mr. Ray here who is far more versed on the mechanism.
Chair Hahn, you have a question?
First, if you'll indulge me, happy birthday, Judge Sire. We didn't know we'd be making him sit through a rate case on his birthday, but we sure do appreciate him here at the commission. But then secondly, since you focused on the statute this morning, the second example you just gave was under and overselling of your commodity water. But the statute also has a true-up, right? For
Yes.
over and under collections. And then also, yesterday in, it was on the ROE discussion, there was some discussion, I would say minimal, on risk. And the statute does also say, in subsection 8, the commission may take into account any change in business risk. Who, would your witness be able to talk about the change in business risk experienced by Missouri American as resulting from implementing an RSM?
Well, I believe what we heard yesterday from witness Bulkley was that the change in business risk from the RSM has already been factored into the analysis because her proxy group includes companies, all of which have a similar mechanism. And so when she is setting, when she's proposing the range of ROE, that's already factored that in. I don't know that we have a witness who could give you Missouri American specific, what does it do for them, because it's already, the analysis has already been done, baking the RSM into the calculation.
Would your witness be able to know how many water companies and water companies alone, not electric or gas, so not talking about the proxy group, that have an RSM?
I suspect so, or at least a reasonable estimate. I don't want to speak for him, but I think there's he is quite knowledgeable about these types of things, so.
Okay, thank you.
All right, thank you. All right, would staff counsel like to present an opening statement?
Good morning, and may it please the Commission. My name is Casey Aslin, and I am here on behalf of Commission staff. Missouri American has now explained to you what they view as the benefits of a revenue stabilization mechanism, or RSM. Now I would like to speak about the disadvantage of an RSM. Missouri American states that the implementation of an RSM will allow the company to align its actual revenues with the Commission-authorized revenues that result from this rate case. At first glance, this seems reasonable. Why wouldn't we want a utility company supplying a necessary service to Missouri citizens to have a stabilized level of revenue? Well, they already do. Missouri American's yearly revenues have been trending up for the last decade. Missouri American's yearly revenue in 2014 was over $270 million. In 2023, it was over $450 million, and Missouri American has not presented any evidence to show that this trend will change anytime soon. Simply put, Missouri American is attempting to turn authorized revenues into guaranteed revenues. No matter the quality of service provided or the amount of water delivered to its customers, Missouri Americans wants their customers to supply an equal level of revenue. Without an RSM, Missouri American is incentivized to provide the best quality of service to its customers, and customers are incentivized to conserve water and see that conservation reflected on their bill without later seeing an RSM surcharge. Missouri American states that an RSM results in risk sharing between customers and ratepayers, and they promote this risk sharing as a benefit. In reality, there is no shared risk, only a guarantee of revenue to the company. Without an RSM, Missouri American is incentivized to find efficiencies between rate cases. With an RSM, that incentive almost disappears because revenues are guaranteed. Staff would prefer that the Commission not approve an RSM. Once approved, an RSM will not go away, but the concept of making an adjustment for the lowering of the risk to the utility will fade over time, so the ultimate result will be an RSM and a higher ROE. For instance, the Commission has the ability to look at the impact of an ROE due to the fuel adjustment clause. Since the FAC is now baked in, there is no review of the impact on the lowered risk to the utility and the inclusion of an FAC mechanism. Further, although Missouri American witness Bulkley did not admit to the lowering of risk to the utility in her RSM testimony, witness Ray does acknowledge that there is a transfer of risk from the utility to the customer. Thus, if the Commission chooses to approve an RSM, it only makes sense for there to be some acknowledgement of the shifting of risk away from the utility. While the lower ROE is one way, the Commission could also order a capital structure that is more consumer-friendly, similar to that proposed by staff or OPC. The utility is granted an ROE because of business risk. As risk is limited or reduced, as through an RSM, it should be recognized. The consumers, on the other hand, do not have any mechanism to compensate them for any risk. So it is an asymmetrical mechanism that allows for risk to be added to one party without any compensatory benefit. Later this morning, staff witness Michael Abbott will take the stand. I encourage you to ask him any questions you have regarding staff's position on this issue and how it will negatively affect ratepayers. Thank you, and I am happy to answer any questions you may have.
All right, do the commissioners have any questions? All right.
Judge, I
Yes.
have one, Commissioner Mitchell.
Commissioner Mitchell.
Are we aware in, past years if the company has been unable to collect their authorized revenue? Has that been a problem in the past for the company? Do we know that?
I unfortunately do not have an answer to that question.
Is there a witness you're bringing forward that might know that?
Possibly a company witness. I am not sure.
Commissioner, this is Dean Cooper from, on behalf of Missouri American. Mr. LeGrand, Missouri American's witness, does have testimony on that subject and would be able to answer those questions.
I appreciate that. Thanks.
All right. Thank you, Ms. Aslan. Mr. Kaufman, would you like to present an opening statement?
Is it okay to stay here? Or,
It's all right with me.
May it please the commission, I can be brief because I think Attorney Casey Aslan stated it as well as I could have. The RSM is a concern because it transfers risk to consumers. The result is that rates go up faster, and even though an individual customer might be able to conserve on their water usage, the overall body of customers are, in a sense, punished for conserving. So if they use less, then then everyone's rates go up later, and that seems like a perverse incentive. It reduces at least the reward that customers expect when they conserve. We also, the RSM is complicated and has some other unintended consequences. We have testimony from an expert, Roger Colton, who's available today remotely, and he goes into an additional concern that we have about how the RSN would impact low-income customers. And so you could ask him those questions. That's all I have.
All right. And Mr. Kaufman, just to remind us, you are counsel for Consumers Council of Missouri and AARP.
Yes, and Consumers Council is sponsoring Roger Colton, who's an expert on a variety of things.
All right. Do the commissioners have any questions for Mr. Kaufman? All right, hearing none. Thank you. Would any of the other interveners like to present an opening statement? All right, Mr. Opitz?
Good morning. Happy birthday, Your Honor, and may it please the commission. The company is asking for a over 40% increase, and embedded within that is a 10.75 ROE. I understand from this morning that the company believes it is entitled to this RSM mechanism, which is a way that will allow the utility to charge more from customers outside the full review of a rate case. And it's my belief that this company is not going to stop asking for these mechanisms, for these incredible requests for increases until the commission tells them no. And here's 5 reasons why you should say no to the RSM request. First, the company has shown that it has not been unable or had an opportunity to earn its authorized ROE under traditional rate-making mechanisms. Second, the RSM will unjustifiably expose customers to bill increases without consideration of changes in cost of service. Third, it fails to account for potential growth in revenue and could eliminate the need for changes to customer bills. That could eliminate the need for changes to customer bills. Fourth, changing rates and customer bills should only be done through a thorough analysis and review of the company's revenue collections and changes in cost of service to ensure that their rates and related bills to customers are just and reasonable. And fifth, to the extent the company seeks revenue stability, there are less dramatic approaches that could be taken that would fit within the traditional rate-making process. For these 5 reasons, I urge you to reject the RSM proposed in this case. I would note that MECG is sponsoring the testimony of Jessica York on this issue. Just for clarity, I'm sure it'll come up. She's also sponsoring testimony for another party in this case. I believe on the RSM issue, they're in total alignment. So I'm happy to answer any questions to the extent I can, but as you can expect, I'm more happy to defer those questions to the expert, Ms. York. So.
Chair Hahn?
Yeah, sorry, Mr. Opitz. I was trying to write the 5 reasons.
Sure.
Can you help me with number 1 and half of number 2?
Sure. So these are all within the testimony of Ms. York and within the position statements I filed for MECG. But the first one is the company has not shown that it has been unable to earn or had the opportunity to earn its authorized ROE under traditional rate-making mechanisms. And are you ready for number 2?
Yep.
Okay. Number 2 is the RSM will unjustifiably expose customers to bill increases without consideration of changes in cost of service.
Thank you.
Are there any other questions from the commissioners? All right, thank you.
Thank you.
Ms. Plescia, I apologize. You're kind of out of my line of sight. But would you like to make an opening statement on behalf of your clients? And if you would, since you're here in person, I believe you were online yesterday?
Correct.
Okay. So if you would, in case I forgot to have you enter your appearance yesterday, could you do that?
Certainly. Diana Plescia, representing the Missouri Industrial Energy Consumers. I'm with the law firm Curtis, Hines, Garrett, and O'Keefe, and I'm appearing today on behalf of the MIEC on class cost of service and rate design.
All right.
I just wanted to briefly add to what Mr. Opitz said. I thought his arguments were very comprehensive. I just wanted to focus on one thing. The legislature has enacted a panoply of various mechanisms that the utilities can use if they need to. And the RSM is one of those things. However, I disagree with the company's counsel in his implication, I believe, that this has been passed by the legislature. It's something the legislature wants the commission to do. I think it's a tool in the toolbox for a utility that is unable to make its authorized return or is struggling in some way. I think the commission can view it that way, and I think that especially in the case of Missouri American, where they're earning their authorized return, there really is no need for this mechanism at this time. And the commission ultimately has the discretion over this to look at all relevant factors and looking at the total circumstances in the case. I think certainly this is not a case where the commission would need to use its discretion to apply that statute. And that's all I have.
All right, any questions from the commissioners? All right, thank you. Mr. Kleiser, would you like to make an opening for the public counsel?
We good, Brian? All right, good morning once again. As before, John Kleiser on behalf of the Office of Public Counsel, going to give the opening arguments regarding the rate stabilization or revenue stabilization mechanism. So the very first thing I want to touch on, and I'm glad to hear that the counsel for the company acknowledge this, the RSM is not a guarantee. The statute itself clearly indicates that the commission is free to approve, reject, or even modify what's been put forward by the company. Well, obviously, I underlined reject because the OPC's position is to reject, but I would also highlight modify. If there's something more to this that you think you need to do, that's a component of this as well. I also want to just point out to you guys that, again, no other Missouri water utility has gotten this. This has not been authorized by anybody else. And the reason I'm focusing on that is just to remind you all, this is a first. This is the first time that you guys are going to be able, if you were to approve it, this is the first time it will be approved for anybody. So it becomes really important to think about how the RSM would theoretically function, what your goal is with it, because it's going to set the stage for any future kind of RSM. Granted that currently there's very few companies who could take under it, but still the point remains. This is the first, so let's think about how the RSM is supposed to work. And to start with that, let's ask ourselves a simple question. When should you approve an RSM? Now, you heard a lot of testimony regarding, are they meeting their authorized ROEs? I think that's an important consideration here. But to me, when I look at the RSM, I think on a much simpler term, I say that the issue really is in the name itself. The question before you is simply, are the company's revenues stable or not? Right? If we're going to have a revenue stabilization mechanism, that really only makes sense if we think that their revenues are unstable. And here, I'm not going to read all this out to you. This is the sort of paraphrased version of the language, and you can see that the whole schema of this statute is all about addressing revenue variations. So we start to look at ourselves and we say, so how have Missouri American Water's revenues, changed? Are they stable? And this graph, which is taken from the testimony of staff witness Mr. Abbott, shows you Missouri American Water has had a very consistent revenue growth over the past decade. And it's been driven by a pretty clockwork series of rate cases and WSERA filings. So in my opinion, I would argue that it's not an issue where we have revenue instability. And specifically, I'm going to address, because Commissioner Mitchell asked, Ms. Lena Mansell directly addresses the issue of revenue variation beginning on page 13 of her direct rebuttal testimony. And on page 14 even, there's a very nice table that lays out from 2017 to 2021 what was the authorized rate case revenue, the billed revenue, and the variances. And you'll see that the percent difference on that table, I apologize I didn't put it in my slide, is about 0.56 over that 5-year period. It's also worth noting over that 5-year period that the company actually overbilled about $8 million in total. So if this RSM was in place, you would have actually had a return of money. That being said, again, a 0.56 difference over 5 years does not indicate a significant variation in revenues that would kind of merit needing to have an RSM. I also want to point out just very briefly that it cuts off at 2021. The only reason for that is because the company hasn't been able to provide us the additional data on it. We asked, they weren't able to. You can ask Ms. Lena for follow-up questions on that. The other thing to consider really, not just in terms of the revenues, but at a broader level, how the company has been functioning. And this kind of gets a little bit into that ROE part that you heard other people talking about. In addition to having very stable revenues, this company has had exceptionally stable dividend growth. I mean, this company has had a consistent and high overall growth of its dividends, and it has been successful year after year in meeting or exceeding its 7.9% compound annual growth rate for earnings per share. So again, this just comes back to the idea, this company is not hurting. This company is not suffering at a moment and needs a revenue stabilization mechanism in order to make itself whole. It's doing just fine. The other component to sort of add to this, and you're going to see this graph come up in a great more detail later, is the actual customer usage that we're seeing. And this, again, ties into that idea. Are we seeing fluctuations in the revenue? And we're not, because we're not seeing fluctuations in the usage. Over the past 5 years, the company's usage has been fairly consistent and steady. Again, I'm going to cover this way more detail with regard to a later issue, so I'm going to kind of leave it alone here, but the general gist of it's pretty obvious. Okay, so let's hypothetically accept for a moment that the company isn't having revenue instability. If that's the case, what does the RSM give us? Well, basically all that it becomes at this point is a guarantee of profit that's being backed by the ratepayers, much like if you had a guarantor for your loan. And what do ratepayers get out of this? Well, first of all, they get risk exposure. You know, if a large customer leaves the system, all the other customers are going to have to pick up the revenue that large customer was providing. And this is important because Missouri American Water has a couple of very large water supply customers who could potentially shift suppliers. You also get an additional surcharge on bills, which, again, you know, there's already quite a few surcharges. You heard the counsel for both MIEC and MECG mention that. And finally, you get a punishment for trying to reduce their own costs. This gets to that conservation component, and I want to run through that visually because I think it's really important for people to kind of visually consider how that works. So you're going to see the next couple of slides here, they're just graphs, but let's just assume we have 5 customers, right? And one of those 5 customers decides that they're going to reduce their usage. They're going to try and lower their bill by reducing their usage. Well, what this RSM would do is it would take the amount of money that that customer was going to have to pay and would effectively redistribute it amongst all the other customers, including the one who had the conservation. So right now, under this scenario, it is true that customer 3, the one who reduced their usage, is paying less than they would have, but they still have to increase what they would have paid because of the RSM. At the same time, the other 4 customers are now having to subsidize the reduction in usage that happened for customer 3. And if more customers start to reduce usage, the problem becomes exponential because the amount of reduction has to be spread out. So what happens if everybody reduces their usage? Well, then everybody is basically paying the same amount because the RSM guarantees that that reduction gets covered. What this effectively means is the more people who try to save, the more people who reduce, the more people who try to conserve, the less effective that conservation is on their own bills. It becomes counterproductive. The last thing I'm going to touch on very briefly is something that was brought up by the counsel for the company, and it concerns the inclusion of production cost tracker elements. Okay, the simple version here is that you can't do this under the statute. The statute only allows for variations in usage. Production costs, or expenses in general, aren't usage. This is not something that you can put into the statute based on its language. I don't really have much more to say to it beyond that, and I'll address this more deeply in the brief. But as far as the issue today goes, the Commission should really only focus on whether the RSM should be granted. The question of whether production costs should be included is, in my opinion, just a complete non-starter given the language of the statute. All right, so really quick conclusion. Like I said, MECG cannot show a need for an RSM because it doesn't have the revenue instability that would justify it. Putting that burden on customers is just going to be another step towards risk-free utility regulation. And I really want to remind this commission that in large part, what this commission is intended to do is to be a proxy for the competitive markets. You all are the solution to the fact that these guys are regulated monopolies and therefore don't have natural competition. And think to yourself, what other business out there gets to operate with a guarantee of its revenue? Does Google operate with a guarantee of its revenue? Does Ford, does Walmart, does Coca-Cola? None of these other companies operate with that kind of guarantee. So why on earth should Missouri American Water be different? This is a step in the wrong direction. It's taking you away from a competitive market. It is taking you closer to a monopoly. It is bad for customers on that face alone. All right, that is my conclusion. I'm happy to take any questions.
Do the commissioners have any questions? Hearing none. Thank you, Mr. Kleiser. All right, the company may call the first witness.
Commissioner calls Charles Ray.
Mr. Ray, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Good morning, Mr. Ray.
Good morning.
Can you please state your name and spell your last name for the court reporter?
My name is Charles Ray. My last name is R-E-A.
Mr. Ray, by whom are you employed and in what capacity?
I'm employed by the American Water Works Service Company. My current title is Vice President, Enterprise-Wide Regulatory Pricing and Affordability.
Mr. Ray, for purposes of this proceeding, have you caused to be prepared in written question and answer format your direct testimony?
Yes, I have.
And is that what has been marked for identification purposes as exhibit number 22?
Yes.
Have you also caused to be prepared in written question and answer format your rebuttal, surrebuttal testimony?
Yes.
And is that document marked and identified as exhibit 23?
Yes.
Do you have any corrections to either exhibits 22 or 23?
I do not, other than any place where it states that I'm a senior director and now I am a vice president.
Okay, thank you. Mr. Ray, other than that change that you just noted, if I were to ask you the questions that are set forth in exhibits 22 and 23, would your answers be the same?
Yes.
And are the answers to those questions true and correct to the best of your knowledge, information, and belief?
Yes.
Petitioner offers petitioner's exhibits 22 and 23.
Is there any objection to the admission of those documents? Hearing none, exhibits 22 and 23 are admitted into evidence.
Witness is available for cross-examination, Your Honor.
All right. For the staff?
Good morning, Mr. Ray.
Good morning.
Have Missouri Americans' revenues been increasing over the past 10 years?
Yes.
And do you have any reason to believe that this trend is likely to change?
It depends on whether the underlying factors that cause those revenues to increase change. It's not, I think it's a mistake to think that revenues are increasing for no particular reason. It depends on whether the underlying factors that cause those revenues to change will continue to be what they were.
But at this time, do you have any specific reason to believe that this trend will change?
Not in particular, no.
Okay, thank you. No further questions.
All right. Thank you. Mr. Kleiser?
I have no questions. Thank you.
All right. Mr. Kaufman?
Good morning, Mr. Ray. I have no questions. Thank you.
All right. Any questions for the council for Riverside or City of St. Joseph? Okay. Liberty? All right. MECG? Yes, Mr. Opitz.
Good morning, Mr. Ray.
Morning.
Are you based out of Missouri?
No, I live in Moline, Illinois.
Okay, thank you.
All right. Any questions on behalf of MIEC? All right. All right. Any questions from the commissioners? Yes, Chair Hahn?
Morning.
Good morning.
Can you tell me how many of Missouri American's operating company, or American Water Works operating companies like similar to Missouri American have an RSM in place?
There are 12 operating companies, water operating companies, in the American water footprint in 12 different states. I can tell you that in Illinois American Water Company has an RSM mechanism similar to what we have proposed here in Missouri. In California American Water Company has recently had a revenue stabilization mechanism. They currently do not, although that is an issue of some dispute. So I would not consider California to be settled one way or the other. Other than California, as I said, Illinois American Water Company has a mechanism similar to what Missouri American Water is proposing. None of the other operating companies have that sort of mechanism.
Okay, so in Illinois American Water Company's RSM, did that company have varying revenues for water service or varying usage?
Yes, and I would say that revenue volatility in the Illinois service territory is less than what it is for Missouri. Illinois American's service territory, Illinois American is probably maybe 2/3 the size of Missouri American in terms of number of customers it serves. It stretches all the way from the Chicago suburbs down to Cairo, Illinois, which is far, far southern Illinois. So the service territory is similar, not quite as big. Revenue volatility is considerably less than what Missouri American Water Company has.
Okay, and thank you so much. And in Missouri, we have it authorized by statute, but it has not been used in practice. So of the 12 operating companies in Illinois and California, it is statutory in both places, or how has it been established?
I don't know the answer to that question. I can tell you that there is a statute in Indiana that allows for revenue decoupling, and we do not have a revenue stabilization mechanism in Indiana. I don't know if Illinois or California has enabling legislation that specifically, talks about this the way it does in Missouri.
Okay. Thank you. Appreciate it.
Any, any other commissioner questions? All right, here.
If I may, Honor, it's
Yes,
Commissioner.
Mitchell.
You mentioned Missouri's revenues were more volatile than Illinois'. Could you expand on that, and what is the historical volatility of revenue and volumetric sales in Missouri that you're referring to?
So that's a good question. So the way I think about revenue volatility, it comes from two different sources. One is how much of your water sales are seasonal sales, that is primarily for irrigation in the summertime, although it doesn't have to be irrigation. But it is seasonal in the sense that it is affected by weather. That's one component. The second component is the relative level of fixed charges and volumetric charges that you have in rate design. The more heavily weighted your rates are towards volumetric components, the more revenue volatility you're going to have, because the seasonal usage that can go up or down due to weather has more value to it. I can tell you that we have 3 states, Missouri, New Jersey American, and California American, that have relatively high levels of seasonal usage, more so than any other state that we operate in. And I can tell you that the rate design that we have in Missouri is much more weighted toward the volumetric component of rates than either New Jersey or California. So in that sense, I would say that we have more revenue volatility due to seasonal usage in Missouri than we have in any other operating company that American Water has. I hope
And
that,
that volatility is,
I'm sorry, I didn't catch that.
that seasonal volatility generally linked to weather patterns. Is that fair to say?
Yes, and it's related to how hot the summer is or not, and how dry the summer is or not. So it has to do with hot weather or the lack thereof, and it has to do with precipitation in the summertime or the lack thereof.
And over the long term, are those variations fairly predictable?
You can certainly predict them. You can certainly do a statistical analysis that shows how sensitive your sales are to both heat in the summertime and precipitation, and I believe that our witness, Mr. McClellan, has done that sort of analysis, and that is one of the foundational pieces of his statistical usage analysis. You can certainly quantify that, both in terms of gallons and in terms of revenue.
I want to shift for a second to customer perspective. And in my mind, a customer's ability to control their cost for the water commodity is pretty limited. The only lever I can think of is to control or manage usage. And with an RSM in place, do you think that diminishes the customer's ability to control their cost by controlling their usage?
No, I don't think it does. And I would say that changes in usage over time are going to be reflected in changes in rates, whether you have an RSM or not. It's not a question of does an RSM increase rates because you. Well, I think it's fair to say a couple of things. One, there is sensitivity to summer weather for residential customers, both in St. Louis County and outside of St. Louis County. And I think that Mr. McClellan's statistical analysis shows that to be true. It is true that residential customers and commercial customers and public authority customers will all have different sort of overall levels of volatility. I don't think that there are significant enough differences between St. Louis County and non-St. Louis County to prevent consolidation of rates on that basis. And I will give you, if I may, I will give you an example of a state where that has been an issue. In California, California American Water has 3 different pricing zones: a northern district, a central district, and a southern district. Northern district is Sacramento. Central district is Monterey, which is just a little bit south of San Francisco, and then the southern is Southern California. three very different climate patterns, that result in very different usage characteristics for residential customers in those three areas. And that is a legitimate reason to not have consolidated rates, because the usage patterns are very, very different in California. In Missouri, that is not the case. Usage patterns between St. Louis County, St. Charles County, Jefferson City, Joplin, St. Joseph, don't come anywhere close to, in my opinion, close to a rationale for not consolidating those rates.
Okay. In your direct testimony on page 39, and I don't know that you need to go to that testimony, but I'll just tell you what was in the testimony. There was a question posed to you: which customer classes would be excluded from the RSM? And your answer was industrial water customers and water customers taking service under contract rates.
Yes.
But the determination of the RSM adjustment, as stated in the tariff, excludes actual production costs. So industrial and contract rate water customers would not be charged for any increased production costs. Is that correct?
Right, that's
Okay.
correct.
When it comes to the number of gallons of water sold, do you know what percentage of the gallons of water sold are to industrial customers?
I don't. Mr. McClellan might. If he doesn't, that is something we could certainly get.
Okay. Could you do that for both 2024 and 2023?
Yes.
Okay.
And I hope somebody's taking notes. Yes, we certainly could do that.
Okay. If the proposed RSM was applied to the company's revenue and production cost since the last rate case, what would have been the average impact on the different customer groups that the RSM would have applied to?
I don't know the answer to that.
How does the RSM tariff as proposed in the calculation of production cost adjustment consider lost or unaccounted for water?
I don't think it specifically addresses that issue. There is certainly production cost associated with non-revenue water. I don't know that the tariff specifically addresses that issue.
Okay. And I'm going to refer back again to public counsel witness Lena Mantle's testimony. In her testimony, she discusses the inconsistencies between how the RSM is described in your testimony to function versus how it is written up in the draft tariff. Is the proposal for the RSM to have monthly or annual true-ups?
It would be an annual true-up. It's based on monthly information, okay, but we would not have monthly filings that true up the amounts. It would be an annual true-up,
Okay,
a true-up that's done once a year.
gotcha. All right, Ms. Mantle, in her testimony, also raises the concern about the consolidation of different customer classes into one mechanism, and the risk to residential customers, especially if usage for commercial customer and or sale for resale customer usage drops, which would be similar to what happened during the pandemic. How would this impact the residential customers under the proposed RSM?
Well, it certainly is the case that changes in one class usage under the RSM would impact the RSM that other customers pay. There's no doubt about that. I would note that all of these customers, residential, commercial, and public authority customers, all pay the same rate. So from a revenue perspective, I think the difference is less than what it would be if there were different rates that different customers paid. I don't know that you can say beyond the hypothetical that any particular change is going to impact any particular group of customers one way or the other. Certainly it will, but to the extent that it would, I think is speculation.
Okay. I want to ask you about fixed costs. Why are fixed costs not included in the RSM?
Well, we're asking for revenues associated with fixed costs, or at least the recovery of fixed costs, but the RSM is not a cost tracker other than the exclusion of the production cost. So I don't know if that answers your question.
Well,
Or not.
I guess the reason I ask that is because fixed costs are not dependent upon usage,
That's correct.
but the company has the ability to control those fixed costs to a certain extent, correct?
To a limited extent, I would say.
Okay.
I don't think that it would be prudent for the utility to, reduce headcount necessarily just because it thinks that the weather is going to, in the summertime, is going to be unfavorable. So there is some limited ability to do that, but I think it's pretty limited.
But would you agree, though, if the premise of the RSM is to share the risk with your customers, shouldn't any savings or increases in the fixed cost also be shared with the customers?
I think that's generally done through a litigated rate case process. I think that the period of time that the RSM is going to be in place, at least in terms, of period of time between rate proceedings, is such that I don't think you would see huge swings in the company's fixed costs such that they would need to be reconciled.
Under the RSM, assuming there were labor positions that were included in the rate case to be filed at a later date but were not filed between rate cases, would those savings be passed along to the customers under the RSM?
Well, the RSM is going to reconcile the revenues that were approved by the commission in this case to revenues that are actually going to be collected going forward. What you're describing to me sounds more like formula rate making, where you're basically recalculating rates every year based on different levels of fixed costs, different levels of usage, different levels of investments, and so on and so on. I think that is a different animal altogether. And so I don't think that that's something that you would want an RSM to necessarily reconcile.
One last question. When it comes to non-revenue water, would the production costs include that in your, would the production costs included in the RSM include non-revenue water?
I think the answer is yes, but Mr. LeGrand might be able to chime in on that too.
Okay. And just to circle back for just a second, when I was asking about the labor positions, really what I meant was that vacant labor positions in between rate cases.
Okay?
Okay. Just to clarify that, does that change your answer?
No.
Okay. All right. Does staff have recross?
No questions.
Public counsel?
No questions, thank you.
CCM?
No questions, Your Honor.
MECG?
I have one question, Your Honor. Mr. Ray, in response to a question from Commissioner Mitchell, you mentioned that Missouri has a higher portion recovered from the volumetric component of bills than other states. Do you recall that?
Yes,
Would you agree that allocating more of the cost to the fixed components would be a way under traditional rate making to increase revenue stability?
yes.
That's all I have. Thank you.
All right. Any recross on behalf of MECG? All right, thank you. All right, Mr. Kyle, any redirect?
Yeah, just one area of redirect, Your Honor. Mr. Ray, do you recall, we're going to go way back to the beginning of cross-examination, Commission Staff Counsel was asking you about whether Missouri American's revenues have been increasing over the past 10 years, and I think you answered yes, they were. I think she then followed up with, do you foresee that changing in the foreseeable future? Do you recall that?
I
line?
recall that, yes.
You answered that latter question by saying, well, it depends upon the factors. What factors have caused Missouri American's revenues to increase over the course of the last 10 years?
Increased levels of investment, increased levels of operating cost. And if you're also talking about what factors have caused rates to change, I would also include changes in usage associated with that.
Do those increased levels of investment and operating costs, are those also causing increases to fixed costs?
Yes?
No further questions, Your Honor.
All right. All right, thank you, Mr. Ray. You may step down.
Thank you.
Mr. Kyle, are there additional witnesses on this issue?
Not on this issue, Your Honor.
All right, then staff may call their first witness.
Staff calls Michael Abbott.
Mr. Abbott, you're raising your right hand. I appreciate that. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You can go ahead.
Mr. Abbott, could you please state and spell your name for the court reporter?
My name is Michael Abbott, Michael Abbott.
And did you prepare direct/rebuttal testimony in this case marked as Exhibit 200?
Yes.
Oh, I'm going to go back a question. I skipped one. How are you employed and in what capacity?
I'm employed with the Missouri Public Service Commission as a project or senior project manager in the water, sewer, gas, and steam department.
All right. And back to that direct rebuttal testimony, do you have any changes or corrections to that testimony?
I do not.
If I were to ask you the same questions in that testimony today, would your answers be the same or similar?
Yes.
And is the information contained in that testimony true and correct to the best of your knowledge and belief?
Yes.
I would offer Exhibit 200 and tender the witness for cross.
All right. Any objection? Exhibit
No.
200. Oh,
I was saying no objection.
okay, sorry. Exhibit 200 is admitted. All right, Mr. Collier,
No questions, Your Honor.
Mr. Kleiser for Public Counsel.
Yes, Your Honor. Good morning, Mr. Abbott.
Good morning.
I saw you sitting over there during the, while Mr. Ray was on the stand. Is that correct?
Correct.
So you heard Mr. Ray ask a series of questions from Commissioner Mitchell regarding volatility. Do you remember those?
Yes.
Now, is it correct to say that, to your knowledge, Mr. Ray hasn't presented information in his testimony that shows what the difference on the revenues included from a rate case against revenues actually billed have been for the past several years?
Can you say that one more time? Ask the question one more time.
That's perfectly good, because I butchered that question. To your knowledge, has the company put forward information that shows what the volatility between what has been authorized in rates and what has been billed in rates was over the past several years?
I don't believe so.
Now, in your testimony, did you put forward an examination of the difference between the authorized revenues and the revenues actually billed over the past several years?
I did not.
Are you familiar with the testimony of Ms. Lena Mansell?
Yes, a little bit, yes.
Do you have a copy of it in front of you?
I do.
Can you turn to page 13 of her direct rebuttal testimony for me.
What page was that again? I'm sorry.
Page 13.
It looks like I made a copying error because I only go to page 9.
Can you provide him with yours? Just leave it in there.
I'm on page 13.
Would you agree with me, and I'm going to paraphrase, I don't have to read everything into the record, that Ms. Mantle is laying out her examination of the volatility of the difference between what is authorized in revenues and what is actually billed based on information provided by Missouri American Water in the section beginning page 13 and continuing on to page 14?
Your Honor, at this time, I'm going to interpose an objection. The witness started off this line of inquiry with limited familiarity with Ms. Mantle's testimony. He doesn't even have in his own copy the pages that are being referenced, and Ms. Mantle's testimony speaks for itself.
May I respond? Sorry. I can actually jump forward to the question. I was really just laying foundation. My question is going to be to ask him his professional opinion on the conclusions drawn on page 14 of the table based on his experience. I was admittedly laying a lot of foundation, but I figured that was an attempt to avoid jumping the gun.
And Your Honor, if that's the end point of his questioning, my objection would be exactly the same. This witness has already said he has limited knowledge of Ms. Mantle's testimony. Ms. Mantle's testimony speaks for itself.
Again, I'm asking his opinion on the information provided. He doesn't have to have familiarity with it. He just needs to know what his opinion is. And I'll just ask the question to make sure it's very clear. On the last column of the table on page 14, it gives the percent difference. My question is, and we'll wait for the objection, do you believe that that volatility, or what the difference shown there, demonstrates a level of volatility that would necessitate a rate stabilization mechanism or revenue stabilization mechanism? That is the question I was going to pose, I was leading up to.
Restate my objection.
All right. I'll overrule the objection. You can answer that question.
There was a lot being said. I can't quite remember the question.
I'm going to try and say it again correctly. Somebody tell me if I get this wrong. On the table on page 14, which shows the revenue differences, the last column on the far right is the percent difference. Do you believe, in your professional opinion, that the percent difference in that column shows a level of variation that would necessitate a revenue stabilization mechanism?
I do not.
Thank you. I'm going to switch gears then entirely. If you would hand that back to Ms. Mansell. One of the issues in this case has been the ability of customers to control their spending. And I know that in your testimony, you had directly addressed this issue. Do you recall that?
Yes.
Would you agree with me that the more customers who conserve or reduce their usage, the greater the impact the RSM will have on customers in total?
Yes.
And in fact, if all customers were to conserve or reduce their usage, effectively the RSM would return those costs back to all customers?
Yes.
Okay. All right, one last line of questioning, and I apologize, they're going to be a little bit weird. It comes from the position statements, because there are a couple of items in here that didn't get fleshed out oh so well. For the purposes of an RSM, so I'm going to ask these questions and I want you to assume, if the commission were to grant an RSM, are you following me?
Yes.
So we're assuming the commission grants an RSM for the rest of these questions. You would agree with me that the commission should set the authorized revenues at the amount of revenue for each class calculated as the normalized billing units multiplied by the final rates?
I don't know that answer.
Fair enough. Would you agree with me that the commission should order the RSM rate to be different for each class and that the revenue target for each class be authorized revenue for that class?
I did not examine the difference in RSM for classes.
Fair enough. Would you agree with me that the commission should order charges credits be calculated at the difference between each class authorized and billed revenues and divide that difference by the expected usage of the class in the recovery period for establishing the surcharge?
I did not.
I have a feeling I know where the rest of these are going. Would you agree with me that the commission should order credits be calculated at the difference between each class's authorized and billed revenues? I think I literally just repeated myself. I have no further questions. Thank you.
Mr. Kaufman, do you have any questions on behalf of the Consumers Council?
No questions, thank you.
Mr. Opitz, any questions on behalf of MECG?
No, thank you, Your Honor.
Ms. Plusha, any on behalf of MIEC? All right, thank you. Do the commissioners have questions? All right. Mr. Abbott, I've got a question. If you'll refer to page 12 of your direct / rebuttal testimony. There are two tables there, and they basically lay out Missouri American's revenues from 2014 through 2023. Would you agree that the revenues include recovery of both fixed and variable costs?
Yes, that revenue includes both.
Okay. And then the only other question I wanted to ask you, I touched on with Mr. Ray, assuming there were vacant labor positions that were included in the rate case to be filed at a later date, but were not filed between rate cases, would those savings be passed along to the customers under the RSM?
I am unsure of that answer.
Okay,
Your Honor.
fair enough. Thank you. All right, Mr. Kyle, is there any recross?
No recross, Your Honor.
All right. Any recross from any of the other parties? Okay. Any redirect?
No questions.
All right, Mr. Abbott, I believe you're done. Thank you.
Thank you, Your Honor.
Let's take about a 10-minute break and go back on the record roughly 10:25. Going off the record. All right, we are back on the record. And next on the hearing schedule is witness Roger Colton for the Consumers Council of Missouri. And Mr. Colton is appearing today via WebEx. So, Mr. Colton, I'd like to swear you in, if that's all right.
Yes, sir.
All right. Mr. Colton, do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Okay. Hey, Rod,
Mr. Kaufman?
yes, yeah, Mr. Colton, can you turn on your video?
The video is on.
We don't see you. Okay. I'm just going to proceed if that's okay, Your Honor. So would you state your name and who you work for, Mr. Colton?
Yes, my name is Roger D. as in dog, Colton, Colton. I own the firm Fisher, Sheehan, Sheehan, and Colton.
And are you the same Roger Colton that caused to be filed direct testimony in this Missouri American Water rate case on December 20th, 2024? Mr. Colton?
Ma'am.
Oh, you am, okay. And in that testimony, you address issues including the UAT, Universal Affordability Tariff, but also the Revenue Stabilization Mechanism. And you're on the stand now to address the Revenue Stabilization Mechanism. If I ask you the questions in your testimony today, would your answers be the same as they were when they were filed on December 20th?
Yes, they would be.
Okay. This testimony has been labeled as Exhibit 450. It's 450. And so I would offer this exhibit into the record, Exhibit 450, and offer Mr. Colton for cross-examination.
All right. Are there any objections to the admission of Exhibit 450? Hearing none, 450 is admitted.
I offer Mr. Colton for cross-examination, if under what the order is. Here it is.
It's the city of Riverside and then the city of St. Joseph, Liberty, MECG.
No questions, Your Honor.
All right. MIEC.
No questions, thank you.
Public Water Supply Districts. Triumph, Triumph Foods, and then OPC.
No questions, thank you.
Staff
No questions.
and the company.
No questions, Your Honor.
Okay.
Are there any questions from the commissioners?
Okay. Mr. Colton, I suppose will be up later on the Universal Affordability Tariff, but that's the only other issue he has.
Okay. Then at this time, Mr. Colton, you're excused.
Thank you, Your Honor.
All right. And then the hearing schedule, I see Jessica York is next up for both MECG and MIEC. Am I phrasing that correctly? Witness for both?
That's right, Your Honor.
Okay.
I guess a administrative question. Do you have a preference on how we offer this witness between MECG and MIEC? She does have separate pieces of testimony for each of us, understanding that the testimony on this particular issue is the same.
If the testimony is the same on this issue, let's just, I'll give Ms. Plesha an opportunity to ask direct test, or ask questions on direct, and then we'll open it up to cross for all parties. So, oh, sure.
The testimony of Jessica York is not yet in the record, is that correct? not yet admitted. So is it okay then, Mayor, if I go ahead and ask her the questions to have her written direct testimony after in her cross rebuttal?
Yes, that's fine. Now, I don't know that you're on the microphone, though.
Diana, do you want to come to this table here?
That's fine.
All right, and in the meantime, Ms. York, would you raise your right hand, please? Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth? All right, thank you. You have a seat.
Good morning.
Good morning, Ms. York. Please state your name and business address, please.
My name is Jessica A. York. I work at Brubaker and Associates. The address is 16690 Swingley Ridge Road in Chesterfield, Missouri, 63017.
And are you the same Jessica York that caused to be filed in this case, direct rebuttal and cross rebuttal, surrebuttal testimony?
Yes.
And if I were to ask you the questions contained in that testimony, would your answers today be the same?
They would be the same. I do have one correction to make, though, if
Please,
I may.
please explain.
On the cross rebuttal, surrebuttal, my only correction is to correct the date, the filing date on the cover sheet. It refers to January 10th, 2024. Obviously, that should be 2025.
With that correction, then, would your answers otherwise be the same?
Yes.
And then I would like to, at this time, ask that the testimony of Ms. York as exhibits MECG 400 and 401 be entered into the record.
All right. 400 being which testimony?
That would be her, that would be the MECG's direct testimony, 400, and then the cross rebuttal, surrebuttal would be 401.
All right, thank you. Are there any objections to the admission of those documents? Hearing none, 400 and 401 are admitted.
Ms. York, good morning. You also sponsored testimony on behalf of MECG, is that correct?
That's correct.
And do you have any corrections to either of those pieces of testimony this morning?
Yes. The date on the cover sheet of this cross rebuttal, surrebuttal needs to be updated to reflect 2025 instead of 2024. That's my only correction.
If I were to ask you the questions posed in your testimony for MECG, would your answers be the same?
They would.
Your Honor, I guess at this time I would offer MECG Exhibit 501, which is the cross-rebuttal, surrebuttal testimony of Jessica York for MECG. And I would also offer MECG Exhibit 500, which is the direct rebuttal testimony of Jessica York on behalf of MECG, and that has a confidential and a public version.
All right. Are there any objections to those two exhibits coming into evidence? Hearing none, then Exhibit 500 and both public and confidential, and 501 are admitted into evidence.
And at this time, I tender the witness for cross-examination.
All right. Is there any cross on behalf of Consumers Counsel?
No questions to Ms. York, thank you.
Any of the other interveners? All right. Public Counsel?
No questions at this time. Thank you.
Staff of the Commission?
No questions.
And the company?
No questions, Your Honor.
Are there any questions from the commissioners? Are there any questions from the commissioners for Ms. Jessica York? All right, hearing none, I do have a question I'd like to ask. Just conceptually, given that the RSM is intended to be a rate stabilization mechanism, how do you respond to the fact that fixed costs have been excluded from that calculation?
My understanding of the RSM was that it was going to be, allowing the company to recover its authorized revenue requirement in this case, which would include both fixed and variable costs. And I guess my suggestion would be that there's other ways to deal with that issue besides the RSM, and if you increase recovery of fixed costs through fixed charges, for example, that might negate the need for this RSM that the company claims that it needs.
All right. So what would be the impact of excluding the fixed costs?
I guess I'm not sure I'm following the question. I mean, if the total revenues are being compared to what, like billed revenues being compared to what's authorized in this rate case, then that would, that includes the entire revenue requirement. Are you saying that you would not reconcile the fixed costs portion of the revenue requirement?
Well, I guess the reason I'm asking is because I know fixed costs, even though they're fixed costs, can fluctuate throughout a year or any given time period. So if that's not included in the RSM, I just was wondering your opinion on how that would impact the RSM.
I guess I'm not sure. At this point, I would have to take a look at that.
That's fine. All right. Is there any recross on the interveners or by the interveners? Okay. And then Mr. Kleiser for public counsel.
Yes, I'm going to make an attempt here to try and clean up a little bit of that confusion that I think was occurring between you and the judge. So the RSM is going to be reconciling the authorized revenue requirement with the actual billed revenue of the company, correct?
That's my understanding.
And the authorized revenue requirement includes all cost components for the company, correct?
Yes.
Now, I think that the confusion is arising because the company is also requesting to include components of the production cost tracker in the RSM. Do you recall that?
Yes.
So now and I know that we're going to touch on that issue a little bit later, but we have to talk about the interplay between these two things. So to make sure we're on the same page, the production cost tracker is attempting to track changes in certain, what we might call fixed costs, between rate cases. Is that accurate?
The production cost tracker, I believe, was going to be tracking variable costs like chemicals, fuel and power, purchased water, and that type of thing.
Okay, so if that's the case, then so like an example of a fixed cost, to make sure we're on the same page, that would be like administrative in general. Is that what we're talking about?
I mean, that would be largely fixed, I suppose, but, the RSM would also be including the return, I guess, on investment. Like, the investment is a fixed thing, and, the return, like, the RSM guarantees a profit, like you were saying earlier.
Okay, so the simple version here is fixed costs are included in the RSM because you're tracking the entire
Yes.
revenue amount. And again, I apologize for the sake of the court reporter. I'm going to ask that question again and wait for you to give the answer afterwards so there's no confusion. The fixed costs are included in the RSM because it includes the entire revenue amount.
Correct.
All right, thank you. I have no further questions.
Any recross by staff
No questions.
and by the company?
No questions, Your Honor.
All right. Any redirect?
No redirect from MECG.
All right. Again, I'll just ask you to find a microphone that would help.
Ms. York, based on the questions that you received from the judge and from Mr. Kleiser, could you explain in general the problems that you see with this mechanism?
In general, the RSM would be allowing the utility to look at one component, like look at its total revenue requirement without considering, or to collect its total revenue requirement that's approved in this case, without considering whether there are changes in other components of the cost of service that might still allow it to earn its authorized return. And so it's, I mean, I think I've explained in my testimony that it engages in single issue rate making. You know, and it will expose customers to bill increases without considerations of changes in other elements of its cost of service. And that's the main issue.
And following up on that, do you believe that the existence of the Commission's legal authority to enact such a mechanism or adopt one in this case means that it should do so, or that it needs to do so, or do you believe that the commissioners should take a different approach?
Your Honor, I'll object. That question exceeds the scope of any cross or bench questions of her.
I'm sorry, Your Honor.
Go ahead.
I believe that the question of how the mechanism works and the necessity for it being a single issue rate making mechanism, that even though it's in the statute, there are reasons why the commission might want to adopt it, some of which Ms. York has explained, but I think the questions pertain to that.
I'll sustain the objection. All right, anything further? All right, thank you. And I believe the next witness is Lena Mantle. Ms. Mantle, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Kleiser.
Good morning. Ms. Mansell, can you please state and spell your name for the record?
My name is Lena, Lena, M, Mantle, Mantle.
And by whom are you employed and in what capacity?
I'm employed by the Office of the Public Counsel as Senior Analyst.
And did you prepare or cause to be prepared testimony which has been pre-marked number 304, 305, 306, and 307, which is respectively the direct rebuttal, class cost of service direct rebuttal, cross rebuttal, and supplemental testimony of Lena Mansell?
Yes.
Do you have any corrections to make at this time?
No, I do not.
If I were to ask you the same questions posed in your testimony, would your answers today be the same or substantially similar?
Yes.
And is the answer is true and correct to the best of your knowledge and belief?
Yes.
All right, I would move for the admission of Exhibits 304, the direct rebuttal testimony of Lena M. Mansell, 305, the class cost of service direct rebuttal testimony of Lena M. Mansell, 306, the cross rebuttal testimony of Lena M. Mansell, and 307, the supplemental testimony of witness Lena M. Mansell.
Are there any objections to the admission of Exhibits 304, 305, 306, and 307? All right, hearing none, 304, 305, 306, and 307 are admitted.
I tender the witness for cross-examination.
All right. Mr. Kaufman, any cross?
Yes, a couple of clarifying questions. Good morning, Ms. Mantle.
Good morning.
I wanted to ask you some questions about what if the RSM is adopted by the commission. And I know, like OPC and staff, we've been pointing out the downsides to the RSM, but there are a variety of sub-issues in this issue about if it is adopted, how to do it. Is that right?
Yes.
And OPC has taken some positions in their position statements about how to do that. And I think and those are in like small Roman numeral 1, 2, 3, 4. On the second subpart, the idea, the question is, if an RSM mechanism is adopted, how would you treat the customer classes, basically? And would you explain what your recommendation would be as to how the customer classes would be treated differently or not?
Each class should have its own RSM rate. This would prevent residential bills from going up quite a bit if a large customer left the system. As proposed, they're all rolled together, so the loss of these big customers impacts every other customer on the rate, which would be residential, commercial, and OPA, other public authorities.
And what is your understanding of the company's RSM proposal? Is it clear that customer classes would be treated separately under their proposal?
It's clear that they would not.
Okay.
They would all be rolled together, and an OPA customer would be treated the same way as a retired widow living in a 1,200 square foot house.
And wouldn't that work to the disadvantage of the residential class primarily? Doing it as the company's proposed?
It would if a large customer left. It would actually be detrimental to the OPA customers if credits were given back to the customers in the manner that the company has proposed. In that case, that would be a detriment to.
And that's the third sub-issue, isn't it? The calculation of surcharge credits and surcharges?
Yes.
Or surcredits. And am I understanding your recommendation that essentially, as with the other sub-issue, it should go back based on a class-based calculation?
That's not my complete recommendation for that one.
Well, could you explain your complete recommendation?
The MOC, as proposed, wants to take, if revenues come in greater than the authorized revenues, the proposal is to take that amount and divide it by customer number and give every customer, whether it's the widow living in a 1,200 square foot house or the other public authority customer, the very same amount. Regardless of who overpaid the most, they would all get the same amount, and it would be done in a lump sum. I would propose, if this is approved, that the credits be calculated the same way that a charge would be, which would be the sum of the amount to be returned divided by the forecasted usage, so that customers could get credits based on their size and their usage, not treating each customer the same. Treating them the same as their usage, it's based on their usage and not the fact that they are a customer.
Okay. And is your recommendation, if an RSM were approved over your objection, is that accurately described on page 20 of OPC's position statements?
I don't have it in front of me.
Could I show it to you?
Yes.
Permission to approach?
Yes, granted.
I wasn't sure that was in your actual testimony, so I just want to make sure that that is your testimony as to how it would be done if it were to be done.
What is on page 20 would be our position, and no, it is not in our testimony, written testimony.
Just one more question about how you would understand that an RSM mechanism would work. It would not only fluctuate with weather changes, but pretty much any change in revenues, correct?
That is correct.
And so that means that rates for customers might change, as you mentioned, if a large customer left the system, correct?
Rates for all customers in those classes then
Within-
would change because an other public authority customer left.
And if you did it the way the company said it, then all customers would face an increase. If you did it the way you were recommending, the impact would stay within the customer class. Is that right?
That is correct.
But the RSM, as the company has proposed it, would also raise everyone's rates if, say, there was a downturn in the economy, right?
That,
If-
as long as
if-
usage or revenues went down, yes.
And that would be assuming, I'm assuming there that usage went down as a result of the economic downturn.
Then yes, all customers' rates would go up.
I mean, doesn't that seem like a real double whammy on consumers who would also be probably suffering other economic impacts at that time?
Yes, that's the risk that is being pushed onto customers if the commission would approve an RSM.
Okay, all right. That's all I have. Thank you.
All right. Is there any cross on behalf of MECG?
No, thank you, Your Honor.
And any on behalf of MIEC? No questions, Your Honor. All right. Any on behalf of any of the other interveners? All right. All right. Staff?
No questions, thank you.
And on behalf of Missouri American?
Your Honor, I do have one
Go ahead, Mr.
question.
Kyle.
Ms. Mantle, have you had an opportunity to review Mr. Ray's rebuttal, sir rebuttal testimony?
Yes.
And on this issue about different treatment of shortfalls and excesses, were you aware that he agreed that that was a valid point and that the company was willing to consider your proposal in that regard?
Yes, that is the way I read his testimony.
No further questions, Your Honor.
All right. Okay. Are there questions from the commissioners?
Yes, Judge. Ms. Mantle, we've spent a good amount of time on your direct rebuttal table on page 14 with on revenue variances, but that goes from 2017 to 2021. Going through a little bit further, let's just say 2022, was the data just not, or was the information not available, or would you anticipate that it would change at all if the data were more current?
In the last rate case, Missouri American Water Company's witness provided the data that's in my testimony attached to one of their testimonies. And that's what I used here. I, too, was concerned what happened since 2021. So I sent a data request asking for that information. That would have been data request, looking for the 8015. And the company was able to give me actual revenue by RSM customer class, but they said that authorized revenues by customer class are not available, as final rate revenues was not prepared by customer class in previous rate cases. So I read that to say this, they don't have that data.
Okay, thank you.
Any other commissioner questions?
Yes, if I may, Your Honor.
Go ahead, Commissioner Mitchell.
So your analysis of the company's history in being able to recognize their authorized revenues over the time period that you had data for, and I guess also their total return. Could you recap what you found or concluded in that analysis?
As
Our ability to recover and what the variance between the actual and the authorized?
As shown in Table 1 there, in 2018, there was 4.47%. They were below their, actually, the billed revenue was above the rate case revenue by 4.47%. And then in the other direction, was then in 2019, the next year, where billed revenues came in below rate case revenues by almost 2%. And I know that's a lot of money, but it's not a big percentage swing, especially when you look over the total of these five years. Over the 5 years, Missouri American Water Company has actually recovered almost $8 million more than their rate case revenues. So it can swing, but it's not what I would consider wild swings, much bigger than my salary. But as for a company the size of Missouri American Water Company, and then it does seem to be over a longer term. 5 years is longer than a year, but not real long term. It seems to be pretty well even.
Would you characterize those variations or as being unstable? Is there some evidence in the data that the revenues for the company are not stable at this point and haven't been stable over time?
I saw no evidence of that, although I do know further back in 2014, 2015, those times period, there was, when I looked at billing data, the actual monthly billing data, there seems to be some billing errors and some billing problems. And that's one of the reasons, too, to look just at the most recent few years to try to make this determination. I would have liked to have had 2022, 2023, and 2024 numbers, but this is what I had to work with. So no, I would not see wild swings. I will, COVID was 2020, 2021 of this data that I have, and you don't see even big swings in those years. So it was pretty well right on the money with the rate case revenues. So circumstances that a person might think would swing the revenues wildly did not, or at least for these customer classes. Did I answer your question?
You did, and I have one other question as well, and this is I'm just trying to make sure I understand what is I guess baked into the authorized revenue requirement. Does that include the company's returns as well as costs?
Yes, there's some confusion on revenue requirement can mean two different things. The auditing staff often uses it as the difference between what current rates recover and what their analysis shows the company should get. So more or less the change. But in this case, if you're calling revenue requirement the amount of revenue necessary to cover all costs and provide a return, then these numbers show that they not only covered that, but in most years earned more than that amount, collected more revenue than that amount.
And just, again, trying to make sure I understand what we're talking about is if we approved an RSM as contemplated here, would the commission be effectively guaranteeing recovery of both cost and guaranteeing the recovery of the return as well?
You'd be guaranteeing that as it was set in this rate case.
Okay. Thank you very much. That helps me understand.
Ms. Mantle, I have a few questions of my own. I don't recall seeing this in your pre-filed testimony, but do you, is it your opinion that fixed costs should be included in this RSM?
RSM as in the statute, so RSM without production cost only looks at revenues. And as the revenue requirement set in the rate case covers fixed cost, then yes, this would guarantee the customer or the company the recovery of the fixed cost as set in the rate case.
So it doesn't need to be in the RSM?
Fixed cost?
Right.
Again, it's revenue, and you're talking cost.
Okay.
If you took the fixed cost out, then you've got a different authorized revenue.
Okay. Should water losses be a factor in this RSM?
They are included in the cost to serve, the revenue requirement. So therefore, they are included because this is the revenue requirement that covers cost of losses. Whatever is included in determining revenue requirement would be recovered.
If there are savings due to vacant labor positions, should those be passed along to customers under the RSM?
They would be, and OPC is okay with it. That's positive regulatory lag for the company.
Okay. Those are my only questions. Any recross by Consumers Council?
Yes, I'm trying to understand the answer that you just gave about losses. As the company has proposed the RSM, if there was a drop in revenue, the RSM would increase the utilities rates so that they were made, just up to their expectation. And if in that scenario there were also vacant positions that the company wasn't paying expenses, would that be calculated? Would that be offset at all under the proposal the company has made?
No, that would not be
Okay.
offset at all.
Right. And so that is a problem with the mechanism, correct? That it actually would sort of it would change the revenues, but would actually give the company this total revenue requirement that they aren't currently up to in their actual operations, right?
Yes, as Ms. York opined, that it is a single issue rate making. In this case, the single issue is a really big one, revenue.
Okay. I just wanted to ask that because I wasn't clear I thought maybe you were talking past the judge on whether or not that was, with the current state or with the proposal. But thank you for clarifying it. That's all I have.
Any recross on behalf of MECG?
No, thank you, Your Honor.
MIEC? No questions, thank you. All right. Any other interveners? All right. Staff?
No questions, thank you.
All right. Mr. Kyle?
No questions, Your Honor.
Okay. Any redirect?
Hopefully briefly. I want to make absolutely sure that the conversation you have with the judge is very clear here. So, to the extent that fixed costs are already included in the revenue requirement, they would also be included in the RSM.
That is correct.
Okay. So fixed costs are not excluded from the RSM if they are included in the revenue requirement set by the commission in this case.
If there is no production tax credit or tracker included. But yes, absent that, you are correct.
And it is normally the case that the commission would include fixed costs in setting the revenue requirement for a utility as part of a general rate case.
The normalized amount, yes.
Okay. And then again, just to make sure that it was clear on the other point that Mr. Kaufman asked you about, when you were describing the positive regulatory lag, that would be occurring in situations without the RSM.
Even with the RSM covers, they would collect, the RSM rate would not change if there was empty positions.
Okay, the RSM rate would not change if there's empty positions. All right, I believe that's the last of my redirect questions, Judge. However, I have two things. Ms. Mansell mentioned a DR response that she kind of read into the record. I would prefer for that kind of thing to actually be in the record physically, but I don't have copies of it. What I would ask is to mark an OPC Exhibit 318, which would be the DR response you referred to, and offer it, but have you stay the pending on the ruling until I'm able to distribute copies to everybody so that they've had a chance to see it.
All right. And that DR number again?
8,015.
All right.
So
So you're offering it?
I will offer it. However, I acknowledge I do not have the requisite copies. I did not know it was going to come up, so I will myself ask you to stay the ruling on that until I've had a chance to distribute it to all parties.
All right. I will do that.
So the second one is very similar. Ms. Mansell was asked a question from Consumers Counsel regarding page 20 of the OPC's position statements and whether those were consistent with her recommendations. Again, page 20 is not part of the record, so solely for the sake of having a complete record with regard to what was referenced in the testimony, I would offer just that page as it pertains to the question. And again, I would mark it as Exhibit 319 and offer it, but ask you to stay ruling until I've had an opportunity to supply, and they can make objections after I've handed it out.
Agreed. I'll do that. All right. Ms. Mantle, you may step down. And then is our next issue CCOS and rate design? Is that still our schedule? Okay. Then the company may call the first witness on that issue.
Your Honor, you can have opening statements.
Oh, thank you. Yes, are there opening statements? First of all, on behalf of the company.
I'll be brief. May it please the commission, Nick Kyle again on behalf of the company. On the cost of service side, there are some issues of debate largely between the company and the larger industrial customers. And I would invite you, if you really want to get into the nuts and bolts of cost of service, Mr. McClellan can answer those questions. But in reality, the rate design in this case is not particularly drawn from those cost of service differences. The issue in this case in terms of rate design is whether we are going to have continued movement towards single tariff pricing. The company wishes to continue that movement by consolidating the volumetric rate for Group A into one rate, and by moving the rates for Rate J closer together. Staff wants to increase all rates in an across-the-board fashion, which actually moves us further away from single tariff pricing. Now, all of the arguments that we hear against the company's proposal are largely arguments against single tariff pricing as a concept. They're all arguments that you would make if you were opposed in general to single tariff pricing. But the reality of it is, this company has been progressing to single tariff pricing for some time now. Over the last 4 rate cases, the company has been moving to single tariff pricing. In large part, the company has already reached single tariff pricing. For instance, all of the non-St. Louis County customers are on the same rate. All of the arguments that we hear against against the company's proposal here could easily be made against the existing rate design. In addition, we have all of the customers in St. Louis County on the same rate, even though all of St. Louis County is not interconnected. So again, all of the arguments that we are hearing against the company's proposal could just as easily be made against the company's existing rate design. I would offer that the decision to move towards single tariff pricing has already been made. That egg cannot be unscrambled. The question is, how far do you continue to move in this case? We are at a point where rate A, the difference between the two rate groups, is 8% apart. And it's the company's proposal that today is the time to bridge that gap and bring those two rates together. The same is not true with rate J. They are further apart in the two rate groups, but they should move closer together. And that, in essence, is the decision before you. How much more do we move towards single tariff pricing? And we would urge that the proposals to move away from it are simply not well taken. I'm happy to answer questions.
Are there any questions from the commissioners? All right, thank you, Mr. Kyle. All right, staff may give their opening.
Good morning. May it please the Commission. You've likely noticed that staff took a different approach in this case by not developing a new class cost of service study. This is not indicative of how staff will approach upcoming rate cases and is the result of a specific set of circumstances present in this case. There were a variety of factors that staff considered when making this decision. Some of these factors are internal to this rate case. For instance, the company's renewed request for a future test year, for an RSM, for various trackers similar to PISA in the electric industry, discrete adjustments, a universal affordability tariff, and the overall level of the requested rate increase. Some of these factors are external to the rate case. For example, the state of the economy, inflationary pressures, and the impacts of rate increases in other utility sectors. Based on these factors, staff reviewed the results of previous studies and outcomes and determined that conducting a class cost of service study in this case was not necessary. Weighing all of these factors, staff determined that the most reasonable way to allocate any increase in revenue requirement would be to take the simple approach of giving an equal percentage increase to all tariffed rate classes and structures. In other words, staff does not believe that this case should be the case for any potential shifts between revenue classes. All customers should be treated equally. Consumers are feeling stressed by increasing costs and with the various add-ons they see on their utility bill. Any study or result today that would propose to give any particular rate class a perceived benefit by being allocated a lower than system average increase, while another class was receiving a higher than system average, does not seem to be in the public interest at this time. For these reasons, staff felt that applying an across-the-board percentage increase would result in the most just and reasonable rates in this case. Staff witness Melanie Mark will be testifying today about staff's approach to rate design in this case. Another issue that staff will address today is normalized residential customer usage. Staff's method of using a 5-year average is the appropriate method as it utilizes actual data to support a normalized level of usage going forward. Averaging data over 5 years produces reliable data and evidence of recent trends in usage. Many factors such as more efficient appliances, conservation, irrigation, can impact customer water usage, and using the most recent data provides the most reasonable determination of customers' usage habits. Staff witness Jared Robertson will be testifying today about staff's method of determining normalized residential customer usage. Thank you, and I'm happy to answer any questions or direct you to the appropriate staff witness.
Chair Hahn.
How many times in the past has the staff not conducted a class cost of service study?
I do not have a concrete answer on that. I believe I am aware of one, but I could get that answer for you.
Sounds good. Do you know if the one that you're thinking of, was it water or was it a different utility type?
I believe it was a different utility.
Okay. Do you know the rationale behind not doing one then?
I do not.
Okay, thank you.
Any other questions from the commissioners? All right, thank you, Ms. Aslan. All right, Mr. Kaufman, would you like to make an opening statement?
May it please the commission, the Consumers Council of Missouri and AARP have a witness, Caroline Palmer, on class cost service and rate design. And Ms. Palmer has some criticisms of the utilities class cost of service study, but at the end of the day, we are relatively comfortable with the staff's recommendation of equal percentages. And as to the residential fixed charge, we are, very concerned. We feel that the company, again, has gone way too far. It's been a little aggressive in what they would suggest for the residential fixed charge. We think there is some cost justification. We're recommending a $1 increase to $11, certainly not doubling it to $21. I think that would clearly disrupt a lot of the relationships we now have between low and high usage customers. I believe that the staff is recommending $1.43 or 34 cents. I may have got that wrong, but more than $1. We would also be comfortable with that as for an increase, but certainly not a 113% increase in that fixed charge. That's all I have. Thank you.
All right, are there any questions from the commissioners? All right. Hearing none, thank you, Mr. Kaufman. All right, any opening from counsel for MECG? Oh, I'm sorry, Mr. Bednar. For the city of Riverside, correct?
Yes, City of Riverside. Thank you, Your Honor.
May it please the commission. Yes, I'm Joe Bednar. I represent the city of Riverside, which is a city within the Parkville Water District. I probably represent kind of a hybrid of everybody in that I have a mixed position. But the city of Riverside, since I've represented them since 2006, 2008, has always been in support of single tariff pricing. And that is from a perspective of the residential property owner. The mayor of Riverside is very committed to protecting her residents of the city. It's a small city, 4,000 people now. It's growing. But the fact of the matter is, as you can look out and see all the attorneys representing all the varied interests, the true residential ratepayer sometimes falls through the crack when we get to just and reasonable pricing for their rates. And the reason for that, it can be seen and heard today. Our position is that in single tariff pricing, we not only believe there should be the same tariff across the state, we believe it should be for every class. That rate J should be the same across the state. Rate A should be the same across the state. Because we're dealing, again, with a commodity that's regulated and restricted. There really isn't competition for the company, which is a benefit to the company, and we all support that policy. But there's also no place else for the consumer to go, and that's the true residential consumer, whether it's a retired couple, retired single individual, a young person starting out from college with their first house, their first apartment, dealing with fixed costs and costs to which they have no control because you have to have water. You have to drink water. We hope people bathe. But those are the type of things that, again, a lack of choice. And it becomes almost, in the context of the way our forefathers have seen for the best interest of the state and for the residents, I believe, and the businesses, that we set up this Public Service Commission by its very name. Reinforces that idea that we're all here. You all are here to make sure that residents are guarded, businesses are guarded. So this is not, and Riverside has always supported business. We're not attempting to pit anybody against anybody, but starting out with, again, what is the price per gallon of water that a user pays? If the cost of that production of that unit, that gallon of water, is the same, why do people have to pay differently? And if there is a basis, then there may be, then should it not start with the individual or the family who doesn't get to recapture their costs? The residents are the single customer of MAWC that does not get to recover their costs and may be suffering from a fixed revenue of their own of which they don't have anybody to appeal to, whether they're fixed on Social Security or their wages at their job. Many other reasons why the residential user has the most limited avenues for relief than any other ratepayer out there. So I would submit, the City of Riverside would submit, that that should be taken into consideration when we're setting rate design, that the issue of volumetric charges, it's amazing when you look at, we have rate A, rate J, rate B is taken care of, I believe, Mr. Fisher, and then the others. And what's interesting about that is within rate A, you can kind of see the complexity of the problem in that we refer to users within rate J as both residential and non-residential without further definition. And then in other parts of folks' testimony, they refer to the commercial user. And I think that gets into, again, part of the issue here is there are ratepayers within rate A that do get to recapture their costs. Now, that will vary by the size of the business. It could be truly a small business of just a few employees or a larger one. It could be a golf course. I'm not sure. But those are the issues that I think bear further evaluation when we finally settle upon a rate design and then the rate increase that's assigned, so that that is equitable. Again, not pitting anybody against each other. We're the state of Missouri. We shouldn't pit the East versus the West. If there's an economic development issue, let's pursue that with the Department of Economic Development and see what incentives we can create for a new business to help them with their new utility bills. But to transfer that cost, that incentive, to the residential ratepayer, I don't know that that's the most just and reasonable approach to take. And so, you know, there are some that would even perceive this as really setting up almost a tax on folks because it is something that you have to do. Again, it's a rare commodity that we have no choices. So we would pursue a more equal, just like gasoline. What you get to, you know, everybody pays the same amount for gas no matter how much you make, no matter where you live in, well, I shouldn't say that. Jeff City's always 10 cents more per gallon than any place else. But for whatever reason, I don't know, we could bring that before y'all. But the point there is that I think that we can get closer to the same volumetric rate, and I'm happy to have more discussion about that. But bottom line is, I think we can do better for residential ratepayers. The mayor of Riverside, Kathleen Rose, firmly believes in that, and the city of Riverside has been fighting this now for almost 20 years. So thank you very much for your time, and I'm here to answer any questions that you might have.
All right. Are there any
No witnesses.
Are there any questions from the commissioners for Mr. Badnar? All right. Hearing none. Thank you. All right. Mr. Opitz, on behalf of MECG.
May it please the Commission, again, Tim Opitz on behalf of MECG. I don't know that I can disagree more with the prior opening statements. When we have a monopoly here where people have no choice, the most equitable way to set rates is based on the cost of service. If you are causing a cost to be incurred, you should be charged for that cost. And the fact is, different classes of customers incur different costs and cause different costs. There's a few sub-issues related to the cost of service and revenue allocation issue. I want to address the allocations first. This relates to the class cost of service study. Now, the staff didn't do one in this case. The parties who did it in this case are the company, and then MECG and MIEC had a witness, Ms. York, look at the company's study and propose adjustments. What the company did was the base extra capacity method for cost allocation. From a technical standpoint, this is an industry standard and widely accepted as reasonable. However, MECG's Ms. York, her testimony for MECG relates to the all other district, so the non-District 1 St. Louis, I'll call it District 2 or other Mo. And she recommends, I believe, 4 changes. First, public fire protection class should receive an allocation for the source of supply and water treatment cost. Now, the reason is because the company confirmed that potable water is used to serve public fire. And because the company is in fact incurring this cost to provide that service to that class, that cost should be allocated to that class, cost of service. Second adjustment she makes is to purchase power expense. And her testimony is that should be allocated on a base and extra capacity demand rather than on base usage. The technical way to do that is using factor 3. She can answer more about that. But this has to do with the way that the utility incurs its electric cost and its purchase power. Cost of service. The third adjustment she makes is related to the rate J distribution multiplier. For other Mo, the company, as I understand, has made a correction. It's a little different from what Jessica has corrected. And I think this gets down to another issue that's a sub-issue here is the commission should order the company to do a distribution main study so that we can see which distribution lines are serving the rate J class or the appropriate classes. We may not be able to get that in this case, but we can order the company to do that study, which they've done in the past, and it will get us closer to advocating for real cost of service to serve customers in the next case. The fourth adjustment Ms. York makes is related to system load factors. This is used to assign costs between the base and extra capacity functions. She has in her testimony that this should be allocated consistent with the customer class load characteristics indicated by customer class peaking factors that reflect the methodology in the AWWA Manual M1. My understanding is that that's recently been a methodology approved for other states that Missouri American offers service in. Those are the adjustments she makes to the class cost of service study. Each of those gets the company closer to cost of service or the potential to do it in the future for providing service to customers in the other Mo district. Now, the next sub-issue is what is the appropriate allocation of the revenue requirement increase that comes from this case. First of all, I believe that the revenue allocation should be consistent with the class cost of service study. So our starting point is to start with the company's cost of service study as adjusted by the recommendations of Ms. York. Moving from that, we do also take into account some impact of gradualism to say that we should have this allocation bringing us closer to what her cost of service study shows, but with the limitation that no class should receive a greater than 1.25 the district average. Those are the two main points that I wanted to highlight to you all. I'm happy to answer any questions. For the details on how those adjustments should be made or the impact on the cost of service, I would direct you to ask Ms. York about that. And again, for MECG, she's offering the testimony on the other Mo district, her adjustments there. So with that, happy to answer any questions.
Are there any questions from the commissioners? All right.
Thank you.
Hearing none, thank you. All right, would counsel for MECG like to make an opening statement?
First, I'd like to start by pointing out that the company in this case, not only on the issue of class cost and service, of service and rate design and consolidated tariff pricing, but on other issues has created a sense of inevitability that what's happening across the country with its overall policies, its parent corporation, and the trends that it would like to see should apply to Missouri. But Missouri has its own unique laws, its own unique concerns, and one size doesn't fit all, and there is no inevitability into the rate-making policy. There is no sweep that requires the commission to ever engage in a bad policy or just making a change if they think it's a good policy. I think the burden is on the company to explain why it thinks that single tariff pricing has been happening anyway, and the commission should just allow it to continue. We strongly disagree on behalf of the MECG. There are two cost of service studies in this case. The one presented by the MECG and MECG, which are actually a little different. We have different sets of clients, but the principles are the same, and the companies. And I hate to go into technical detail, it's a technical issue, but the MECG recommends that the commission, first of all, reject the company's proposed revenue spread because it is based on continued movement to consolidated tariff pricing. And I'd like to explain why we think that that's bad economic policy, it's bad for businesses and all other customers in the state. It is based on an incorrect and flawed cost of service model. The proposal violates all principles of cost causation, which is the cornerstone of just and reasonable rates. The difference between a tax and a rate is that a rate is supposed to represent the cost to the consumer as well as the cost of the company in providing service to that particular consumer. Consumers are different. A private business would treat companies with different costs to serve differently as well. This is not meant to be a one-size-fits-all. And the economic distortions that result from that are obvious when you look at the impacts on businesses or low income. There have to be countenancing of those differences. Consolidated tariff pricing also erodes the efficiency of the company's entire system. It reduces the company's incentive to perform due diligence before acquiring additional water systems. It also ignores the economics of scale that are required to service a large, far-flung, and non-interconnected system into an artificially condensed district. Many of the systems are not interconnected with all of the smaller utilities that Missouri American has acquired over decades. There is not a fairness when the utility was able with its own capital to purchase these systems and then to impose these costs on customers that have already paid for the systems over the course of many decades. It's convenient for the company, but not fair to ratepayers. And this pricing would undermine any relationship between rates and costs. Turning to the company's cost of service study, as mentioned before, the company uses the base extra capacity method, which is a broadly accepted method of cost allocation. So just by using this method, the company is recognizing cost of service. But the company's study is grossly inaccurate in key respects, and these inaccuracies make the company's cost of service study unreliable. And specifically, as pointed out in the testimony of MECG and MECG witness York, the company, number one, fails to allocate the source of supply or water treatment cost to the public fire service class. It inaccurately allocates purchase power expenses. It uses an unsupported, quote-unquote, rate J distribution multiplier, which is novel and has no basis in evidence. It uses system load factors to assign cost to demand factors that do not reflect the load factors actually shown by the customer class peaking factors. In her testimony, MECG witness York makes the following specific recommendations to correct these serious flaws in the company's study. She recommends that 86.39% of depreciation expense in plant investment be changed to size to 10 to 16 inches and be assigned to the distribution cost rather than transmission. This is consistent with the classification of mains in the company's annual reports. In her testimony, MECG witness York also makes the following other specific recommendations. She rejects the company's consolidated tariff pricing proposal and proposes that no class in this case should receive an increase greater than 1.25 times the district average. And even if the commission were not to adopt Ms. York's corrections, the commission should still ensure that no class receive an increase of more than 1.25 times the district average. That avoids rate shock. It allows gradualism. Based on her corrections to Missouri American study and her rejection of the company's consolidated pricing proposal, we believe that the commission should adopt Ms. York's cost of service study and reject the company's and allow her corrections to the company's flawed study. I would also note that the company proposes to shift approximately $8.7 million to St. Louis County water customers and away from customers outside of St. Louis. This would result in St. Louis County non-residential and rate B customers paying rates that are more than the company's cost to serve them. The company instead should base rates in each district on the respective class cost of service. Moving to the commission staff's position, the staff did not prepare a water class cost of service model in this case. Staff witness Merrick stated that staff made this decision because, quote, it appears that the company's submitted case and the staff's prepared class cost of service from the last rate case, there was not much difference in the cost allocation. I would note that the company's last cost of service study was performed in 2022. It would not be reasonable for the staff or the commission to rely on the staff's class cost of service models from the 2022 case for either cost allocation or rate design, because in that case, the staff's model for both districts contained major errors, and unsupported data that was used to develop flawed allocation factors. As a result, the 2022 study did not provide an accurate measure of the cost of service to the classes. Accordingly, it would be unreasonable to conclude that if the staff had somehow updated its water model, that it could be consistent with the company's. As Ms. York points out, there are errors such that it would be impossible to incorporate the principles or compare that with the staff's, with the company's cost of service study. For these reasons, we believe that the commission should adopt the approach taken in Ms. York's testimony, and it should evaluate the fairness of the allocation based on class cost of service with an understanding that gradualism is a part of that. And I'm happy to answer any questions.
Do the commissioners have any questions for Ms. Plesha? No questions? Oh, sorry.
Sorry,
There is a
Ms.
question.
Plesha. I want to understand some of your comments around the 2022 class cost of service study for this particular company the staff did. You said it had major errors. Just because I wasn't here then, can you describe those?
I would have to rely on my witness for the technical errors involved. I know that we spent many days, I was personally involved in the case, and we spent many days working directly with the staff to try to get some of those errors corrected. And I would actually, if possible, defer those questions, since they're technical, to our witness, Jessica York, if that's okay with you.
Sounds great.
Okay, thanks.
All right, Mr. Fisher, would you like to make an opening statement on behalf of the Public Water Supply Districts number 1 and 2 of Andrew County?
Yes, very much, Your Honor.
Hand out a PowerPoint that I'll get into in a minute. Thank you very much. For the record, my name's Jim Fisher, and I am representing the Public Water Supply Districts number 1 and 2 of Andrew County. I'm going to shorthand those just to water districts, if that's all right. I've been representing various water districts that take sales for resale service from this particular company for many years. And I just want to, we would like to discuss some of the rate design issues in this case, as well as give you a little bit of history about the issue. Missouri American, as counsel for the company indicated, has currently 2 districts. District 1 is the St. Louis area district, while District 2 is the rest of the state. My clients, the water districts, are in the rest of the state, and as their name suggests, they are in Andrew County, which is just outside of the St. Joseph area. Rate B is a single tariff rate that applies to all water districts in both the Missouri American districts. So it's that, for that particular one, we do have single tariff pricing. As not-for-profit wholesale customers, the water districts are really representatives of their own customers, since any increase in the cost of water must eventually be passed on to their customers. The water districts in this case are principally concerned with the class cost of service studies issues, as well as the rate design issues. We're not taking a position on the other issues in the case, principally revenue requirement issues. In this case, as staff counsel indicated, the staff commission did not, or the staff of the commission did not conduct a new class cost of service study, since the staff was comfortable with the results of the cost of service study that they completed in the last rate case, which was WR-2022-0303. And I'd like to address one question from the bench about what the problems were in that last cost of service study. There were some problems in the staff's cost of service study when they filed it in their direct case. They corrected those in the rebuttal case. The principal problem was they forgot to include in their cost of service study something called the mains adjustment. In their rebuttal testimony, they corrected that, and they produced a class cost of service study, which is the results which I have included, and I'm going to talk about here in a minute in my opening statement. The water districts believe it is appropriate to broadly utilize the results of that staff class cost of service study in this case to allocate any increase that comes out of this case. And Brian, let's go ahead, and you've got that up there. Let's go to the second slide, if you don't mind. Or can I do that? I can do that. Okay. All those numbers don't show up very well. I'm glad you have it in front of you.
Your Honor, this is unusual, but I'd like to interpose an objection here. This is Tim Opitz on MECG's behalf. I understand this is opening statements, but these slides here are, my first objection is hearsay. These are out-of-court statements offered, I suppose, for the truth of the matter, that they're reasonable. They don't appear anywhere in the testimony in this case. They're not supported by a witness who will take the stand, these figures. And then the second is relevance. There are two cost of service studies or analyses done in this case, neither of which show these factors or these allocations.
Judge, this is an opening statement, and this is just for a demonstrative exhibit at this point. I do, though, intend to ask the staff in cross-examination about the results of their class cost of service study, since that's what they said they relied on in making their recommendations in this case. So, and during cross-examination, I will present to the witness this summary table, which shows what they had relied on in the last rate case to make their current recommendation in this case. So it will be in evidence.
And correct me if I'm wrong, Mr. Fisher, but these schedules were actually admitted in the previous rate case.
Oh yes, definitely. That was Exhibit 127. It was in the staff's testimony and Carrie Ross' testimony.
All right. I'm going to overrule that objection. You can continue.
Okay, thank you. let's look at the results of that class cost of service study. For District 2, which is the first table that I have up there, and that's where my clients are located, the staff study shows that assuming an overall increase in that case of 17.8% in District 2, which is what the EMS run for the staff was showing at that time, that even though the rates were going up for that district by 17.8%, the cost of service study results showed that my clients, the rate B, should have had a rate reduction of 21.6%. So even though overall rates were going up 17.8, the rate reduction should have been, if you'd followed the class cost of service study, a 21.6% reduction. And if we go to the second slide, which is the District 1, the St. Louis area, that one shows that if there was a 19.3% increase for the district as a whole, which was based on the staff's EMS run at the time, the sales for resale class should have received a 17.7% rate reduction based upon the results of the class cost of service study. So under staff's assumptions, rate B in the aggregate for both districts should have received a $2.2 million rate reduction if the staff's cost of service study results were used to allocate the overall increase. Now, if you look at the last columns over there on both pages, the only negative percentage is the sales for resale class. So that shows that with the rate increases that were going on, the only class that should have received a rate reduction, according to the staff's class cost of service study, was my clients, the sales for resale class. In the 2022 rate case, there was a settlement which was approved by the commission, which took a modest step toward closing the gap between the rate B revenues and the class's cost of service study. While some progress was made in that last case, the water districts believe that the commission should take another step in this case to further close that gap. In that case, the revenues from rate B rates were decreased by approximately $755,000, which was about a 4.5% decrease in volumetric rates, and I think they also increased the meter charges by about 11%. Now, as background, I'd like to mention a little bit of regulatory history related to this company. In the Missouri American rate case in the year 2000, the commission adopted a major policy shift to adopt district-specific pricing rather than continuing with its previously announced decision to go to single tariff pricing. The single tariff pricing approach applies the same rates to a given class across the state, but very importantly, it has the effect of recovering new plant investment costs from customers throughout the company's service area. And if you have a question about that, please ask me. In the 2000 rate case, a new St. Joseph water treatment plant was being placed in rate base, resulting in a very large increase in the revenue requirement for that case. In its report and order, the commission majority rejected the water district's recommendation to use single tariff pricing, and instead, using district-specific pricing, put the entire cost of the St. Joseph treatment plant in rates into the St. Joseph area rates, resulting in a very substantial rate increase for customers in the St. Joseph area. By a 3-2 vote, the commission raised the sales for resale class rates, my clients' rates, in the St. Joseph area by approximately 267%. 267% is what resulted in our rates going up in that case. The dissenting opinions of Commissioners Murray and Drainer discussed the ensuing rate shock associated with these 267% rate increases. Commissioner Diane Drainer, I think, was rather prophetic 25 years ago when she noted that the sales for resale customers and other classes in the St. Joseph area, and I'll just quote what she said, will receive such a rate shock from this case
that their future rates can only be viewed as unjust and unreasonable. Now, this is the 9th rate case that we've had since that case. Some were litigated, some were settled, but the sales for resale class still is above its class cost of service, according to the staff's last cost of service study. So, in conclusion, the commission should broadly use the staff's class cost of service study from the last rate case to determine the appropriate allocation of the revenue requirement in this case and make a meaningful downward adjustment in the proportion of the overall revenue requirement being borne by rate B, which is the rate that applies to my class. I'd be happy to answer your questions. Thank you for your attention.
All right. Are there any commissioner questions? Hearing none. Thank you, Mr. Fisher. All right. Mr. Kleiser for Public Counsel.
Yep, I understand. Yep. Pull up rate design first, if you would, please. So before I get started, let me just say, somewhere in the haze of preparing for hearing, I got the impression that one of the issues today was coming up under a different heading. So I prepared 2 different openings, thinking that they were going to be 2 different mini openings. I realized my mistake. They're actually all under this one umbrella term. So I'm just going to run through both of them back to back real quick. Here's the good news. I know you were just throwing a lot of stuff on class cost of service rate design. I'm going to be fairly simple, at least on that one issue. And I'm going to get a little bit in depth on a very, very particular part after that. So let's just start with rate design and class cost of service. The OPC has 3 primary points that we're pushing for. First, we're asking to maintain 2 separate districts for water. Second, we're asking for a no revenue neutral shift across classes. And third, we're asking for no change to the residential customer charge. I'm going to walk through each one of those with a single slide. Maintaining the 2 water districts. Again, you've already heard a lot of stuff already from everybody about why they want to do this. Our position, water is local. It's not like electricity where it's built way over there and transported across. Usually it's all made and brought in at the same place. That means that your individual costs, right, the cost of the individuals living in that community are going to be directly tied to the projects in that community. We call that, cost causative principles. We want the people who cause the cost to be the one theoretically paying for them. So keeping water local maintains that cost causative principle. It also allows for a better understanding of the ratepayer of how their usage is affecting them. If you consolidate rates, right, you mute that price signal. So if you consolidate rates, a person in St. Louis is going to get charged for something being built in St. Joe, and they're not going to be up really any way to kind of mitigate that. So again, consolidating rates mutes price signals, and it also potentially allows for overinvestment because of it. And I'm not going to go into the details because I believe one of the prior speakers already discussed the St. Joe resource that was kind of put into place that caused such a big concern about that. If you have further questions on that, I do, though, recommend you talk to Dr. Mark about it. So the second one, no revenue neutral shifts. All right, our position here is really, really simple. This is going to be a big one, right? Like almost no matter what happens, you're going to talk about double-digit rate increases, possibly into the 20-30% range, hopefully not that high, but that's a distinct possibility. You are going to have rate shock. Like, that's just going to happen because of this rate increase at this stage. And while a lot of different, reasonable minds can differ under normal circumstances, as of right now, this is just not the case to start making revenue neutral shifts. You are going to cause a whole lot worse rate shock than you're otherwise going to get already. And that's my point there. And then finally, residential customer charge. 7 years ago, MECG lowered its monthly customer charge from $15 to $10. Since then, the company made a bunch of investments in AMI meters, and part of the promise of those investments in AMI meters was we're going to reduce the fixed costs that we normally include or bake into the customer charge. And let me actually back up and just clarify that point really quick. When we set rates, normally, the costs that we're trying to recover through the customer charge are the costs that are going to be borne or caused by every customer no matter how much they use. So for example, a meter reader has to come to the house whether you use 50 gallons or 5,000. So the cost of sending the meter reader is going to be part of the fixed charge because you have to, every customer is going to incur that cost. But if you get rid of the meter readers, right, because we have the AMI meters, theoretically we should be able to lower those fixed costs built into the customer charge. However, instead of that, we're instead seeing the company asking for nearly 113% increase in the customer charge. This is just unnecessary given the facts in front of us. And it also reduces the overall risk to the company and moves us further away from market-based competition, which I've kind of touched on earlier today. So, like I said, our three positions, very simple: maintain 2 separate water districts, no revenue neutral shift across classes, and no change to the residential customer charge. I know I ran through those pretty quick, but again, I think you guys have heard quite a lot, and I didn't want to take up too much of your time on it. I do, however, strongly encourage you to ask any questions on any of these topics or anything else you've also heard of our witness on this particular part of it, Dr. Jeff Mark. Man knows his way around class cost of service very well and can help to answer any of your questions. All right, I will pause there if there's questions on that component of it, because I'm going to move into a slightly more complex issue that takes a little bit more detail here in a second.
Your Honor, before he begins the second part of his opening statement, I shared the same confusion, I guess, that he did, which was we presented our opening on cost of service and rate design, and we were assuming the residential normalization was under revenues. I have an opening on that. And thought that that was where that topic was going to be covered until we heard the staff cover it in their opening.
I'm also, like, if we want to just do class of service, it may be a better idea, honestly, to just do class cost of service right now and then come back and do this, because this is a very specific issue. I don't know if that would work for other parties. I'm more than happy to do it that way. I don't know, for example, that's a no? I have no objection. Oh, you have no objection. Did anybody else have an issue with potentially just running through class cost of service and then taking up the normalization of residential usage afterwards? If that's the case, I'll just withdraw that opening and I'll come back afterwards, because that'll make things faster.
Yeah, that seems to be the consensus.
Okay. In that case, again, were there any questions on the class cost of service component?
The commissioners are indicating negative. I apologize, Mr. Holden, you are online and I skipped over you. Do you have an opening that you'd like to present on behalf of Triumph Foods? Or are you still online? All right, Mr. Holden, last opportunity, if you'd like to make an opening statement. Oh, Harden, I'm sorry. Yes, Mr. Harden. All right. All right, then I'll assume by his silence that he does not wish to present an opening statement. At this time, we will break for lunch. All right, if we could reconvene at 1:15, we'll go off the record. Oh, I'm sorry.
Hey, Your Honor, I apologize. I was trying to get to the right button on my computer. No, I do not have an opening statement.
And you're Mr. Harden?
Yes, this is
Josh. Mr. Holden. I don't know if you heard all
Apologies.
that. All right. With that, then we will go off the record.
That's called, you're talking about a grid.
Yes, yeah. So he's, so I thought maybe just call and see if I can.
I don't see him anymore. What was his name again?
Roger Colton.
If I have to call back in.
Cannot see you. Well, he's not up right away.
Yeah, I'll be in here for a few minutes. You can hold me and you can call in.
Okay, I'm trying to. Try his other number. Oh, hey, Roger. Hey, oh, hey, okay, so we now see you on the screen, the little box, so, are you, can you try to, show your video, turn on your camera?
My camera is turned on.
Okay, we can hear you. So there's.
You may have to look in his WebEx setting. You may have to look in his WebEx setting and turn it off, turn it on.
He says, you may need to go into your WebEx. Turn on your video.
Mr. Colton, I do see you. We are on a lunch intermission until 1:15.
Yes, we're trying to fix this video where
Okay,
I didn't show up.
I gotcha. I do see you on the WebEx.
Okay, I need to be on the screen.
We're still trying to get, Mr. Colton's video to turn on. So we can see his face.
So if you got him on the phone, tell him to go to, like, under video, and he may have it muted. Okay, I don't know.
Can you hear me, Roger?
Yes.
Okay, go into your, on the bottom row, where it says start video or stop video. If you just hover
Yes.
over, there's options. There's something that says video options.
It's probably turned off.
You know what I'm saying, like sort of a bubble, stop video.
Yeah,
And then you just hover over the little arrow that goes down,
okay,
and then it says video options. Click on
yes.
that, and you can, is there anything there, settings that you need to turn on?
Well, I have a couple of options. One is use the last connected camera, and then I have an HP Wide Vision 5 MP camera.
Try whatever, try them all.
Okay.
Whatever camera you
I just hit the, oops. I just hit the Wide Vision 5 MP camera.
We're not seeing you.
Okay.
This guy trying to, and he's trying to turn his camera on. Turn your camera on. You think you might have something flipped over it? I said, go to YouTube and turn on over there. Yeah, I know.
They're saying that there's some.
I haven't tried that. Yeah, I haven't tried that other one. Any other ideas? What you might have a camera over there? The guy that's turned to the camera. Yeah. She's not sending anybody else. I know. That's what I'm trying to tell him. I can hear you.
Okay, well, play around with that.
I said check those options.
I don't think we're fine. You're not going to be up on the witness stand.
Witness stand again anytime soon. There is going to do last cost of service and rate design, and then later the UAT. So there'll be several witnesses before you.
Okay.
Hey, Roger, you don't have anything.
He doesn't.
On your camera, do you?
He's not sending video.
No.
All right, well, just, maybe you can play around with it. We're going to.
Check.
We're going to look right now and then coming back and doing the rate design.
Check.
So you'll be, if you come back on the stand, it'll be late in the afternoon.
Okay. Okay, it's not clear. Okay. I'll see what I can do here. I don't know what's going on. Yep, okay, bye.
Yeah, I get that all the time. I get that too. Is that better work? Yeah. Can we go, negative 500? Yes. Is that right? You can't go. You can't go negative 500? I just put it at 500 and messed that in. Try negative 500. Huh? That's what I said to do. You gotta hit the, read that window, man, okay? Yeah, close. Okay, I didn't have that close. Let's try to take it 500. All right. Then I'm gonna go get me some food. I guess that's better? Yeah. Okay, that's negative. That's negative. Let's see, advanced audio, all right, you want me to try just 500? Negative 1,000. Negative 1,000? Yeah, I don't know what to tell them whenever they have this problems like that. I'm like, you know, everybody else is just working, man, I don't know. All right, I'm closed. I guess that's instantaneous. It's about the same. That's close. Closer. Try taking it 1,500, just for giggles. Then negative 1,000 is gonna be the number. They'll get it. Negative 1,500? It won't let me, it's only got 4 digits. 1,500? So when I put the negative in, it takes the 4th digit. Use the little arrow. It'll pass. Put it back on 1,000. Negative 9999. I thought you said we were negative. I don't know. I thought I had one. Here, I can knock him out. Go ahead. 99. All right, 8. Not, you won't even let me 999 it. All right, 8. Go ahead. All right, I want to take it one today, bud. Before I get the hell out of here. They won't let me get that microphone set up now? I did. I used your little track stuff. It looks ugly as hell, but it's over here. So we got one over here. What do you got to minimize? Huh? What do you got to minimize my track to? Minimize your what? You said little track stuff? Oh man, come on, dude. I've been put through the ringer today. Oh yeah. So anyway, that's it. I think Kleiser gets like a bonus if he got 3, dude. Got 3. might have to do them again. So, all right. Yeah, for all nasty looking stuff. But yeah. Shit, what time did we say? We're coming back. 1:15. All right. All right, I'm out.
Yeah, Mr. Colton, I saw you for a sec.
Oh, let me come back and see. Do you see me now?
Yep, that's working.
Okay, hopefully this is, hopefully whatever the problem is has gone away. Okay, I'm going to turn my video off and hopefully this will work when I'm back on the stand again.
Okay, right on. We'll see you at 1:15 Central.
Yeah, thank you. Lunchtime. Thank you, folks. No, it's lunchtime.
right, let's go back on the record. And we are on the record. Ms. Aslan, you mentioned off the record that there is an issue you'd like to take up.
Yeah, I have a short list of questions. First, I believe that Mr. Pringle dealt with this yesterday, but I just wanted to clarify that Malachi Bowman will not be appearing tomorrow for staff under the issue of depreciation because his issue has settled in the partial stipulation agreement.
Okay. I was, all right. Maybe I didn't match the issue numbers and sub-issue
Okay.
letters. So there will be no testimony on depreciation.
Well, there is.
Okay.
But this is just a specific witness, and the depreciation rates were part of the first partial stipend agreement that was filed, and the only issue that Mr. Bowman was testifying on were part of that, so he was
Okay.
inadvertently left on the witness
I
list.
do understand now.
And then next, just for clarification, since we are now dealing with, I cannot think of the name of the issue now. Normalized residential customer usage as part of revenues. Jared Robertson will now not be testifying under CCOS rate design. We'll just move him to later this afternoon.
Okay.
Next is Alexis Branson, whose testimony was admitted yesterday, needs to make a correction to that testimony, and since it has already been offered and admitted, staff was wondering if you had any direction as to how you would like that addressed.
Can a corrected copy be filed?
Yes.
After the parties get to review?
Yes.
Okay, let's do it that way.
Okay. And then the last thing is I have a list of issues here that I have distributed to all parties, and I don't believe that I have heard back from everyone, but I've heard back from most. There are a few issues where parties have agreed to waive cross on staff witnesses. Because these specific issues that I can list off for you, the only difference between staff and the company is actually related to discrete adjustments. And discrete adjustments will be addressed by staff witness Kim Bolin tomorrow morning. These staff witnesses can still be available to testify, but we would just request that any questions for them be kept general, and any questions about discrete adjustments be directed to Ms. Bolin. And if it would be easier, I could email the list of issues that this affects.
Yeah, let's do it that way.
Okay, all right. And that is all I have.
Okay.
Judge, one question for the corrections, Casey. Will they be redlined or then in like an errata sheet? How extensive are they?
That I cannot answer right now.
All right, Mr. Kleiser.
Yes, the Office of Public Counsel had previously offered OPC's Exhibits 318, which was the data request 8015 and the response provided by Missouri American Water, and OPC's Exhibit 319, which was page 20 of the OPC's position statement as referenced in the testimony given today by Ms. Mansell. I had originally offered both of those exhibits. I would now like that they be, you take up the offer.
Okay. And the parties have had an opportunity to see those documents.
I attempted to distribute them. If any party has not, please let me know right now. I have copies.
Yes, Your Honor, the company has received them. We will not object to the data request, although I would note for the record, the responsible witness for this data request response was Charles Ray. The proper protocol, if it was to come in, would have been through cross-examination of Mr. Ray. We do object to the page from the statement of position. We were told on cross-examination that this position was nowhere stated in pre-filed testimony. The practice of, now introducing a written document that really, if they wanted it to be in their case in chief, they should have put it in their case in chief, and so on that basis, we object.
All right. But this is, I understand your procedural objection, but I'm going to overrule that objection. Are there any other objections? All right, exhibits 318 and 319 are admitted. All right. We are already starting.
Your Honor, I have, this is Tim Opitz, MECG. I have one additional, I guess, preliminary matter.
Yes.
Maybe an hour or so ago, there was a stipulation filed. MECG intends to file an objection to that. I know it was, one of those issues was related to one that was supposed to be heard today. I guess maybe I should inquire of the parties. Is there a way that they all had thought to approach that, or if the judge prefers, I'm still happy to take up that issue today as well.
Can we go off the record for about 5 minutes to confer internally?
Yes, let's go off
Or
the
less?
record. go back on the record. All right, and we are back on the record, and while off the record, one of the things that was discussed was the second partial stipulation agreement that includes, I'm sorry, yes, the second partial stipulation agreement that has to do with the issue of universal affordability tariff. The company's witness on that topic, that issue, Mr. Ray, is unavailable after today. So the current plan is to take class cost of service first, and then there will be opening statements on universal affordability tariff, correct? Okay. And witnesses on that issue. So with that, Missouri American, call your first witness.
Thank you, Your Honor. Our first witness is hopefully a short one because he's got one topic that has not yet been covered, and that is Jody Carlson. Mr. Carlson testifies on the consolidation of the 5/8 and 3/4 inch meter charge. And his testimony has already been admitted, so he is available for cross-examination.
All right. Staff, do you have questions on cross?
No questions.
All right. Public counsel?
No questions.
All right. Consumers counsel?
No questions, Your Honor.
All right. Any of the other interveners? Yes, Mr. Bednar.
You as well?
Turn on the mic. Just a couple quick questions. On page 44 of your, I think it's your direct testimony, you state at the bottom of the page, lines 20 through 21, that there are approximately 425,500 customers that currently have a 5/8 inch water meter?
Correct.
Now, can you tell which one of those are true residential customers versus commercial users?
Versus what, I'm sorry?
I think commercial users, aren't they also in rate A to some extent?
I don't know that we would have any, yes, we can determine those under the rate A commercial, yes.
Okay. And how do you go about doing that? What are the, how do you determine the non-residential? I guess you referred to it, and I think in this testimony, maybe others have referred to rate A as having both residential and non-residential users. So I would be focusing on how do you determine the difference between those, or can you? Or is that for Mr. McClellan?
I think that would probably be better served for Mr. McClellan or possibly Brian LeGrand.
Okay. And then in regards to the new meters, the AMI meters?
That would be the direction we would go, yes.
Okay. And can you describe what those meters do and the process of installing those?
On this switch out, it would simply be changing out the existing meters, putting a new meter in. There's an antenna that goes with that, that's then a cellular read, and then that gets communicated back to our database.
And within that meter, can you program that to determine whether it's a residential or non-residential customer?
I don't believe that meter is programmed that way.
Could it be programmed that way?
I don't know the answer to that.
Okay, thanks.
Yeah.
No further questions.
Any other cross from the interveners? All right. Do the commissioners have any questions for Mr. Carlson? All right. Hearing none, Mr. Carlson, thank you.
Thank you.
And the company may call their next witness.
We call Mr. McClellan, please.
Sir, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Kyle.
Good afternoon. Can you please state your name and spell it for the court reporter, please?
Max W. McClellan, Last name is spelled MCCLELLAN.
By whom are you employed and in what capacity?
I'm employed by the American Waterworks Service Company. I am employed as a principal regulatory analyst.
Mr. McClellan, for purposes of this proceeding, have you caused to be prepared in written question and answer format your direct testimony?
I have.
And is that document marked for identification purposes as Petitioner's Exhibit Number 18?
I believe it is.
Have you also caused to be prepared in written question and answer format your rebuttal, surrebuttal, sur-surrebuttal testimony?
I have.
And is that document identified for is that document marked for identification purposes as Petitioner's Exhibit 19?
I believe it is.
Do you have any corrections to either Exhibits 18 or 19?
I do not.
If I were to ask you the questions in Exhibits 18 and 19, would your answers be substantially the same?
Yes.
Are the answers that are set forth in Exhibits 18 and 19 true to the best of your knowledge, information, and belief?
They are.
Petitioner would offer Exhibits 18 and 19.
Is there any objection to their admission? Exhibits 18 and 19 are admitted.
Witness is available for cross-examination.
All right, does staff have any cross-examination?
No questions, thank you.
Public counsel?
No questions, thank you.
Consumers counsel?
No questions, Your Honor.
City of Riverside?
Yes, Your Honor.
Okay. Mr. Bednar?
Mr. McCollum, nice to meet you.
Nice to meet you.
Appreciate the work you've done on this case. I'm just going to ask you a few questions about some of the background and terminology and the class structures.
Okay.
One of your responsibilities in this testimony was to present the case for single tariff pricing, correct?
That is correct.
As well as the differentiation between classes, Class A, J, et cetera, correct?
Yes, that's correct.
Can you tell me whether or not there is a definition for residential user versus the non-residential user?
I don't believe there's a definition. I do believe whether or not a premise is a residence can come into play. I believe for rate J, if a customer is a residence, that would automatically disqualify customer account from being part of rate J.
So you could have a commercial, when I say, I think you referred to in your testimony, residential and non-residential, and then rate J. So is that correct? That you have those three different distinguishing characteristics?
Yes, that's correct.
Okay. And so how do you distinguish, just within rate A, residential versus non-residential?
Sure, the underlying data does have customers by residential, commercial, OPA, industrial, sales for resale, et cetera.
But within rate A itself, you're saying, although you just went through 4 different categories, those are outside of, some of those are outside of rate A, though, if I understand the testimony correctly.
Sure, I'm not sure where this is going, but within rate A, we don't distinguish between those classes within the tariff.
But in your testimony, you had labeled users, differentiated users in rate A as residential and non-residential, correct?
That's correct, and mostly those are differentiated in the context of the cost of service study.
And can you explain that to me, please?
Sure, in the cost of service study, those are separated customer classifications, utilizing data from the billing system.
What type of data do you utilize from the billing system?
Meter charges, ultimately this is used to create billing determinants for revenue purposes as well as to categorize customer costs for those cost of service studies.
And the volumetric information, would that be within those determinants? How much water that user is using?
Certainly.
Okay. You mentioned the way you distinguish rate J from others, that if a user who has a residence in their location would automatically be disqualified from rate J, correct? What are some of the other requirements to be included in rate J as opposed to rate A?
A user must use 450,000 gallons regularly, the vast majority of the time. they must essentially have a flat level of usage.
Can you explain that flat level of usage, what that means?
There's a ratchet within rate J in which if a customer is to not use a certain amount, and I would have to look into this really quick, but just off the fly, if a customer's not using a relatively flat amount of usage, there was a ratchet that would basically increase their bill such that their usage, their billed usage is flat throughout the year.
Sorry to interrupt. Can you speak into your microphone? Some people are having a hard time hearing you.
I think going back to, if I understand you correctly, within rate A, you will have users using anywhere from 1,000 gallons a month to 450,000 gallons a month, correct? Or 400,000?
Rate A serves all general service customers. A customer that uses more than 450,000 gallons is certainly still eligible for rate A.
Okay. Has there been any discussion analysis for creating a new rate class potentially for the instead of referring to rate A as residential and non-residential members, has there been any discussion about converting it to residential and commercial classes?
Within the rate design?
Yeah, so you could create basically a new rate, rate C, for instance, as opposed to rate A, residential, non-residential.
I'm not aware of any conversation.
Okay. Would that be outlandish in your mind?
I'm not sure.
Okay. So it's in the realm of possibility, if everybody agrees.
I've never considered it.
Right, that's important. I appreciate that testimony. In your, I think it's on page 30, it's your work paper, your work paper schedule MWM-4 in your testimony. I think your exhibit 18 would be. It doesn't have, it's page 1 of 1, but it's pretty much buried in your schedules. It's just referring to the volumetric charges amongst all the rate classes.
I have that open.
Okay, thank you very much. Now, we've heard testimony, argument about St. Louis County District and then non-St. Louis County District, correct?
Yes.
And that was part of your case, as you're advocating for single tariff to bring those districts together on rate A and closer on rate J. Is that correct?
That's correct.
So when we talk about, let's talk about just briefly about St. Louis County. Maybe we should just call that the Eastern District versus the Western District, because if I recollecting right, you have St. Louis County, St. Louis, or St. Charles County, correct?
Are you asking if that's included within?
Yes. What are all the geographic, political subdivision? I mean, how many counties are within the St. Louis County Water District?
I believe just the one.
Warren County isn't in St. Louis County?
I believe that Warren County is not within St. Louis County.
Right. That's what I'm saying. There are multiple counties within that district, though, correct? That we call the St. Louis County District?
I believe that the St. Louis County Pricing District is St. Louis County.
Solely St. Louis County?
I believe that to be the case.
Okay.
Mr. Bednar, excuse me, Mr. McClellan, can you speak closer into the microphone?
Sure, absolutely.
Thank you.
And within your testimony, you're still advocating for a difference in rate J between the St. Louis County and non-St. Louis County, right?
In my proposed rate design for rate J, the proposed rates for rate J, it's 2 blocks. The first block is actually consolidated within my proposed rates. And in that second block, it's still differentiated. That's correct.
Okay. And what is your basis for that
My basis for what piece of that?
For the second piece of the differentiation between the east and western side.
Currently, I believe that the two rates are 48% apart, so for the purpose of gradualism.
Okay, thank you. Can you explain gradualism?
Gradualism, it's in my testimony, but essentially to mitigate potential rate shock that could occur.
Did you hear the opening of Mr. Fisher?
I've heard
About St. Joe?
today.
Yeah, just about the rate shock of St. Joseph, Missouri.
I did hear that, yes.
Okay, no further questions.
Thank you.
Thank you. Is there any cross on behalf of MECG?
Not at this time, Your Honor.
Any on behalf of MIEC? No questions, thank you. All right. Mr. Fisher, any on behalf of the Public Water Supply Districts? Okay. And Mr. Harden? Any cross?
No, thank you.
Are there any questions from the commissioners? All right, hearing none. I have a question or two myself. Mr. McClellan, I'm going to refer you to your schedule, MWM5. So, first of all, can you tell us what that is?
MWM5 is the proposed wastewater rate design.
Okay. And is there, I didn't see anything indicating this, but is there anything on that document that's confidential?
On MWM5,
Right.
no, I believe nothing here is confidential.
Okay. That schedule lists minimum charges for Holiday Inn, Jellystone, Six Flags, a usage charge for Route 66, and a bulk rate charge for Pilot Knob. Are these all special contracts for wastewater?
I believe that these are minimum charges that were essentially, for lack of a better term, grandfathered in.
I see. So, in your opinion, they should not be listed on tariff sheet 3.1?
Your question is that should they or should they not be listed on the tariff sheet?
And I don't have the tariff sheet in front of me.
Sure.
But my understanding is that they're not listed on that tariff sheet.
I believe that you would be correct in that. I have no opinion on whether or not they should be included on the tariff sheet.
Okay. Should they have their own tariff sheets?
I do not know if they have their own tariff sheets. I don't think that would be unreasonable.
Okay. All right. That was my only question. Staff, do you have any recross?
No questions.
All right. Public counsel?
No questions, thank you.
Any other parties? All right. Mr. Kyle, do you have redirect?
No redirect, Your Honor.
All right, Mr. McClellan, thank you for your testimony.
Thank you.
And Mr. Kyle, is that
That concludes our witnesses on cost of service and rate design, Your Honor.
okay? All right, and staff has witnesses on this issue?
Yes.
Or at least one witness. You can go ahead and call that witness.
Staff calls Melanie Marek.
Thank you. Would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. Go ahead.
Could you please state and spell your name for the record?
Melanie Marek, Melanie, Marek.
And how are you employed and in what capacity?
I'm employed with the Missouri Public Service Commission as a lead senior utility regulatory auditor.
And for this case, did you prepare direct rebuttal testimony marked as Exhibit 217 and cross-rebuttal, surrebuttal testimony marked as Exhibit 221?
Yes.
Do you have any changes or corrections to make to your testimony?
No.
If I were to ask you the same questions contained in your testimony today, would your answers be the same or substantially similar?
Yes.
And are the answers contained in your testimony true and correct to the best of your knowledge and belief?
Yes.
I offer Exhibits 217 and 221 and tender this witness for cross.
Are there any objections? All right. Hearing none, Exhibit 217 and Exhibit, I lost track here, I'm sorry, 221? All right, are admitted into evidence. All right. Does the company have any cross-examination?
No, Your Honor.
Public counsel?
No, thank you, sir.
Consumers Council of Missouri?
No questions.
City of Riverside? All right. MECG?
A few questions, Your Honor. Good afternoon, Ms. Merrick.
Good afternoon.
You did not perform a class cost of service study for this case, did you?
I did not.
Instead, you rely on the staff's analysis from the prior case, is that correct?
The results and outcomes of the prior cases, yes.
And you did not perform that analysis in that prior case personally?
I did not.
And you did not develop the underlying work papers that supported that testimony in the prior case?
That is correct.
And you did not include as attachments to either of the rounds of testimony in this case the results of that study?
Correct.
Are you aware that in the prior case there was testimony calling into question the accuracy of the staff's analysis on class cost of service?
Am I aware of that from the testimony in the prior case? Was that the question? I'm sorry.
Are you, in general, are you aware that there was testimony in that case calling into question the accuracy of those staff cost of service study results?
Based on the opening statements, and yes.
Would you agree that in her testimony in this case, Ms. York pointed out some of those errors that were identified in the staff's prior cost of service study?
I do recall that from her testimony, yes.
Staff's position is that the same allocation factors used in the last case are sufficient for this one. Is that correct?
Yes.
Can you tell me what are those allocation factors?
I cannot know.
I have no further cross, Your Honor.
All right. Is there any cross-examination by MIEC? All right. Thank you. And Mr. Fisher, any on behalf of the public water supply districts?
Yeah, Judge, I'll come up here where I've got a microphone.
Perfect.
Good afternoon, Ms. Merrick. I'm Jim Fisher, and I represent a couple of water districts in Andrew County. I've got a few questions for you about your class cost of service and rate design testimony. Do you have your direct rebuttal testimony with you?
I do.
Okay. On page 2 of your testimony at line 16, you state that rate B is for wholesale customers that are reselling water to other customers. Is that right?
That is what it says, yes.
Is it your understanding the rate B would be applicable to, would be the applicable rate for water districts like the ones that I represent, public water supply districts?
I don't know,
You-
I don't know the public water supply district's operations.
Okay, that rate applies to the two districts that would resale water from Missouri American, is that your understanding?
Yes.
On page 3 of your testimony, beginning at line 6, and I believe you just answered this question, you indicate that the staff did not prepare a class cost of service study for water operations in the case, correct?
That is correct.
And on page 3, you also indicate that staff has relied upon the class cost of service study prepared in Missouri American's last rate case for developing your recommendations in this case. Is that true?
Can you repeat that question, specific, sorry?
Yeah, and I'm referring there to line 8 on page 3, where you say the staff did not prepare a class cost of service study for Missouri American water and sewer operations, but because it appears with Missouri American's submitted cost of service study and the staff's prepared cost of service study from the last case, there was not much difference in the cost allocations, and that's where you basically have used, in part at least, your results from the last case for making your recommendations in this case, correct?
Correct, yeah, I can see that.
And just for the record, it was the last rate case that Missouri American had, WR 2022-0303. Is that your understanding?
Yes, and I think that's supposed to be footnoted there,
Okay, oh, that's right.
but I don't see it on there.
Do you happen to have your, the position statement of the staff in this case?
I do not.
Okay, let me give you a copy that relates to the rate design.
Thank you.
If you turn to page 4 of that position statement, it indicates that it's, and I've highlighted it, I think, on your copy, it's staff's position that the same allocations used in the last rate case are sufficient for this one. Is that right?
Yes, it says that.
And then there's another section just below that, 3A, double the little i's. Do you see there, you say that staff answers the question, what is the appropriate allocation of revenue requirement among the rate classes? Do you see that? There's a question there.
Yes.
The staff position statement goes on to state it's staff's position that the same allocations used in the last rate case are sufficient for this one. Is that right?
It does say that, yes.
Okay. Judge, I'd like to have an exhibit marked. And I don't know what my numbers are. I haven't had any testimonies.
Thank you.
Mr. Fisher, under the numbering system laid out in the order setting procedural schedule, excuse me, your exhibits are in the range 700 to 749, so.
Could I have 700 then?
700. It is available.
Ms. Mark, I'd like to show you this exhibit, which I've taken from the rebuttal testimony of staff witness Carrie Roth in that last rate case. It was exhibit 127. Have you previously seen this schedule?
Oh, when you presented it to me, yes.
You've seen this before?
Yes, when you presented it to me.
Okay. Does this schedule appear to contain the summary of the staff class cost of service study results from Missouri American's last rate case?
It does say staff class cost of service study. And it does have the prior case number on it.
You don't have any reason to doubt that that's the results from the last rate case? Maybe I should show you the staff's testimony in that case. I'm showing you Exhibit 127 from that case. Does that appear to be the rebuttal testimony on class cost of service from Carrie Roth, the staff witness?
It does appear to be, yes.
And would you look on the last 2 pages of that? Does that have the schedule that I just asked you, exhibit number 700?
It does appear to be the same, yes.
Okay, great. Judge, I'd move for the admission of exhibit 700.
Your Honor, I object to the admission of Exhibit 700 as hearsay. The witness testified on cross-examination from MECG. She did not prepare that document. She did not prepare the underlying work papers related to it. She did not include that document or the underlying work papers in her testimony either round in this case.
Judge, in response, I just say this is the cost study that she relied upon to make her recommendations in this case. It's the staff's class cost of service study from the last case that was admitted, and it's appropriate that the commission in cross-examination allow me to cross her on what she relied on in this case and have it introduced.
I would agree with that. So I will overrule the objection and admit Exhibit 700.
Ms. Merrick, I'd ask you to turn to the second page of this exhibit, 700, which deals with the staff's class cost of service study results for District 2. Do you see that?
I do, and it's Marek.
I'm sorry, what did I say, Mark?
It's Merrick.
Merrick, oh, I'm sorry, I apologize. I heard it 2 different ways today. Merrick. Marek, I'm sorry.
Thank you.
I apologize.
It's okay.
Is it your understanding that second page relates to District 2 results?
Yes.
Would it be correct that Public Water Supply District in Andrew County would fall into that District 2? Is that, do you know? If you don't know, that's okay.
I don't know definitively, no.
Okay, let's look at the row that applies to the sales for resale customers.
Okay.
Staff's class cost of service study in the last case was showing that the cost of service for this class after the reallocation of the public fire costs was approximately $2.842 million. You see that?
Yes, I see that.
And the present revenues for the sales for resale customer class was $3.626 million. Is that right?
That's what it says, yes.
And so the staff schedule indicates that the sales for resale class, the revenues exceeded the staff's cost of service study by $783,756. Is that right?
That is what it appears to be saying, yes.
And that's just for class 2, correct?
District 2?
I'm sorry, District 2.
Yes.
The last column shows that the present revenues exceeded the cost of service for the sales for resale class by 21.6%. Is that right?
As cost of service amount?
Yes.
And percent increase?
That's a percent reduction, correct?
Yes, it would be, it's negative, but it's cost of service.
Right, cost of service.
Yes.
And none of the other classes in District 2 were exceeding their respective class cost of service, correct?
From this study, no.
And that's the staff study.
Apparently.
All of the other numbers in that, for the other classes in that last column are positive percentages, correct?
Correct.
If we look at the row down below there where the staff lists the total revenues, it indicates the total proposed revenues were $16.2 million higher than the present revenues for that district? Yes?
I think so, yes.
Yeah, that was based upon the staff's EMS run at that time. Is that what that note down on the far, down below there on the bottom part shows?
Yes, that is what it says.
And so that was a 17.8% increase in rates overall, correct?
Yes.
So is it your understanding from this summary schedule that if the total revenues of the company were assumed to be increasing by 17.8%, the revenues for the sales for resale class should be reduced 21.6% if the rates were changed to reflect the cost of service study results of the staff study? Is that right?
So it says the cost of service increased by 17.8%. It doesn't say the rates did. The rates are separate.
Right, that's how much the revenue requirement was going up, 17.8%, but to get to cost of service for the sales for resale class, you'd need to have a rate reduction of 21.6%. Isn't that what that shows?
I believe so, yes.
Let's turn to the first page of the exhibit, which relates to district number 1. Is it correct that the sales for resale class in this district was exceeding its cost of service by 17.7%, according to staff's cost of service study?
I believe so, yes.
And none of the other revenues from the other classes in District 1 were exceeding their respective cost of service, according to the staff's cost of service study, correct?
Correct.
Let's go back to your, the position statement, the staff position statement. On page 4 there, it goes on to state that you asked, the question is, I guess, in our list of issues, should the commission utilize the class cost of service studies filed in this case to determine the appropriate allocation of the revenue requirement to each class? Do you see that?
I see that, yes.
And then if you drop down to where you answer the question, the staff position statement answer says, no, the class cost of service study filed by Missouri American Water was based on a future test year, which includes estimated future expenses and revenues, and therefore invalid, correct?
That is what it says.
That's your position?
That's staff's position.
Staff's position, okay. And then it goes on to say, the adjustments proposed by MECG include assumptions as made by Missouri American Water Company and therefore also not reasonable. Is that what it says?
That's what it says, yes.
And that's staff's position?
Yes.
On page 4 at line 5 of your testimony, you're asked the question, what rates are staff proposing? You see that?
Of the direct rebuttal testimony?
Yes. And your answer on line 6 is staff's rate design can be found in the attached schedule MM-D2. Is that right?
Yes.
I might not have had a correct copy in EFS, but was that attached in the EFS filing?
It's filed in EFS, yes.
Is it filed in EFS?
Yes. They're two separate documents under the same entry.
Okay, so you're okay, we've got that study, we've got that schedule in the record?
Yes.
Okay. That's all I have, Judge. Thank you very much.
Mr. Harden, do you have any cross-examination?
I do not, thank you.
All right. Are there any questions from the commissioners? Okay. Hearing none, I do have a couple of questions myself. And I assume you still have your direct and rebuttal testimony handy. This would be on page 4. On line 14, there's the question, does staff agree with aligning the commodity rates closer together? And part of your answer on line 17 says, basically, Missouri American Water Company is attempting to slowly consolidate all its rates into a statewide tariff. Is it true that in the company's last 3 or 4 rate cases, the commission has consolidated numerous rate A districts closer to a singular rate A cost of service?
Honestly, Your Honor, I don't know.
Okay. Do you have an opinion, though, as to whether eventually we should get to that point, full consolidation of rate A customers?
Staff is against that.
Okay. Despite the staff's position, if the commission were to decide to consolidate the rate A customers into one tariff, do you think the commission would have the opportunity to deconsolidate or break up those rate A customers in a future rate case if that's what the cost of service demonstrates?
I haven't considered that before, but it does seem possible. I think there would be, I don't know that that would be beneficial to ratepayers, though.
Okay.
Really confusing.
All right. Does the company have any recross?
No, Your Honor.
All right. Public counsel? Recross by any of the other parties? Yes, Mr. Kaufman.
Ms. Merrick, yes. Marek, I apologize.
That's okay.
Ms. Marek. Have you calculated what the additional impact would be in the St. Louis County area if the commission moves to single tariff pricing? Just the single tariff pricing change, how much roughly would rates go up?
We did not calculate that because we are against it, because it strays from cost causation.
But earlier you said, you testified about I believe the St. Louis County rate A area, or I'm sorry, which District 1, I guess is what we call it, is 48% of something. Do you recall saying that earlier? And I wasn't sure exactly what was meant. I think in response to a question from Mr. Kleiser. You don't know that.
I don't recall saying any
Okay.
percentages, nor him asking me.
Probably
questions.
my confusion. I'm sorry.
Okay.
That's all I have.
All right. Any other recross? Any redirect?
Just a few questions. Ms. Marek, because staff is proposing an across-the-board percentage increase, doesn't that therefore mean that no changes to the allocations are necessary?
Correct.
And do you recall being asked about the class cost of service study from the last rate case?
Yes.
And there were some questions about whether or not there might have been errors in that?
Yes.
Could you explain to me what is the relationship between a class cost of service study and rate design?
So the class cost of service study is just used as a guide in rate design. And with rates like Missouri Americans, where rate A includes so many classes, rate design takes the overall revenue requirement and allocates it through each of their rate classes.
So would it be accurate to say that there is more work to be done after a class cost of service study to develop a rate design? A class cost of service study, does not produce a rate design?
That's correct.
Okay. No further questions.
All right. Thank you for your testimony.
Thank you.
All right. I don't recall exactly whether this was discussed on the record, but Mr. Robertson will testify in a bit when we get to the issue of revenues, correct?
That's correct.
All right. And Mr. Kaufman, Ms. Palmer will testify on Monday. Okay. And so next on the list is Jessica York. So, Mr. Opitz, would you like to call her as a witness?
MECG recalls Miss Jessica York.
Okay. All right. Mr. Opitz, go ahead.
Miss York, I believe your testimony has been admitted. I tender the witness for cross-examination.
Mr. Kaufman, do you have any cross-examination?
No questions, Your Honor.
Mr. Bednar? Mr. Bednar, I'm sorry. Could you?
I apologize. Ms. York, question on the rate design issue. I guess, number one, would you agree with the statement that rate design, cost of service doesn't dictate rate design?
Yes, I generally agree that it is, ideally you would set rates based on cost of service, but it's not always possible to do that.
Right. And then in regards to rate A, and the issues there with a number of different types of users, has anyone ever asked you to present any type of an opinion as to breaking that rate up, separate from rate J, and would not have separate and apart from rate J, just have for instance, a rate C?
Generally speaking, class-specific rates would be good. I mean, it would be easier to tie them to the cost of service results then.
Right. When you have a class that goes from 0 to 450,000 gallons of usage, that's a pretty broad band to be able to utilize cost of service effectively. Wouldn't you agree?
That would certainly make it more challenging, yes.
Yeah. Thank you. No further questions.
All right. Any cross on behalf of MECG?
I could phrase this as friendly cross, but I just wanted to give the witness the opportunity to respond to the chair's questions earlier about concerns or flaws with the staff's cost of service study from 2022 that's been so much discussed. So if that's all right with the commission, I'll go forward with that.
Yes.
Okay. And this, I explained this in my cross-rebuttal, surrebuttal testimony. I pointed out that in the last case, the staff had originally not applied the distribution multipliers that it had supported in its direct testimony to its actual class cost of service model for rate J or the sale for resale classes. I showed that the staff's models included maximum day and maximum hour demand ratios by class from a prior rate case, with no evidence to prove that those factors were still representative of the load characteristics of the classes as of the last rate case.
Okay. And Ms. York, I'm going to interrupt. Could
Go
you
ahead.
move your microphone down a bit?
Sorry, yes.
Perfect.
Is that better?
Thank you.
I also pointed out that there were some other unsupported data points, including the source of average day rate of flow used to develop allocation factor 3, and other things like the horsepower of pumps used to develop factors 6 and 7. So then in rebuttal testimony, in staff's rebuttal in the last case, they did make some corrections for those issues. They did end up applying those distribution multipliers to the industrial and sale for resale classes. They did update the customer class max day and max hour demand ratios. And they had modified some other data points that were used to develop their allocators, like the annual usage by customer class, let's see, max day demand ratios, maximum hour demand ratios, the weightings of the base, max day, extra capacity, and fire protection components in the development of factor 3, weightings of base, max hour, extra capacity, and fire protection components in factor 4, and the weightings used to develop factor 5 as well. And the issue that I had in that case, even with those corrections, staff's testimony did not really explain any of those things, any of the changes they made, other than acknowledging that they had updated the distribution multiplier issue. So my position in that case was that because staff's testimony was silent on the other changes that it made to its models, it really hadn't supported those changes. And so we were still hesitant to be relying on that model in the last case.
All right, anything else, Ms. Plesha? Okay. Mr. Fisher, do you have cross? You knew what I was going to ask, didn't you?
Sorry. With those changes, though, staff did correct many of the things that you'd brought up in your rebuttal to their case, right?
They made the changes, but I was still not able to verify whether those were acceptable or, reasonable, justified, correct, and so on and so forth.
Were there any suggestions that you'd made they didn't do?
I don't remember. I don't know if I captured all of the changes in this testimony or not. I really don't recall.
Your testimony also in that case indicated, didn't it, that the resale class was recovering a greater percentage of the cost of service than other classes?
I don't recall offhand, but it might have. I mean, that testimony is
Okay.
up there.
Yeah. Okay, thank you very much.
All right. Mr. Harden, do you have any cross?
I do not, thank you, Your Honor.
All right. Mr. Kleiser, do you have any on behalf of public counsel?
No, thank you, Your Honor.
And staff?
No questions.
Mr. Kyle?
No questions, Your Honor.
Are there any questions from the commissioners? All right. And, all right. I have no questions myself, so thank you for your testimony.
May I have one
Oh.
redirect question, Your Honor?
Oh, I'm sorry.
Ms. York, you were asked about staff's cost of service study in the last case. Even if we assume that there were no errors with that, the staff is still not relying on that for its recommendation in this case. Is that correct?
Correct.
Thank you.
All right. Ms. York, you are free to step down. And my understanding is Dr. Mark is the next witness. All right. You do have your right hand raised. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Kleiser.
Dr. Mark, could you go ahead and state and spell your name for the record?
It's Jeff, Geoff, Mark, Marke.
And by whom are you employed and in what capacity?
Missouri Office of Public Counsel. I'm the chief economist.
And did you prepare a cause to be prepared testimony that has been marked 308, the direct rebuttal testimony of Jeff Mark, and 309, cross rebuttal testimony of Jeff Mark in this case?
Yes.
Do you have any corrections to make to that testimony at this time?
No.
If I were to ask you the same questions posed to you in that testimony today, would your answers be the same or substantially similar?
Yes.
I know those answers true and correct to the best of your knowledge and belief.
Yes.
I move for the admission of Exhibit 308, the direct rebuttal testimony of Jeff Mark, and 309, the cross rebuttal testimony of Dr. Jeff Mark.
Any objections? All right. 308 and 309 are admitted.
I tender the witness for cross-examination.
All right. Mr. Kaufman, any cross on behalf of Consumers Council or AARP?
No questions, Your Honor.
All right. Mr. Bednar, on behalf of Riverside.
Just a couple of short questions. Wait, are we talking about monthly customer charge?
We can, yeah.
Still good, yeah. I just didn't want to I'm confused on the two categories. I
think you stated you found no basis for the increase from 10 to 21.34 per month in the requested increase in monthly meter charge?
Yes.
5 minutes. And is that in a, not the requested revenue stabilization form, but is that not almost a rate stabilization mechanism of its own right?
It is.
Right. And then you also talked about potential, I'm sorry, never mind. No further questions.
All right. Any cross on behalf of MECG?
No cross, Your Honor.
All right, thank you. MECG?
No questions. Thank you, Judge.
Public Water Supply Districts? All right. And Mr. Harden, any on behalf of Triumph Foods?
No, thank you, Your Honor.
All right. Ms. Aslan, any cross on behalf of staff?
No, thank you.
And any cross by the company?
No, Your Honor.
Do the commissioners have any questions for Dr. Mark? All right. And I don't have any questions, Doctor, so yes.
Dr. Mark, with regard to the question posed to you by Mr. Bednar, and the rate stabilization impact that the increase in a customer charge would have, does that rate stabilization justify a increase to the customer fixed charge?
Well, I don't think either do. You know, we've been pretty vocal about the RSM's already been discussed at length this morning, but the customer charge, the combined two provides more revenue certainty to the company. You know, and again, this is a balancing act that the commission's got to consider. And the way I would advise the commission on this is it's a risk reward issue. So with each incremental, in isolation, moving to, you know, 113% increase in the customer charge, you know, there might be some logic behind that in, you know, from one perspective, but collectively all of it is doing is it's all increasing or decreasing the risk to the company, decreasing the company's ability to function as something that would be comparable for what you would see in the market. And the reality, you know, in any other market-based entity, they've got the discipline of the market. You know, people can choose where they want to go. They can elect to do different things. And the real basis behind this building and everything that goes on here is to serve as a proxy for that. Absent that, then you start sitting there and start questioning, why are we doing a risk premium? Why are we putting that profit at such a high level? And I think at a certain point, you're going to start to get questions from the public at large. And you see this take place in some other states that move to municipalization, where you know, the frustrations with the investor-owned utility, you move towards a public system, and that's taken place with other cities. I think American Water's done a good job, mind you, but when you start approaching, you know, 30-40% rate increases on a continuous basis, it becomes much more difficult for customers to be able to afford that. Having the power to, you know, take control of your bill on the usage is one mechanism to do it.
Thank you, Dr. Mark. No further redirects.
All right. Thank you, Dr. Mark.
Thank you.
And Mr. Kleiser, do you have another witness?
The other witness is responding to the issue that we have now, I think, effectively moved to revenue. So assuming that, yes, I have no further issue on the existing class cost of service at this time.
All right. Then are we prepared to move on to the uniform affordability tariff? Okay.
Your Honor, Can I ask for maybe a 5-minute recess?
Actually, let's do a 10-minute recess. We'll reconvene at 2:40 and going off the record. We're back on the record. At this point, we will cover the issue of the universal affordability tariff. And so would the company like to call any witnesses on that issue?
Good afternoon. The company doesn't need to call a witness unless somebody wants to cross, but we have come to an agreement with the staff of the commission, the Office of Public Counsel, Missouri AARP, and Consumer Counsel of Missouri, and we filed that stipulation earlier today in EFIS. We will be filing an updater. There was a scrivener's error in the draft that was filed, so we will correct that. It doesn't change the substance. All those parties are in agreement, and that is the collective position of each of those parties now. We understand there's an objection to that from another party, and if he wants to cross one of our witnesses, we can call Mr. Ray back to the stand.
Your Honor, this is Tim Opitz, MECG. MECG is the party that will, at some point today, file its objection. Since we're taking this issue up now, I'd like the opportunity to be heard with a mini opening statement, and then I do expect to cross-examine Mr. Ray.
Are there any other parties that would like to present a mini opening statement? Okay, it sounds like not. So, Mr. Opitz.
May it please the Commission, again, Tim Opitz on behalf of MECG. Universal affordability tariff sounds like a good thing, and you're probably wondering why I would lodge an objection to that. First, 10 years ago, in a Missouri American Water rate case, I believe, I was counsel for the Office of Public Counsel at the time, and I evaluated a proposal in that case and argued that a low-income rate was unlawful. And my argument there in my briefs, and I got right here, is that from that case is we had a responsibility to all residential customers, not just the low-income customers. And so we needed to take into account the legality of what was being proposed and the impact on other customers. In that intervening decade, I've not seen any Missouri court case law to change that legal analysis, and I've not heard anything or read anything, rather, in the testimony in this case that makes me change my view that this kind of low-income tariff is unsupported by authority of under the current law. You know, the premise is we've got to avoid unjust discrimination between customers when setting rates. Differences in rates must be based upon differences in service, and a customer's income is not an immutable difference in service here. Second, with respect to my review of the stipulation that's been filed, understanding that it may be updated, I do have concerns about the implementation. First, these costs are not known and measurable. You know, I don't understand how any party can make an assessment to support this kind of program when the company's own testimony says that 69,500 customers could potentially see a 55% discount on their bills. If every eligible customer took service under that regulatory asset would be a humongous figure. A subpart of that about the implementation is the rate treatment when that regulatory asset is considered in a future case, if it's approved, is unknown. You know, I have concerns about whether the company might ask for a return on that amount or the speed at which it is amortized. These are concerns that will impact rates possibly significantly in a future case. And then third, to me, it is incredible that a company asking for a 40% increase, within that increase is a request for, I believe I heard yesterday, a highest in the nation 10.75 return on equity, is asking for an affordability tariff. Physician, heal thyself. What has the company done to control its cost? As far as I've seen, in the presentation of this case? Nothing. Should every other customer, the majority of the residential customers who aren't eligible to take on this, or business customers in rate A, or business customers in rate J, however it's allocated in the future, should they be on the hook to subsidize the excesses of a monopoly company that has made its rate so unaffordable that I believe 15% of its residential customers would qualify for a huge discount on their bill? I urge the commission to get back to the basics on affordability. We know as stakeholders in a case how to address affordability, and it's not by pursuing unlawful means. We should address it by rejecting their 10.75% ROE, which would be the highest in the nation. We should reject their capital structure, which has the impact of driving up the increase in this case. We should reject their RSM, which would cost customers more money without a rate case and without full review in the future. We should reject their PCT, the production cost tracker, which would cost customers more money in the future. We should reject their applications for accounting treatment that has been described as water pizza. All of these things will increase their rates. All of these things would lead to increases in their case. If affordability is an issue, the answer is not an unlawful approach that will further burden other customers. If affordability is an issue, the parties in this case know what to do, and I hope the commission knows what to do. And I will file my objection later on to their stipulation. Happy to answer any questions.
Do the commissioners have any questions?
I do. Mr. Opitz, since you're not a signatory to this pilot program, is there a budget for this particular program that you're aware of, a cap at all?
I'm not aware of the of a cap for the stipulated thing. I guess I haven't looked at the cap. My understanding of the testimony was that 69,500 customers would qualify for various levels of discount, 75%, 55%, and then a lower amount that I can't recall right now. Sorry, go ahead. No. I was going to say, if you did put a cap on this, that would further compound my concerns about the legality of this kind of program. Because if you're just going to open it up to some portion and it becomes first come, first serve for a program that is already of questionable legality, I think it compounds the problem.
And as far as you know from this stipend agreement, how would the cost for the program be recovered?
I don't believe in the document I reviewed that it was addressed in there. I think it was left unsaid for the future rate case, which again contributes to my heartburn about this. In addition, setting aside the legality of it, I don't know the magnitude of it. And I hope to ask the company witness if he knows some idea about the magnitude. But that number of customers, if I look at a 55% discount on a bill using the company's 21-point-something customer charge and their proposed per 100-gallon commodity charge, and I thought I read somewhere that there was about a $6,000 average use, or 6,000 gallon average usage per month. I'm looking at about an average bill of about $80-some a month after this case. So if 69,500 customers get 55% of that off, we put all that into a regulatory asset, they stay out for 2 years. I mean, how many tens of millions of dollars are we looking at there? Is the company going to earn a return on it? How are they going to amortize it? There's a lot of unknowns, and so I can't agree to that. And because I believe it's questionable legality, I think it's questionable policy, and I think it's unknown. I'll be filing my objection to that.
Thank you.
Thank you.
Thank you, Ms. Opitz. All right. Ms. Niemeyer, I do know that there's potentially some questions from the commissioners of Mr. Ray, so is it possible to recall him?
Absolutely. The company recalls Mr. Ray.
Go ahead, Ms. Niemeyer.
He's already provided his testimony. It's been admitted, so I have he's tendered for cross.
Okay. Ms. Aslan, would you introduce our next staff counsel that is making his appearance in the hearing, or he can introduce himself?
Good morning, Your Honor. I'm Eric Vandergriff, staff counsel. The court reporter has my information.
Perfect. Mr. Vandergriff, do you have cross-examination for Mr. Ray?
No, Your Honor.
All right. For the public counsel?
No questions, thank you.
Mr. Kaufman for Consumers Counsel, or AARP?
No questions. Or, well, let me just ask a couple. In reading your testimony, Mr. Ray, is it a fair summary that you find there to be a cost causation difference between high income and low income water customers?
Generally speaking, yes.
Okay. That's all I have. Thank you.
Okay. Mr. Bednar, any on behalf of City of Riverside? Okay.
No, Your Honor.
Mr. Opitz?
Mr. Ray, I've got a couple questions, but to go back to that question from Mr. Kaufman, he asked about causation. Your testimony doesn't say causation, is that right? Your testimony says correlation.
Can you point to where you're talking about that and where it doesn't say cost causation?
As one example in your, I believe it's your direct testimony, page 32. And I'm looking at lines 13 and 14, I guess going on to 15. And would you agree that you talk about the correlation between income and seasonal use of water?
Yes, so in that section of testimony, what I'm saying is that there is a positive correlation in the company's residential customer base between household income and seasonal use of water. Higher income does not cause the seasonal use of water, but customers generally that have higher incomes tend to use water more for seasonal usage, like lawn irrigation, swimming pools, that sort of thing, than lower income customers do. The cost causation issue is whether customers that use seasonal water more cause more costs to be incurred by the company than customers that do not. That's the cost causation issue.
And you don't disagree that there may be low-income customers who are seasonal users of water?
As I said, if you look at median household incomes across our territory and the communities that we serve and the seasonal use of water in those communities, there is a strong correlation between income and seasonal use of water. Are there low-income customers somewhere that may use more water in the summertime than they do in the wintertime? Yes, but generally speaking.
And there's high-income customers who may use less water in the summer too, right?
That is certainly true.
And they wouldn't be eligible. They'd be discriminated against under this tariff.
Why would they be discriminated against? I don't understand that question.
Because they would not be eligible based solely on their income rather than the nature of their service class.
It's a program that's whose eligibility is based on income. I don't consider customers who have high incomes that already have affordable water bills to be discriminated against by not being able to participate in the discount program.
In fact, they would be paying for the discount program in all likelihood.
Well, to the extent that those costs, the administrative costs and the costs of the discounts are included in rates at some point, not in this case, but at some point, all customers would be paying for that, not just the non-participating customers.
I have some concerns about the magnitude of this potential regulatory asset. In your testimony, would you agree that you describe it as 69,500 eligible customers?
We estimate that there will be that many customers whose household incomes would qualify them for participation in the program. And that's, as originally filed, that was 150% of federal poverty or less. Now, in the stipulation, and the tariff attached to the stipulation, there is an additional qualifier of 60% below the state median income level. I don't know if that expands participation significantly or not, but it is a slightly different set of qualifiers than what we had originally proposed.
So it's at least 69,500 in your estimate, but it could be more.
I don't know.
Do you know how many customers Missouri American Water has in rate A?
More than 400,000, I believe, residential customers.
Would you agree that the minimum filing requirements in this case listed as 445,445?
I wouldn't disagree with that.
So it's probably not exact, but in that wheelhouse, right? So if we take 69,500 divided by 445,445, that's about 15.6%.
That sounds about right.
So Missouri Americans' rates have increased so much that 15.6% of its customers need an affordability rate?
That's not what we're saying. If you want to think about the numbers of customers for whom we think that water service, basic water service, is more than 2% of household income, that information is provided on page 17 in my direct testimony with the affordability analysis we provided in this case.
But this tariff and the stipulation, and I don't believe the one in your testimony, was not so limited by that. It's the income, that if you qualify for that income, you're eligible for this program. Is that correct?
The eligibility requirements for the program are probably larger. Would include more customers than the customers that we have estimated fall in the different categories under page 17 that fall in the charts 5 and 6 on page 17 of my direct testimony.
Have you done any analysis about what the balance of this regulatory asset would be after 1 year?
So currently, as I understand it, the estimate of the administrative costs for the program are approximately $30,000 per month. I don't know if that's based on the
But a significant, I would say a more significant portion of this program's budget is going to be that discount that customers participating are given on their bills. Is that correct?
Your Honor, I'd like to interpose an objection. He has several times interrupted the witness while he was in the middle of his answer before moving to the next question.
All right. I'll note that. And
I agree, I have.
but yes, if we can wait until the answer is complete before you ask your
Well,
next
I'm
question.
asking yes or no questions for the most part, and if he goes beyond yes or no, then I'm going to ask a new question.
All right.
Of the program that is stipulated to, have you prepared an estimate of what that regulatory asset will be?
As I said, part of the cost of the program will be administrative costs, and we have an estimate for that. That's the $30,000 a month that I talked about before. But I don't know if that estimate is based on the originally filed eligibility requirements or the stipulated eligibility requirements. Mr. LeGrand could probably answer that question. The other part of the administrative cost will be the cost of the discounts, and that will be variable depending on the number of customers that participate. So I guess to answer your question, in total, no, we don't have an estimate of the total amount of costs that might be incurred in the program over time.
Would you agree that if 69,500 customers are eligible, that the potential regulatory asset will exceed $10 million?
Oh, I would have to work out the math with that. I can't agree to that sitting here.
Would you agree that if it does exceed $10 million, you won't seek recovery?
No, I wouldn't agree to that either.
By putting forward this tariff in your direct testimony, are you admitting that the company has an affordability problem with its rates?
No, there will always be customers on any system for whom affordability of service could be an issue. That is true. That is true as we stand today. Even absent a rate case, that would be true. And the goal of the tariff is to try to mitigate those concerns for the customers where we think that's where affordability is a concern. So no, it's not a reflection of whether or not rates are generally affordable or not, because there will always be some group of customers, unless you're giving water away for free, there will always be some number of customers for whom affordability will be an issue. And the point of this tariff and the point of this program is to try to mitigate affordability concerns for that group of customers.
But you would agree you're not giving away water for free? I'm sorry, that Missouri American is not giving away water for free?
We are not.
And you would agree that the company's request for 10.75% return on its equity will have an impact on the affordability of the rates?
Certainly, a higher increase granted in this proceeding relative to a lower increase granted in this proceeding, or no increase granted in this proceeding, would have an effect on affordability of rates.
And the return that the company asks for is something that's within its control, is that right?
Presumably.
I don't have any more questions.
Is there any cross on behalf of MECG?
Just one question. My clients haven't taken a position on this particular issue, but one question I have is there anything that would prevent the company from absorbing some of these costs below the line?
We don't believe that that's necessary or appropriate. based on the information that we provided in direct testimony on pages 29 or 28, 29, section D of my section on that tariff.
I appreciate that, but the question I asked is it possible?
Well, effectively absorbing part of the cost of the program effectively is a reduction in ROE due to the offering of the UAT, which I don't think that the company would agree to.
Chair Hahn, you have questions? Go ahead.
Thank you. In other, and I'm not an expert on low-income programs, but I have read some of the program guidelines for other low-income programs, and they do contain both shareholder dollars and ratepayer dollars. So are you telling me that this has 0 shareholder dollars in it?
This particular tariff offering,
That's right.
yes, that's true. Now, we have other low-income programs for which shareholders do contribute, but that's not a feature of this tariff offering.
Okay. And is it also true that this program would have no budget or no overall cap?
Not as proposed,
Okay.
at least in terms of the discounts that are offered.
How many other operating companies within within American Water Works have something similar to this that is uncapped with 0 shareholder dollars?
The programs that American Water, well, let me answer it this way. Pennsylvania American Water, New Jersey American Water, Illinois American Water have low-income programs that are designed almost exactly like this program. None of them have caps. West Virginia and California also have low-income programs, but they're not designed the same way that these programs are. I'm not aware of any program like this that American Water sponsors or operates where participation is capped at a certain level.
Okay, so you, in Pennsylvania, New Jersey, and Illinois, you have programs that are identical or nearly identical to this?
Right. Different discounts for different tiers of household income.
Okay. Are there any shareholder dollars that help support those programs?
Not that I'm aware of.
Okay. What about in West Virginia and California?
California, I don't know the answer to. In West Virginia, those discounts are actually funded by the state through a reduction in a certain type of tax that the company otherwise would pay, that they don't pay, based on the amount of discounts that are provided through the program.
Okay. So of the 12 companies, operating companies of Missouri American, 5 have some kind of program, 3 have identical programs.
Nearly identical. The tiers are different, the level of discounts are different, but the structure is the same.
Okay. Would it be possible for you to prepare an analysis that would show, under these assumptions of 69,500 folks, that's the minimum that would qualify without the SMI additional qualifier? That would basically be the floor. What that would look like in the regulatory asset over the next 2 years?
Sure. We could do that.
Thank you.
Yep.
Are there further questions from the commissioners?
May I ask a clarifying question?
Yes.
Is that an assumption that we can do that for any level of participation that you'd like to see? Do you want to see that for 100% participation, 50% participation, different?
I would probably run a range of scenarios, right? And maybe even model it off of participation in some of your other programs.
Okay.
I know OPC probably has how many folks, percentages of folks that normally participate in low-income programs, but I'm feeling uncomfortable with what's before me because I have no idea the kind of impact it could have. And I want to have a better understanding of that.
Sure.
Thank you.
Sure, no problem.
Any other commissioner questions?
Judge, if I may, it's
Yes.
Commissioner Mitchell. So Mr. Opitz pointed out that Missouri has a statutory prohibition against charging customers in the same rate class different rates. And I'm curious, how is it that this does not run afoul of that statute?
I don't have a copy of the statute. I don't know that I have an opinion on whether this program is legal or not legal. I can tell you that it is generally true that the cost of providing service to customers that use seasonal use of water versus customers that don't is different. And they are all being, essentially charged the same price. So we don't see that this low-income program runs afoul of any of that kind of principle.
But they are customers in the same customer classification that would be charged a different rate, true?
Can you ask that question again? I didn't catch all of that.
The customers that would qualify are customers in the same rate class that would be charged a different rate, true?
They today are charged the same rate.
Yeah.
They are all rate A residential customers.
But if this is approved and moves forward, that would be the case, true?
Some would be eligible for discounts and some would not. So effectively, yes, that would be true.
And I've heard the word pilot discussed. And what exactly does that mean, a pilot?
I'm sorry, I didn't get all the question again. I apologize.
So I've heard this described as a pilot program. Can you tell me what that means, a pilot program?
To be honest, I don't consider this, well, the tariff is listed as a pilot program. I don't think that it needs to be a pilot program because we have operated programs like this in other states and we're pretty well versed on how this works. Whether it needs to be or should be called a pilot program for the purposes of Missouri regulation is probably better addressed to a different witness than me.
Okay. Are you familiar with other pilot programs that have been approved or authorized by the commission that don't have an endpoint or don't have performance metrics or don't have a stated goal or data set that are trying to be evaluated?
I am not. But I also must confess that I'm not completely conversant on other pilot programs that electric or gas utilities in Missouri may have asked for approval from the commission for. Again, that was probably a question that would be better addressed to somebody else. And I'm looking at the OPC witness when I say that, so.
Okay.
Who appears to be nodding his head in agreement, so.
Thank you. Are there differences between what was originally proposed as the UAT and what is now being proposed as the pilot program?
The only difference that I'm aware of is the qualifier of state median income that was included, and it also appears that I should say, I'm sorry, there are a couple of differences. One is the inclusion of the state median income qualifier. Another is that this appears to apply to water and not to wastewater, which was not our original intent but I think we are fine with. The other issue, the third issue, is there is, as has been discussed, a tariff provision that says at the end that all customer discounts, administrative fees, and other program costs will be deferred to a regulatory asset for recovery in the next rate case. Originally, we had built in a level of discounts under an assumed level of participation in our rates. This tariff language would appear to negate that, and that there would not be any discounts built into rates, which would lower the volumetric rate somewhat, and all of that would be addressed at a later date.
And I guess the other difference would be the insertion of the word pilot into the language. Fair to
Yes.
say?
Yes, for whatever purpose that serves, yes.
And just bear with me a little bit. If it is a pilot program, what is it that we're looking to study or test? Or what would be the performance metric of whether the pilot was successful or unsuccessful?
Well, again, I personally don't consider this to be a pilot program in the truest sense, because American Water has these programs in other states. I think I would again defer to an OPC witness who might be able to better answer that question than me, particularly because it pertains specifically to Missouri regulation that they may be more conversant on than I am.
Thank you. And at the end of the day, is the effect on the general population of ratepayers really the transfer of what would otherwise be bad debt to a regulatory asset then would automatically be recovered in the next rate case?
Can you ask that again, please?
At the end of the day, is the net effect of this program to be a transfer of what would otherwise be bad debt to a regulatory asset that would then be automatically recovered by the company in the next rate case?
Well, I would say two things. One, I think that we would expect that bad debt expense would go down generally because of the existence of this program. Just because customers who might be facing that issue more, who participate in the program, will have lower bills. I think that the net effect of this program will be that water service will be affordable to more customers with the program than without the program, regardless of what the administrative or level of discounts might turn out to be.
But fair to say the discounts and administrative costs are simply transferred to the balance of the ratepayers. Is that correct?
All ratepayers will pay for them. So it's not transferred to just non-participating customers. All customers will pay for them, assuming that at some point all of that is included in rates. But the discounts that are offered to qualifying customers will result in an overall improvement of affordability across the system.
Well, I think some rates would go down and some would go up, and the net effect on the company would be zero. Correct?
Ultimately, yes.
Thank you, Mr. Ray. That's all the questions I have.
All right, Mr. Ray, to kind of piggyback on Commissioner Mitchell's questions about this being a pilot program, the actual, I'm trying to think of the right word, but I guess what creates this program is this tariff sheet, and it's a single page, correct?
Yes.
Okay. Looking at that single page, I don't see anything that discusses how long this pilot program might last. Do you see that?
There is nothing in the printed tariff page that discusses that. I would agree with that.
And nothing that really addresses any metrics on the success or failure of the program.
I would agree with that.
Okay. So as it stands here, we don't know how long this would be a pilot program versus a permanent program or what have you.
I don't, no.
Okay. I'm afraid you're going to tell me I should ask this witness, but I'm going to refer to the company's witness, Brian LeGrand. He has in his direct testimony, page 35. Let me find that. The question posed to him was just describe the regulatory treatment you're requesting for UAT cost. And his answer is the company is requesting that actual costs associated with the discounts be captured through the RSM, and that costs associated with the administration of the program be recorded and deferred to the company's next general rate base. So my question is, if the commission does not approve an RSM, how will those actual costs associated with the program be recovered?
Yeah, that feature would not apply under the stipulation, and I apologize to the commissioner. I should have mentioned that as another change. Originally, the company proposed that the discounts be recovered through the RSM. Under the tariff sheet, under the stipulation, those discounts would not be recovered currently under any mechanism. So it would not be recovered through the RSM.
Okay. All right. That's all the questions I have. Any recross on behalf of staff?
Yes, Your Honor. I believe that MECG and Commissioner Mitchell asked you about seasonal costs. What is the relevance of seasonal costs with regard to customers in this proposed tariff and the other customers in this that you're targeting?
One of the arguments that's commonly made against a program like this is that it amounts to a subsidy from higher income customers to lower income customers. The point of the analysis that we provided in direct testimony is to show that in many cases, higher income customers that have significant seasonal use of water are actually being subsidized by lower income customers and other customers who do not have seasonal usage of water. And there is a strong correlation between seasonal use of water and income. And so what we're trying to show is that part of what this program is doing is actually sort of reversing a subsidy that already exists that's going from lower income customers to higher income customers. That's the relevance of the discussion around seasonal water usage.
So we talked about classes and the legality of it. To your best recollection, what classes do we have right now?
I think of it in terms of rate classes, and there are three. Rate A, Rate B, which is sales for resale. Rate J, which is large users. And Rate A, which is effectively everybody else.
All right, so you would say that everyone in those classes are similarly situated within their class, correct?
I wouldn't necessarily say that. We certainly have residential customers, small commercial customers, public authority customers, all of which are in Rate A.
And with that, do you discriminate between any of those within their class?
Well, I mean, if you're asking me if I think that rate A is discriminatory on its face, I'm not prepared to answer that question, yes or no.
So you not no or yes? All right. Well, what I'm getting at is between the federal poverty level, which is tiered, are you going to be discriminating between the tiers, whether that be the 150 tier? Are you going to be discriminating between any of the tiers within each level?
Well, there will be different discounts for different tiers. I don't know that, to me, that necessarily qualify as discrimination. But there will be different discounts as proposed for different tiers.
So so your answer is that they will all be treated the same within their tiers?
Yes.
No further questions.
Any recross on behalf of public counsel?
I do not think it would be a good use of time for me to recross Mr. Ray on this issue. However, I do want to point out that a large number of the questions that have been posed to Mr. Ray by the commission and the bench and the concerns that have been expressed are items that can be directly addressed and explained by the OPC's witness, Dr. Jeff Mark, who I will make available. And I encourage you all in the strongest terms to please ask Dr. Mark the same questions that you posed, especially those that Mr. Ray suggested he was not able to answer. With that, I have no further statement. Thank you.
All right. Mr. Kaufman, on behalf of the Consumers Council of Missouri.
Thank you. Mr. Ray, I just, there were questions, let's see, I know you're not an attorney, but have you looked at the statutes that are relevant to discrimination based on class in the Missouri statute?
Specifically in Missouri?
Yes.
No.
Okay. Well, I just want to ask you then about the budget. You know, there was, Mr. Opitz talked about the 69,500 customers that may potentially qualify. Are you familiar with the numbers with the similar programs in New Jersey, Pennsylvania, and Illinois as to how many customers might qualify under the eligibility in those states and how many people actually wind up taking advantage of the program there?
Yes. The Pennsylvania program is by far the most successful in terms of participation. It's also by far the oldest.
How many years has it been in place?
Many. I don't know exactly.
More than 30?
I don't know about more than 30. Certainly more than, it's certainly more than 10.
Okay.
And participation levels in that program, I believe, are 35 to 40%, approximately. The program in New Jersey is practically brand new. The program in Illinois is a couple of years old. I don't know what the participation levels are there, but I think they're less than 10%.
Okay. So with a very mature program that's been around a long time, the penetration into the eligible customers is still only 30%, give or take.
Currently, yes.
Okay. And so for the brand new program in New Jersey, do you have a sense of how long it has taken for that program to get up and running? Like how many, do you know how many customers were in the first or second years of that program?
No, I don't think it's a year old even, but no, I don't.
Okay. But in your experience with these type of programs, wouldn't you expect it to be a trickle at first, a very small number that would ramp up over time as the program kind of got its feet under itself?
Generally, yes. We would expect it to ramp up over time. We would expect initial participation to be relatively low.
But as far as the budget, as far as what Missouri American Water Company is expecting is there would be a little over $300,000 for Dollar Energy's implementation, correct?
Yes.
So an annual cost of, do you know what the number is? 320,000 maybe? Or is it?
I'm not following the question.
What is Dollar Energy's cost per year?
The estimate that's current, that I understand is in place, is $30,000 a month, so that would be $360,000 a year.
Okay, so $360,000, and then the really difficult part of trying to determine the budget is how many of these 69,500 customers might find out about the program and follow through and be qualified.
Right, and I believe the chair has asked for an analysis of what those costs might be under different potential participation scenarios, which we can do.
Have you, and since this is based on very similar income qualifications as the LIHEAP Energy Assistance Program, are you familiar with how many people who would qualify for LIHEAP assistance actually get it nationally or in Missouri?
I don't, no.
Would you be surprised if it was in the area of 25%?
I would not be surprised.
Okay. And so when you perform your various scenarios for the commission, I assume you're going to include something in the 25-30% range as a potential number?
Sure, that's why I asked.
But would you even expect it to be that high in the first couple years of the program? Based on your experience in implementing these programs?
Well, we would, I didn't say the company is happy with participation levels anywhere it's got. And, I mean, to be sure, we have been asked in Pennsylvania to figure out ways to ramp it up. But, to answer the question, would we expect to see something north of 25% in the first year or two? I think we would be doing exceedingly well if we got to that level of participation off the bat, off the start.
And under the stipulations that have been filed thus far, there would be quarterly meetings amongst interested parties to look at the numbers and to talk about ways to promote it and to make sure that the budget is coming in, as expected, right?
Well, certainly there's a provision for quarterly meetings. And I presume that that would be a topic of interest.
And is it not true that Missouri American Water, as long as it's using the WSIRA surcharge, is going to have to come back here in at least 3 years from now, if not sooner, for another rate case?
I presume that that's true, but that's a question that you would need to ask Mr. LeGrand.
Okay. So, given that the stipulation would have all these costs put into a deferral, means that there would be no cost as a result of this case under the non-unanimous stipulation, and that whatever cost is collected over the next 1, 2, or 3 years would then be completely under this commission's control to decide what happens in the subsequent case.
Both of those things are true.
Right. And so in the sense that this is the first experience with a water program in Missouri, that amount would then be, in a sense, this interim period would be a pilot program, and the next rate case would be when the commission would be evaluating that pilot. Is that a fair assessment of the step?
You could look at it that way.
That's all I have. Thank you.
Mr. Opitz.
Hopefully briefly, Your Honor. Mr. Ray, Commissioner Mitchell, and I can't read my writing on the exact phrasing, but he asked you a question about bad debt expense and the relationship to this being a pilot program. Do you recall that line of questioning?
I do.
Do you know the amount of bad debt expense that Missouri American has included in its case this year?
I personally do not. That would be a question better asked of another Missouri American witness.
Would you disagree that it's around, in year 2023, $3.08 million?
I don't have an opinion.
Okay. To the extent that this program could be classified as a pilot with the goal of reducing bad debt, I understand that's not your view, but to the extent that that were the case, would it make sense to have a program budget that exceeds the possible savings by avoiding your budgeted bad debt expense?
Yes. It makes sense to me that the administrative costs of the program would be higher than what you would expect to save on bad debt expense, because the purpose of the program, in my opinion, is not to reduce bad debt expense. The purpose of the program is to make service affordable for as many customers as we can. To me, that's the point of the program.
So to the extent that it is characterized as a pilot, you would say that bad debt reduction is not one of the outcomes you are prioritizing with this tariff?
Well, I don't believe that the program should be categorized as a pilot program for the purpose of learning something that we otherwise don't know, because, as I said, American Water has operated these programs in other states pretty successfully. So I don't really have an opinion of what metrics ought to be included as part of the designation of this being labeled a pilot program, because I'm not sure that it, other than for regulatory or legal expediency, I don't believe that it should be a pilot program.
But, I mean, legal expediency is a pretty big consideration that a state agency should keep in mind. Would you agree?
Well, we've called this a pilot program in the stipulation. As I have said, I am not as conversant on what that means in terms of Missouri law or regulation than other witnesses who have signed on to, or other parties that have signed on to the stipulation. So I don't know that I'm in a position to answer that question.
Okay. And you're not an attorney?
I am not.
Okay. I have no further questions. Thank you.
All right. Is there any cross on behalf of MECG? All right. Redirect by the company.
Just one question. Is there a reasonable basis to charge different rates for eligible customers in each category on the tariff?
Can you ask that again?
Yes, I can. In the tariff as proposed and the program as proposed,
Do you mean that as stipulated to?
yes.
Yes.
Is there a reasonable basis to charge different rates for different customers?
Are you asking, is there a reasonable basis for different discounts for different levels of household income?
Sure.
Yes. And that generally is provided, or at least as originally proposed, provided in the analysis on page 26 of my direct testimony, where we're trying to figure out what levels of discounts would be needed at different levels of the household income to get customers basic water service down below 2% of household income. That's the basis for how we proposed the discounts originally, and that's also the basis for why we stopped the discounts at a tier of 150% of federal poverty level.
Nothing further. Thank you.
All right. Thank you, Mr. Ray. You may step down.
Thank you.
Does the company have any further witnesses on this issue?
We do not.
And does staff have any witnesses they'd like to?
Yes, Your Honor. We'd like to welcome Scott Glasgow.
All right, Mr. Glasgow has his right hand raised. I appreciate that. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Mr. Glasgow, please state your name and spell it for the court reporter.
Scott Glasgow, SCOTT, GLASGOW.
How are you employed?
I'm a senior research data analyst in the customer experience department with the Public Service Commission.
Did you prepare or cause to be prepared testimony in this matter marked as Exhibits 205?
I did.
Do you have any changes or corrections for your testimony?
I do not.
Are the answers contained in that testimony true and correct to the best of your knowledge and belief?
They are.
If I were to ask you the same questions today, would your answers be the same?
I'm so sorry. They would.
I move the admission of Exhibits 205 into evidence.
All right. Is there any objection to the admission of Exhibit 205? All right. Hearing none, 205 is admitted.
And tender the witness for cross-examination.
All right. Does the company have any cross-examination?
Now,
No questions.
All right. Public counsel,
No questions.
consumers counsel,
No questions.
MECG,
No, thank you, Your Honor.
and MIEC? Okay. Any questions from the commissioners? All right, Mr. Glasgow, you're free to go.
Your Honor, are we ready for Mr. Colton again?
According to the schedule I'm looking at, yes.
Is Mr. Colton, are you on there? He figured out how
Yes.
to turn on his camera. There he is, there he is. Okay.
All right, Mr. Colton, I placed you under oath earlier, and I'll turn it over to Mr. Kaufman.
Okay. Good afternoon, Mr. Colton. You're already sworn, and your testimony is already in the record, Exhibit 450. You have many pages on affordability and the universal affordability tariff. And so, I mean, is that not correct? Your testimony is in Exhibit 450?
It is.
Yes. And so I now offer Mr. Colton for cross-examination.
All right. Any cross by MECG?
No, thank you, Your Honor.
MIEC? Public counsel?
No, thank you.
Staff?
No, Your Honor, thank you.
Missouri American?
No questions, thank you.
Any questions from the commissioners? All right. I have no questions either. So thank you for your testimony.
So Mr. Colton is...
Thank you, Your Honor.
Mr. Colton is excused, I assume?
Yes.
Thank you.
And according to my schedule, that would lead us to Dr. Mark
Correct.
for public counsel. All right. Go ahead, Mr. Kleiser.
Dr. Mark has been sworn. His testimony has been offered. I tender the witness.
All right. Mr. Kaufman, any cross?
Yes, I think I have a couple. Mr. Mark, there has been some discussion about the fact that this is a deferral and we don't have a particular budget in this stipulation. Could you opine about what you think about the appropriate expectation of the cost of this program over, say, the first 1, 2, or 3 years of it, if it's approved?
I mean, it's a good question. It was top of mind of a lot of people when we were putting this together. So what gave me comfort in moving forward with this is that you've got other examples in other states. So, I mean, Pennsylvania, I've heard that it's a program that's been around for 30 years. So for 30 years, you're getting, at best case scenario, 40% of the eligible people have applied for that. We're not going to get anywhere near that. I mean, based off of our experience with other income eligible programs, it's going to be a challenge. Now, I'm optimistic we'll get people applied, but it's not going to approach the sort of levels that I think that are going to cause problems in a future proceeding, at least in the near future.
So, Mr. Mark, isn't there a benefit to this being treated as a deferral between now and the next rate case, such that we don't set a budget or put too much into the revenue requirement now, not knowing how many people will take advantage of it?
And that was the logic behind it. The one cost that we did have an estimate for was the administrative overhead cost. So we've got a third-party implementer out of Pennsylvania that administers the other American Water programs. And And they administer it in other states. So we cross-checked references there. We felt comfortable with that. And I'm optimistic we can actually lower those costs moving forward. I've started conversations with Department of Social Services about an app that they're exploring right now, a Steady IQ app, which would make it easier for customers it's income verification is what it is, and it makes it easier if you get SNAP or LIHEAP or any number, government subsidy programs, because that's the real challenge, is just people not having their paperwork.
I don't think that you're an attorney, are you, Mr. Mark?
I'm not.
Have you, at least, I know you've analyzed these issues from a variety of directions. Have you looked at the statute that has sometimes been called the anti-discrimination statute in Missouri?
I'm familiar with it.
Does that statute have any requirement as to what the customer classes should be for any particular utility?
No.
So it doesn't even mandate that there be a residential, commercial, small business, no rate A, B, C, D, or anything. That's all within the commission's discretion to define the classes, correct?
That's my understanding.
And the statute doesn't even prohibit all discrimination between classes, just that discrimination that is undue, correct?
Correct.
Okay. Are you aware of any court cases that have addressed whether a low-income rate is illegal in Missouri?
I'm not aware of any.
And are you aware that there is pending legislation in the state capitol right now that might put a new set of laws or rules in place with regard to low-income rates?
I am, and I am familiar with that, yes.
And so if this, the thing before us today, the universal affordability tariff, is put into place as a pilot, it would presumably, or it could possibly be, when it's evaluated, there will be new laws in place that could be addressed at that time?
Yes.
Okay. And, but just back to the issue of, how fast this program is going to ramp up. Are there any other examples that you've experienced in Missouri with new programs of this type, and how quickly they got up and running?
So, I'll give you a little history on this, and I'll try to be quick. We've explored low-income rates a couple times on Missouri American Water. Very, very, very small programs. St. Joe, in Mexico, it's effectively a discount on the customer charge. The problems with those programs were really the implementer at the end of the day was just overworked, and we did not get enough people signed up for it. So, those were pilot programs. They were technically rate design or rate tariff programs, but historically, what the commission's approved have been bill assistance programs. And I think there is a difference. The Keeping Current is probably the most obvious example of this. That's a program that's designed to go ahead and keep existing customers current on their bills. It's not meant to be indefinite. It's a 2-year program. And that's a program that's funded 50-50 by ratepayers and shareholders. This is different. This is a program where it's effectively, you're eligible. This is going to be, it's a LIHEAP program effectively, and a huge discount that's going to be moving forward. So this is new territory for us moving. And if the commission approves this, what will they get out of it? A really good, valid data point. I mean, quite frankly, moving forward. Again, reasonable minds can absolutely differ over what the thresholds should be. Again, we were comfortable with it because these were same thresholds that were offered in other states that did not, at least initially, see the uptick that would cause a huge rate shock, moving forward. So with those variables in place, the fact that we're going to be meeting on a quarterly basis and looking at this data, and there's going to be a lot of eyes on this because this is first of its kind, I do feel comfortable with it moving forward.
I have no further questions.
Mr. Bednar, do you have any cross on behalf of the city of Riverside?
I do not, Your Honor.
All right. Mr. Opitz, on behalf of MECG?
No, thank you, Your Honor.
Ms. Pleasure, on behalf of MECG? Okay. And staff?
Just one. So you've said that, there's no statute, nothing in the statute that says that discrimination or even these classes are illegal, right?
I think I understand the question.
And-
I do not believe that's the case.
All right, thank you. Now, you also heard that larger customers, like businesses, may be subsidizing this program. Do you believe that that is true?
I think at this point, it would remain to be seen. I mean, this is going to go into a deferral account at the end of the day. And I think I would caution with the word subsidy in what we're doing here. And Mr. Ray just articulated, and that really was just the whole basis of his testimony, was that this is counterintuitive, that you've got low-income customers. And if you think about it logically, think customers in an apartment, right? These are customers that are most likely going to laundromats to go ahead, and they're paying extra for water use for this. They're not watering lawns. They don't have pools. That's effectively the group you're talking about. And what Mr. Ray's analysis, in its generalizing, there's going to be examples where customers are going to fall out one way or the other. But on a whole, that subset of customers, you could make an argument, are actively subsidizing other customers that have much higher use during, in particular in the summer.
Thank you. And to follow that up, let's say that there is a risk to these customers or these business classes. What do you think that risk is with regard to the universal affordability tariff?
At this stage, very, very low. Just because, again, I don't think we're going to get the numbers that, I understand where Mr. Opitz is talking about, but the 69,000 customers, and we're roughly 500,000 customers in total, but we're not going to get 69,000 customers in the 2 years that we're talking about. And even then, there's all sorts of additional questions to ask. So this is not a black and white issue.
No further questions. Thank you, Dr. Mark.
All right. Any cross on behalf of the company?
No, thank you.
Do the commissioners have questions?
I do, Judge.
All right, Commissioner Mitchell.
And this is a question I asked Mr. Ray, and he deferred to you. But so, do we have any other pilot programs in the state that have been approved by the commission that don't have a time limit or don't have a budget limit, don't have any limiting factor or performance metrics attached to them?
It's a great question. I would say since I've been here, all of the low-income programs have been couched as pilot programs. I would characterize it as out of an abundance of caution. And parties have effectively been okay with that. And we've taken that opportunity to learn from those programs and adjust them accordingly. As far as the budget is concerned, the closest example of that would be past Missouri American Water cases, which were much, 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 much smaller in scope. So this is sort of a first in that area. I will say we do have annual budgets for other programs, and in those cases, we almost always over budget. We plan for over budgeting because we never want to be in a position where we're actually, we've hit that mark and we're turning customers down during, the holidays or whatnot. So there's usually a rollover function that takes place. And I don't believe I know the third part of that question. Oh, time limits. They're examined periodically is the short answer. And in any given rate case, parties are free to go ahead and adjust the programs, discontinue. We've discontinued programs. We've reevaluated them entirely. That I think is going to be on the table for this one as well.
Be fair to say that for this instance, there's not a budget or time limit established in the language.
There isn't in the language, but yeah, I would say we will absolutely be evaluating it and judging it on the quarterly calls. Clearly in the next rate case, that's going to be a topical issue. And we do have metrics that we can point to. And the easiest example, you've already identified one in terms of arrearages, but disconnections, is the other obvious one. We know from the data docket that the commission, the rulemaking process, and the commission staff just finished up a report here a month ago that looked at those annual numbers across utilities. American Water, their discontinuance in any given month was a low end of 176 customers to a high end of 2,155 customers. So that would be one area that we could look at. Again, it's not a lot of sample at that point, but this is a start, and there's going to be some sense making with it.
Do you think this tariff could inadvertently create disincentives for low-income customers to perhaps have to choose between an incremental advance in their pay, or taking a different job that paid better, or moving out of a poverty classification for fear of losing the discount?
That is a really good question, and I think that's one that will always persist with any sort of income eligible program. As a whole, no. I don't think that'll be the case. But you need to look at it in its totality. I think what you can say, and I think what there is a lot of fear among low-income advocates right now, is that a lot of existing subsidies to keep them afloat are drying up in other cases. So, for example, post-COVID, the federal government had what they call LIWOP. It was a low-income LIHEAP program that provided a subsidy, and that's no longer in service. There's other examples like that, but clearly there's going to be, if we hit an inflationary period that continues, or becomes more exasperated, or there's a further downturn with the economy, this program should help.
Thank you, Dr. Mark. That's all the questions I have.
Chair Hahn.
Just one. Keeping current does have shareholder dollars attached. But in this, there's no shareholder dollars attached. Talk me through that rationale.
It's a great question. I think context is important. It's different in its design. So, there's a bill assistance program that usually has further details that I think differentiate it from just a straight income-based discount, right? They're seniors, for example. They're, customers that need, keeping current is also half keeping current and keeping cool. So that would be an example of that. Or there's a time limit for keeping current, it's 2 years. This doesn't have that. We didn't know exactly what the magnitude of the cost would be. And I'll put it this way. I think because we're deferring the dollars into a future rate case, parties are free to argue whatever they want at that point.
Understood. Thank you.
Yes, Commissioner Colquitt.
Thank you. Good afternoon, Dr. Mark. Are there any other water companies in Missouri that offer subsidies to low income, or discounts, or one class is subsidizing another class?
American Water is by far the biggest water utility in the state. So every other smaller water utility, Confluence comes close. There are no low income, and I don't think there are any economic development subsidies on the commercial side for those other customers. But American Water does have that. Triumph Food's an example of that, of somebody that is being subsidized by other customers.
LIHEAP, that's, you're eligible, I mean, water is an eligible utility, correct?
No,
No?
no,
Okay.
yeah. So they had a program for about 2 years post-COVID that was LIHEAP, but that's been discontinued.
But my recollection of LIHEAP, a consumer gets so much money and they decide whether it's going to go to electric
Right.
or gas or what utility they need it to go to.
That's correct.
Yeah.
That's
Thank
correct.
you.
All right, Mr. Kaufman, do you have any questions?
No, Your Honor.
All right. Mr. Bednar, any recross?
No, Your Honor.
Mr. Opitz? Ms. Plasha? Mr. Vandergriff?
No, Your Honor.
And Ms. Niemeyer?
No, Your Honor.
Very, very quick redirect.
Yes.
Yep, sorry. For the sake of the record, there was mention of LIHEAP. That was the Low Income Home Energy Assistance Program, correct?
Yes.
And just to make sure this is clear, can LIHEAP dollars be applied towards a water bill?
No.
Okay, they are only applicable towards gas and electric.
Yes.
And again, for the sake of the record, LIWAP would be Low Income Water Assistance Program?
It is. The LIWAP also has another connotation on the electric side, but for the record, for 2 years, there was a low-income assistance program called LIWAP. And it's just the W indicating water.
All right, thank you. That was it.
All right. Thank you, Dr. Mark.
Thank you.
Unless there's an objection, I think it'd be appropriate to take a break here. So let's go off the record and reconvene about 10 after 4. All right, let's go back on the record. We are ready to move on to the issue of revenues, is that correct? Okay. Are there many opening statements on this topic, this issue? Okay. Then, with the company? Okay, Mr. Kyle.
In the interest of getting the witnesses quickly. The real issue on revenues that's in debate is whether or not we will use the company's linear regression analysis to forecast future residential, commercial, and OPA usage. The company is the only party who submitted a linear regression analysis, and that analysis unquestionably demonstrates a long downward trend in usage per customer. The only way the other parties can attack that analysis is to truncate it and look at less data points. They have instead used a 5-year or a 3-year simple average to project usage. Those averages completely ignore that downward long-term trend in usage per customer. Water's no different than other utilities. They typically use linear regression to forecast their usage. It should be the same here. Thank you. And I'm happy to answer questions if you have.
Are there any questions? All right, thank you. Mr. Vandergrift? Oh, I'm sorry. Ms. Johnson, for staff.
Thank you, Judge. We're playing a little musical chairs here to make sure that everyone's with their appropriate witness, so I appreciate your flexibility. I'll be brief also. Again, reminder, Tracy Johnson from Staff Counsel's Office. May it please the Commission. So I'm here to give a statement on issue number 28, which is revenues. The main difference on the issue of revenues involves what's actually known and measurable versus projections and assumptions. What's known and measurable is reasonable. Pushing for discrete adjustments and the inclusion of data beyond the true-up period in this case is unreasonable and excessive. Staff opposes discrete adjustments as a general policy, and you'll hear from staff witness Kimberlin tomorrow during the presentation of witnesses on regulatory policy. The reconciliation difference between staff and the company in this case is $1.8 million across all revenues. Staff expects that difference is going to increase during true-up to approximately $2.5 million. If, as the company suggests, we utilize customer growth, rely on projections, and make assumptions, pushing the data beyond the true-up period out to May of 2025 to include future data, the difference jumps to $12 million. Staff's reasonable approach for calculating usage is based on current tariffs, currently ordered test year. Staff's approach involves analyzing 5 years of data to identify trends. If the data indicates that there is a flux in the trend from year to year, meaning that no trend is identified at all, then a 5-year average of the data is used. If there is an identifiable trend, up or down, then only the last 12 months of data is used because it's the most indicative given the trend. Relying on 5 years of data allows for inclusion of an appropriate amount of data points without allowing outdated or old numbers from too far past. 5 years sheds light and provides more accuracy, especially whenever staff takes into consideration the adjustments that were made according to the trends. This is reasonable. Utilizing known data and measurable trends with the currently in place tariffs is reasonable. The bottom line is, if you calculate revenues based on the numbers suggested by the company, the customer number, or the metered units, however you want to talk about it, will be based on speculative projections, and it will artificially drive revenues down to the benefit of the company and the detriment of the ratepayers. Ashley Sarver is staff's witness on this issue, along with Jared Robertson. They've put together customer usage data for you, and there's detailed specifics on residential usage that would be best addressed by Mr. Robertson. Missouri American's witness, McAllen, acknowledged on page 18, line 10 of his second round of testimony, specifically, that Ms. Sarver's methodologies in calculating usage and customer numbers in this case are generally consistent with the methodologies used by the company. The main difference between staff and Missouri American is the amount and time frame of the data. Working the numbers to get the most beneficial output is not reasonable. In this case, it's excessive. Relying on staff's approach is reasonable. Thank you.
Any questions from the commissioners? All right. Hearing none. Thank you. Mr. Kaufman?
No opening.
Okay. Opening statement by any of the other interveners? All right. All right. For the public counsel, Mr. Kleiser.
All right, I know it's getting late, so I'm not going to go through this bit by bit. I'm going to try and speed things up a little bit here to keep it slow going. Really quick, this just high-level talk, really second. Billing determinants, how does this work? Okay, what happens in a case? You guys are going to come up with a revenue requirement. That's the total dollar amount that you have to set in the case. Then you're going to divide that revenue requirement up among the classes, right? So let's say you had $500 million total pot. You give $300 million to Class A, $150 to Class B, $50 to Class C. Once you've put it in a class, you then have to divide it up among the number of customers in the class. That gives you the cost per customer. And then you're going to take that, you're going to say how much of that is going to be the customer charge and how much is the volumetric charge. And then when you finally know how much you want as the volumetric charge, you divide that by the billing determinants to give you the actual rate. So what's at issue here is figuring out what that billing determinant is, and that's based on the normalized usage. And all we're trying to do is figure out what the volumetric rate should be by making sure we have an accurate normalized usage. And just the word normalization, all that means is that we take out weird parts. You know, if there's a spike or a drip or whatever, we just want it to be something that represents what's the actual normal occurrence. And it's really important to understand that this issue doesn't or shouldn't affect the revenue requirement. And what that means is that the company isn't supposed to get more or less money depending on how this works. However, you have to make sure the number is accurate, because if you get it wrong, the company will collect more or less money than they're supposed to. Because you're dividing the volumetric, because you're dividing the amount per customer by the billing determinant, if you put that number too high, then the volumetric rate will become too low and the company will collect too little money. If, on the other hand, you put the volumetric rate too low, I got that right? If you put the volumetric, if you put the billing determinant too low, the volumetric rate becomes too high, and the customer company collects too much money. So again, the real key that I want to stress to you is, this is not some big policy issue. This is not like, hey, should the company collect for paying incentive compensation, or how much profit should they make? Your goal is really simple. You just want an accurate number. We all just want the most accurate possible number we can for that billing determinants, because otherwise the company will either over or under collect. That's all that's at stake here. Okay, so what is the problem? Why is there a dispute? You already heard it from staff counsel. Missouri American Water wants to predict rates through May 31st of 2025. But more importantly, they're predicting that the usage will go down. And that's going to result in a lower normalized residential usage, and because that's what you're dividing by, that results in a higher volumetric rate, which means that if the company gets it wrong, the volumetric rate will be too high and the company will over-earn. So why does the OPC have an issue with this? What is our position? We believe that the residential usage is not actually declining at this point in time. And that means that, again, if we use what the company is predicting, rates will be set too high and the company will over-earn. All you have to do to understand this, all you need to look at, is the company's current trend for water usage. This graph is the case for the OPC. And what this graph is, it's the last 5 years of usage. And what you can see, we have the line numbers on there, and this, by the way, it's in the supplemental testimony of Ms. Mansell. If you remember back from high school algebra, y mx plus b, m is your slope function, it's positive. These are not declining. these numbers are holding steady. I mean, you should be able to look at that visually and say, these are fairly steady numbers. And that's what the staff relied on. They looked at the last 5 years and said, you know, that's what they based their numbers off of. What the company did, which is what you kind of heard of, is they used 10 years. And if you go back 10 years, yes, the numbers are starting to actually decline at that point. However, that is not a good usage. We should not be using 10 years. And the simple reason for that is, first of all, 2014 through 2018 is not a good representation of what's happening here in 2023. All right? We want to use the most recent data possible. Second, it's no longer evident that we have a decrease. Yes, it might have been decreasing from 2014 to 2018, but the last 5 years have been steady. We don't need to go back further when the last 5 years are steady, because that's a good indication that we're going to have steady movement moving forward. And finally, I just want to point out, if you accept this whole linear regression analysis, what that basically means is you're accepting that water usage is going to be constantly declining. But you should know there's obviously a point where you have to stop declining. Like, you can't have a constant decline down to zero. People still have to drink, wash, bathe. People are still going to use water at some level. So even if you accepted a decline at some point, you would expect that decline would level off too. And again, that reinforces what we've seen. In the last 5 years, we've had a steady, flat rate. So the only difference between the staff and the OPC, staff used 5 years, the OPC actually said to use 3 years. You can ask Ms. Mantle for the kind of justifications behind that. We felt that it would help to avoid the complications presented by the COVID. We thought maybe that was an impact there, so we just looked at 3. However, even if you use R3 instead of 5, the difference is only about $600,000, which when you compare that to the $10 million that you just heard from staff is the difference between their case and the company, you can kind of see that it's not really that big a difference. And again, that just reinforces the point. These last 5 years, we've had very flat, steady rates. We don't need to be predicting that customers are suddenly going to be using a whole lot less than they've been using over the last 5 years of steady rates. All right, I think I ran through that. Like I said, I was moving quick. I'm trying to get through to the witnesses, so I'll pause there if you have any questions.
Any questions from the commissioners? All right. Thank you, Mr. Kleiser. The company can call their first witness.
Petitioner recalls Mr. McClellan.
Okay. And Mr. McClellan, I'm going to say you're probably going to have to adjust that microphone.
Okay.
All right. Go ahead, Mr. Kyle.
Your Honor, his testimony is already in the record, and he's already been sworn, so he is available for cross-examination.
Okay. Mr. Vandergriff, any cross?
Yes, Your Honor. Good morning, Mr. McClellan.
Good afternoon.
Good afternoon. Would you agree that accurate water usage projections are critical for setting proper billing rates?
Yes.
You used a regression analysis as opposed to normalization, correct?
Regression analysis I consider to be a form of normalization. The way we utilized it, yes.
You utilized the 10-year linear regression analysis versus staff's 5-year averaging method, correct?
That is correct.
The regression analysis uses statistics, correct?
Yes.
Is it factually accurate to state that regression models rely on assumptions about the relationship between independent variables, and in this matter, water usage?
Yes. Water usage per customer.
Would you agree that statistical significance does not always guarantee an accurate representation of real-world conditions?
Could you repeat that?
Would you agree that statistical significance does not always guarantee an accurate representation of real-world conditions?
I don't think that I agree with that. Statistical significance, I think within its definition, does kind of account for the possibility of something not being true, though.
Would you agree that if any assumptions are incorrect, the reliability of the regression model would be compromised?
Yes.
Is it correct that your weather adjustment relies on calendar month data?
The weather data used in the regression analysis utilizes calendar weather data. However, it's weighted. I'll let you proceed with your next question.
Would you agree that water usage is recorded based on billing cycles rather than strict calendar months?
Yes.
Is it true that your regression analysis uses data from as early as 2014?
Yes.
Would you agree that water usage patterns observed from 2014 through 2018 may differ from those observed in the most recent years?
Yes, that's true, and for that reason, we weather normalize all the data.
No further questions. Thank you.
Any cross on behalf of public counsel?
No, thank you.
CCM?
No questions.
MECG?
No, thank you, Your Honor.
MIEC? All right. Any questions from the commissioners? All right. I don't have any questions myself. Redirect.
Just one, Your Honor. Mr. McClellan, you were asked by staff counsel a question about weather and monthly data, and you answered that question, and you ended it with, however, it's weighted, and then you finished it by saying, I'll let you ask your next question. What were you getting at with that, however, it's weighted?
Yes, so we have calendar weather data, and billed sales and bill cycles they cross over several calendar months. So for that reason, the company weights its weather data from one month to the next in cognizance that a month of billed sales carries over several calendar months.
Does that process of weighting deal with this issue that you're describing about a billing cycle carrying over more than 1 month?
Yes, I think it certainly accommodates that.
No further questions, Your Honor.
All right. Excuse me. Thank you, Mr. McClellan.
Thank you.
Does the company have any further witnesses on this issue?
We do not, Your Honor.
Okay. Staff, call your first witness.
We have Mr. Jared Robinson.
All right, Mr. Robertson, you have your right hand raised. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you.
Good afternoon. Please state your name and spell it for the court reporter.
Jared Robertson, that's JARRODROBERTSON.
How are you employed?
I'm with Missouri Public Service Commission in the Water, Sewer, Gas, and Steam Department as a Senior Research Data Analyst.
Did you prepare or cause to be prepared testimony in this matter marked as Exhibits 211?
Yes.
Do you have any changes or corrections to that testimony?
No.
Are the answers contained in the testimony true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
I move for the admission of Exhibits 211 into evidence.
All right. Mr. Vandergriff, let me ask you this, though. Are you moving at this time also for his cross rebuttal and sur rebuttal?
Yes, Your Honor.
Exhibit 224.
We're moving into all of his testimony, sir rebuttal and his cross rebuttal.
Okay. Would you like to ask him the foundational questions for 224?
For exhibits 224, excuse me for missing that one. Do you have any changes or corrections to that testimony?
No.
And are the answers contained in that testimony true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Your Honor, I move into evidence exhibits 224.
All right. Is there any objection to the admission of Exhibit 211 and 224? All right. Hearing none, those exhibits are admitted.
I tender the witness for cross-examination.
All right. Any cross by the company? All right. Public counsel.
Good evening, Mr. Robertson.
Evening.
I'm looking at your schedule JJR-D1, your curriculum vitae, effectively, the cases that you've participated in. According to this, I see at least 4 cases that describe you having the issue of normalized usage. Is that accurate?
Yes.
And those are 3 Missouri American Water cases and 1 Liberty Water Company case. Is that accurate?
Those 4, and then this is the 5th.
And this would be the 5th. Have you employed the same methodology in all 5 of these cases then with regard to normalized usage?
Yes.
That's the 5-year average for the sake of the record?
That's correct.
Would you agree with me that Missouri American Water's water usage over the last 5 years has maintained a relatively steady rate for residential customers?
A steady rate or volume?
Steady rate of usage.
No.
Has it increased or decreased dramatically?
Did you ask me over the last 5 years? My apologies.
Yes, last 5 years.
I've decreased.
The water usage has
On a per customer basis?
Yes.
Or overall? On a per customer basis, we have seen a decline in usage.
One second, Your Honor. Apologies. It's right here. Can you turn to, I'm sorry, can you turn to page 14 of your direct rebuttal testimony?
That was direct rebuttal?
Direct rebuttal, yes.
Yes, I'm there.
You would agree with me that the number labeled next to 2023 is higher than the number labeled next to 2019?
That the number next to 2023 is higher than the 2019 volume?
Under per day, you would agree with me next to 2023, it says 207.0702,
Correct.
and next to 2019, it says 197.9667.
Correct.
And then on 2022, it's 206.2013.
That is correct.
And 2021, it's 200.9525.
We're focusing on D1 only?
D1 only.
That is correct.
And those tables represent the those tables represent the residential customer usage on a per day basis.
Those are the normalized usage levels, yes.
So the normalized tariff usage level is increasing from 2019 to 2023.
There was an increase from 2019 to 2023.
And the information provided in D2 had to be updated as part of your cross-rubber, correct?
That is correct.
Yes. And the information had to be updated as part of the cross-rebuttal testimony. And if you turn to page 4 of your cross-rebuttal testimony,
I'm there.
we'll see effectively the same table. Or rather, I should say, a table detailing the same information. Let me put it that way. Is that correct?
That is correct.
And that would be the residential customer usage on a gallon per day basis.
Yes.
And again, for District 2, from 2019, it starts at 144, and it increases to 154 as of 2023.
Correct.
Thank you. Now I have no further questions.
Mr. Kaufman, any cross?
No questions.
Mr. Opitz? No, thank you, Your Honor. Ms. Plesha? Okay. Any commissioner questions?
Just one, just so I'm clear. Usage is increasing, decreasing, or about the same?
What we're observing here is simply a snapshot of customer usage on a per day basis for each year. In order to get a 5-year average, we have to include the data from 2018 to get the 5 data points, and that would be the driver for the overall decline.
Thank you.
All right. Mr. Robertson, could I direct you to your direct and rebuttal testimony, page 9?
I'm there.
There is a question asked of you, why does staff believe June 2020 is a more appropriate removal date for the COVID-19 variable? And your answer, and I'm going to paraphrase, is that any COVID-19 variable should be limited in Missouri Americans regression analysis. Is that fair to say?
Could you rephrase that question, please?
Well, the question asked of you was, why do you believe June 2020 is a more appropriate removal date for the COVID-19 variable? And you say, I believe, more or less, that any COVID-19 variable should be limited in Missouri Americans regression analysis. Would any residential increase in water consumption during the COVID-19 period be offset to some extent by reduced business and commercial water consumption?
There are 2 characteristics to this that we're looking at: time as well as the impact of COVID being placed at 100% over that amount of time by Missouri American Water. That basically would appear that assumptions are being made that all customers, households, reacted to the pandemic and or regulatory aspects in the same manner. It makes assumptions that each household had children in the home had children in school that had to stay at home at that time, or that customers in a home had jobs that allowed them to work at home at that point in time. There's been no evidence to support that across the board, 100% for each and every customer of Missouri American Water.
Okay. All right. Is there recross by the company?
No, Your Honor.
All right. How about from public counsel? The other interveners? Yes, Mr. Kaufman.
Okay.
All right. Okay. Mr. Vandegrift, redirect.
No, Your Honor.
All right. Mr. Robertson, thank you for your testimony.
Thank you. Appreciate it.
All right, and it looks like Ms. Sarver is retaking the stand, and Ms. Johnson will handle the direct.
Thanks again for your patience with our musical chairs. Ms. Sarver has already been sworn and her testimony's already been admitted, so we tender her again.
All right, does company have cross?
No, Your Honor.
Public counsel? Consumers Council of Missouri.
No questions, Your Honor.
MECG? MIEC? Okay. Any questions from the commissioners? I hear none. All right, maybe, well, I do have a couple of questions. Mr. Robertson, in his direct and rebuttal testimony, stated that staff reviewed Missouri American water usage for the most recent 5 years and used an average for purposes of its revenue analysis. You also used a 5-year average in determining the chemical, fuel, and power costs to be included in Missouri American's cost of service. Is that correct?
We looked at 5 years, yes.
Okay. But for those expense items?
Yes.
Okay. When applying the matching principle, would it be important to use the same methodology in determining revenues with customer water consumption and the chemical, fuel, and power costs?
No, not necessarily.
Okay. Why not?
They're two separate. Like, whenever we look at these expenses and stuff, we pick an average, or we pick like 5 years to review, but it doesn't have to necessarily be the same for the revenue side.
I see. Okay. Okay, I don't have any further questions. Any recross from the company?
No, thank you, Your Honor.
Public counsel? No. Any of the other interveners?
No, Your Honor.
All right. Thank you, Mr. Kaufman. Any redirect?
No, thank you, Judge.
All right. Thank you, Ms. Sarver. Any further staff witnesses on this issue?
No, Judge, just the two.
Okay. All right. And it looks like Ms. Mantle is retaking the stand on behalf of public counsel. So, Mr. Kleiser, go ahead.
Ms. Mansell's testimony has already been entered into the record, and she is still sworn, so I tender the witness.
All right. Mr. Kaufman, do you have any cross-examination for Ms. Mantle?
Yes. I'm trying to understand some of the questioning that just occurred with the staff witness regarding the most recent 5-year usage numbers. Could you explain me what your perspective is on the most recent 5 years and whether you agree with staff on their analysis?
I too was very confused with Mr. Robertson's testimony. I start with the real data, not an average, not a difference between the years, and look at that, and we all saw that in the graphs in my counsel's opening. But then when you look at the numbers that were in Mr. Robertson's testimony that Mr. Kleiser pointed Mr. Robertson to, it's very obvious that usage has increased since 2018, I think was its earliest, 2019, both in Division 1 and Division 2. In Division 1, by the way, that's the St. Louis, and Division 2 is non-St. Louis. He has a table where he shows that it's declining. I had to ask for work papers for that table. And if I remember correctly, he took differences between years, whether it was an increase or decrease, and then averaged those to come up with a number that said it was declining, but that makes no sense. That makes absolutely no sense when the numbers are actually increasing.
So in other words, your math from 2018 to the most recent, what is the most recent date that we have?
2019 through 2023.
So from 2019 to the end of 2023, you think that the math clearly shows an increasing amount of usage from those two data points?
Yes.
Okay. And that and you're telling me that the staff analysis, you think, distorted that by looking at the changes from one year to another within that 5-year period?
Yes.
Okay.
That's my recollection. It's really, it has to do too with his table on page 2 of his cross rebuttal that I could not understand, and again, had to look at the work papers to try to understand.
But again, there's no doubt about the math from 2018 to 2023. It's an increase usage overall.
It's numbers that
Increase,
even my grandson, who's in first grade, could tell you that those are increasing numbers.
And that's in your testimony?
Well, not about my grandson,
No.
but yes.
So if the commission wanted to find those raw numbers, where would they look?
Mr. Robertson has them in his testimony.
But you, in other words, your recommendation is look at the actual numbers for that 5-year period instead of doing some calculation within that 5-year period.
There's no need to do any kind of calculation. You can just look at the data, which every analyst should start with looking at the data.
Okay. Thank you. That's all I have.
Mr. Opitz, any cross? Ms. Plesha? All right. I'm sorry. Ms. Johnson?
I do have just a few follow-ups. Good afternoon, Ms. Mantle.
Good afternoon.
So were you here in the room? I think you were, for my opening on this issue, followed by Mr. Kleiser.
Yes.
And to me, it sounded like staff and OPC were on the same page, but for one thing, which was the number of years, right? So staff looked at 5, and it sounded to me like you looked at 3. Is that correct?
That is correct. We use the same data. I used 3 years, and Mr. Robertson used 5.
So is it fair to say that your issue with Mr. Robertson's testimony is his representation of the same data that you used, and that you don't agree with how it's presented, but the overall outcome would be the same for staff and OPC's position?
I don't agree with him that the usage is declining. The numbers are what the numbers are. We use the same numbers, and the 3-year average was so close to the 5-year average, which just demonstrates how flat the usage has been over those 5 years. So I agree that an average is a good way because the usage is flat. There's no need to do any fancy analysis. And we use the same data, and we came up with almost the same numbers.
Understood, thank you. Can you contrast that for me with the linear regression modeling that's been suggested by the company?
The linear regression model goes back using data back to 2014. And as the graph in the opening presentation showed, from 2014 through 2018, there was a decline, and then it flattened out. And a regression model fits a line through the data that's given. It can't look at it and say, oh, well, here it's turning and going flat. You put it in the model and it spits something out. And because it was declining and then going flat, that regression model would show that it's declining still, because the number that it started with in 2014 is higher than it was the last 5 years. Regression models, statistics just spit out an answer. It takes an analyst to look at it and see if the results really do fit the data that you have. And so when he's doing a prediction and he's using 2014, he's predicting that that will continue regardless of what's happened in the last 5 years.
Whenever you say he, you're talking about Mr. Max McClellan for the company, right?
Yes, the one that conducted the regression analysis.
Thank you for clarifying, that's all.
Any cross on behalf of Missouri American?
No, thank you, Your Honor.
Are there any questions from the commissioners? Hearing none, I also have no questions. Any redirect?
Very briefly. So obviously there was a conversation and a bit of a dispute on whether there's an increase or decrease. You obviously have taken the position that there's an increase, correct?
Correct.
But just for the sake of clarity, the OPC is not recommending that that increase be projected forward until May 31st, 2025, correct?
No.
And
No.
staff is also not making that.
No, staff is not projecting. Staff is using a normalized number.
And this is contrary to what the company is doing, correct?
Yes, they predicted what would happen.
All right, thank you. That was my redirect. Thank you, Your Honor.
Thank you, Ms. Mantle. You may step down. So are we moving on to production cost tracker or cash working capital? Mr. Cooper.
Well, and maybe there's a third option. I would like to put Mr. Walker on to admit his testimony and to stand cross-examination to the extent there is any on cash working capital. I don't necessarily need to do openings at this time or complete that whole issue. I'm happy to come back to it at a future time.
How about if we put Mr. Walker on the stand and then when we come back to that issue, if there are opening statements, if the parties would like to present opening statements, we can do it at that time.
That's good. We would call Mr. Harold Walker then in that case.
Mr. Walker, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Please state your name.
Harold Walker III.
By whom are you employed and in what capacity?
Gannett Fleming Valuation and Rate Consultants, LLC. I'm employed as a manager of financial studies.
And you're appearing today on behalf of Missouri American Water Company?
That is correct.
Have you caused to be prepared for the purposes of this proceeding certain direct testimony and rebuttal testimony in question and answer form?
Yes, I have.
Is it your understanding that that testimony has been marked as Exhibits 28 and 29 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
I do not.
If I were to ask you the questions which are contained in Exhibits 28 and 29 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would offer Exhibits 28 and 29 into evidence and tender Mr. Walker for cross-examination.
Is there any objection to the admission of those documents? All right. Exhibits 28 and 29 are admitted. All right, Mr. Johnson, cross on behalf of staff.
No questions, Judge.
All right. Mr. Kleiser, any cross? Mhm. We are up to 320 would be the next exhibit.
No cross at this time.
Mr. Kaufman, any cross?
No cross, thank you.
Any cross on behalf of MECG? Any cross on behalf of MIEC? Any questions from the commissioners? All right. Hearing none. Mr. Walker, I do have a couple of questions myself. Let me see if I can find this. I'll direct you to your rebuttal, Sir rebuttal, and Sir rebuttal testimony, page 5.
I have it.
Okay. On line 6, the question is asked of you, does the company have complete control of the billing lag? And your answer says no. For example, as to Arnold Sewer customers, the company must rely on the water districts that provide water service to the Arnold Sewer customers for water use data. As a result, no Arnold Sewer customer has a billing lag that is less than 18 days. With that in mind, I want to direct you to your direct testimony, Schedule HW2.
I have it.
All right. And you're ahead of me on that, but on that schedule, I believe it says on the first page that it lists a billing lag for Arnold Sewer as 5.5 days.
Yes.
So how do you,
The billing lag was calculated on a total company basis, 5.5 days, and that was used for all the groupings of companies. So everything was done on a consolidated basis.
are you saying across all of Missouri Waterworks companies,
Yes,
subsidiaries?
yes.
Okay.
But and that's because some of the data in the revenue lag itself is not available for individual companies. But I looked at the actual invoices and was able to see those in Arnold, where they fell within that parameter, to know that the smallest number was 18 days.
I'll direct you back to page 5 of the rebuttal testimony.
Yes, I have it.
So back in your answer to that question about the billing lag, you go on to say, additionally, although the majority of Missouri American Water Company's customers have billing lags of less than 3 days, some customer bills require extra scrutiny, which delays the billing process for those affected. Do you know how many customer bills require that extra scrutiny each month?
I do not.
Okay. Can you explain why, if the majority of Missouri American customers have a billing lag of less than 3 days, why your direct testimony schedule, MW2, shows every group of customers having a 5.5 billing lag, 5.5 day billing lag?
Because it's weighted based upon the total bill. So when I make the statement that the majority of customers, I'm looking at individual invoices, and I can see that the majority of those are less than 3 days. However, on a weighted basis, when you take the actual lag and you multiply it by the revenue dollar for that particular customer, and then you sum it up for all 550,000 customers on a weighted basis, you develop the 5.5 days. So it's a weighted average, the 5.5 days.
Okay. And you actually have that in your testimony, it looks like. The very next sentence, the company's billing lag is properly determined and reflects the weighted average of the billing lag days for all 500,532 customer invoices reviewed.
Yes, I just misspoke. I was recalling that it was 550. You are correct. It's 500,532.
Okay. All right, those are my only questions, so I will open it up to recross. Mr. Johnson.
No questions, Judge.
Okay. Mr. Kleiser?
No recross, Your Honor. Thank you.
Any recross by any other party? Okay. Mr. Cooper, do you have redirect?
I do not. Thank you, Your Honor.
All right, Mr. Walker, thank you so much for your testimony.
Thank you.
All right, so my understanding is we are now going to switch to production cost tracker. Is that correct? Okay.
Your Honor, before we leave that, may Mr. Walker be excused?
Yes, as far as I'm concerned, if there's no objection. Okay. All right. The company may call their first witness on the issue of production cost tracker. Oh, that's right. Sorry. You do, you do, Mr. Kleiser, have a tendency to keep me in line. So, Mr. Cooper, you will present your opening, the opening for the company?
I will, Your Honor. Missouri American's rate-making proposals in this case are designed to at least partially address constraints with the existing rate-making structure. Among other things, Missouri American is requesting that if the commission does not approve an RSM that includes a production cost tracker, it separately approve a tracker mechanism for production costs. And that's what we're trying here at this point in time. These production costs roughly make up 23% of the company's expenses. The tracker would allow any difference in production costs incurred and production costs and customer rates to be deferred to a regulatory that differ from production costs and customer rates to be deferred to a regulatory asset or liability. The relevant costs are related to things like the cost of electricity at water treatment plants, the costs of chemicals to treat and clean water before it is delivered to customers, sludge removal costs at wastewater lagoons, and water purchased from neighboring communities to supplement production capacity. Similar to the company's pension and OPEB trackers that have been in place for over 15 years, the production cost tracker consists of costs that are outside the company's control and are volatile in the case of chemical prices and volumes of water purchased. These production costs are among the most critical costs incurred because they are essential for providing safe, clean drinking water to Missouri American's customers and their families, and is not a discretionary expense the company can choose to incur or not incur. Missouri American's proposed tracker would allow recovery to be addressed in a future rate case, and if inclusion of the regulatory asset or liability in rates was approved, would ensure that customers only pay for the expenses incurred, nothing more and nothing less, while allowing the company to collect the revenues associated with a portion of the company's expenses experiencing volatility. And that's all I have at this time, Your Honor.
All right. Are there any questions by the commissioners? All right. Thank you, Mr. Cooper. Mr. Graham, it's good to see you.
Good to see you, Judge.
Presenting on behalf of the staff.
Yes, thank you, Paul Graham. I'm going to try to keep this brief, and that's actually a promise. And I'm going to try to do no harm, and I'm going to try to do good. In my effort to do no harm, I'm going to not try to argue facts. The facts are very granular in this case. There's going to be a lot of dispute back and forth among the witnesses on what constitutes extraordinary type expenses. What I'd like to bring to the table and do good with is a legal perspective. What I don't often hear in cases, but I do hear it from good judges, I do hear it from good lawyers, I do hear it from good law professors, is a question. What is the rule of decision in this case? What rule should you apply in deciding whether or not to grant this request for a production cost tracker? I submit that the burden of proof and persuasion is on the company. Let's unpack that. That means the staff does not have to prove or persuade you that the application or following the usual procedures of setting rates and packing the numbers that are in question into general rate-making procedures will result in fair and just rates. That's already the law. The burden of proof is on the company to show that the application of the ordinary procedures is more likely than not to result in unjust and unreasonable rates. So let's formulate that now as a rule of decision. The commission should reject the request for the production cost tracker if the company fails to sustain its burden of proof to show that not including those, not implementing a tracker will cause it to, will result in unjust and unreasonable rates. That's the rule of decision here. That concludes my statement. Any questions?
It appears not. Thank you. Mr. Kaufman, would you like to make an opening?
No, Your Honor.
Mr. Opitz? Ms. Plesha?
Yes, I would like to. May it please the commission. I agree with everything that Mr. Graham said, but I have a different perspective. Because the primary reason for the commission to not approve a production cost tracker is that it is unlawful. And I will simply cite the Missouri Supreme Court's decision in Utilities Consumer Counsel versus Public Service Commission. And the commission's, the court's opinion in the case provides policy reasons why it is inappropriate to allow trackers or any type of rate increase mechanism that does not consider all relevant factors. And I would like to just read a few paragraphs from that decision, which I think is very persuasive, and it's rooted in the Constitution, the Missouri Constitution itself. Although no hearing by the commission is required before a new rate goes into effect under the file and suspend method, the commission is nonetheless required in determining whether or not to suspend the proposed rate to consider all factors relevant to the proper maximum. However difficult may be the ascertainment of relative and material factors in the establishment of just and reasonable rates, neither impulse nor expediency can be substituted for the requirement that such rates must be authorized by law and supported by competent and substantial evidence upon the whole record. Citing the Missouri Constitution, Article 5, Section 22. The importance of this is that the commission was never instituted to simply take certain costs and allow those to increase without considering countervailing costs. And by using trackers, the entire jurisdiction of the commission is called into question. And the basic constraint that the commission by law is required to consider all factors and not just one to the exclusion of others is the key to the powers of the commission. There are other policy reasons why it's a bad idea, even if it were to be lawful to have a production cost tracker. It is single issue rate making, of course. It also requires that customers take on the burden of proof of proving that a cost is not appropriate for recovery. It also causes the utility to be less efficient. It disturbs the balancy of the efficiency incentives that a utility should have. It isolates one increasing cost without considering decreasing costs at the same time. And it is not consistent with just and reasonable rates in general. Our witness has testimony on this issue on the production cost tracker, and we will be glad to call her to the stand for any questions that the commission has. Thank you.
Do the commissioners have any questions? All right. All right, then the company may call their first witness on this issue. Oh, I'm sorry. Oh, I'm sorry. I very specifically kind of had that in front of me, and I'm like, we still have public counsel, but it has been a long day.
There's no handout this time. There's no presentation. I'm going to keep this quick. There's two parts to it. First, I'm going to hit you with the policy, and then I'm going to throw another monkey wrench into it based on what's already been said before. Okay, policy-wise, this is really simple. You are removing the incentive for them to be efficient. I want you to think, let's say you own your own business, right? You have to buy goods. In this case, you have to buy chemicals. If the cost of chemicals go up, you're not without, recourse. You can shop around. You can look for different suppliers. You can find ways to get cheaper chemicals. You own a home. You're responsible for your own energy bills. The energy bill goes up. You have options to try and fight that down. You can install cost-effective lighting. You can turn down your air conditioner in the summer, turn down your heater in the winter if you're using electric heat. This idea that these are costs completely beyond their control is wrong. They can control these costs. And if you give them a tracker, they have no incentive to stay efficient. Basically, it's like if you owned a company and you had to buy chemicals and somebody came along and said, hey, it doesn't matter how much the chemical cost increases, we're just gonna pay the difference. We'll give you the difference no matter what. Well, guess what? You no longer have any incentive to try and keep costs low. It's bad policy for that reason alone. Now, the second half of this is the monkey wrench I'm gonna throw into this, and Judge, I really want you to focus on this. In order to have a tracker, you have to have the numbers you're gonna track against. And the problem is, in this case, several of the items they want to track have been resolved by black box settlement. So you don't actually have the numbers against which you can have a tracker at this stage. I fundamentally don't think that you can do the production cost tracker in this case under any circumstances, because the numbers being tracked are already settled via black box. You can't authorize a tracker when you don't have anything to track against. Does that make sense? I don't know, why am I asking you? I apologize. Anyways, those are my 2 points. Are there any questions?
Yes, Commissioner Coleman.
I just want Mr. Kleiser to know that we've been insulted by better people.
I was more meaning the fact that you can't answer my questions than anything, but.
All right. Thank you, Mr. Kleiser. All right.
Plus, you didn't have a handout, so I'm disappointed.
All right. On this issue, the company may call their first witness.
We will call Mr. Brian LeGrand.
Mr. LeGrand, do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Please state your name.
Brian LeGrand.
By whom are you employed and in what capacity?
So I am very recently employed by the American Water Service Company, but still as the Director of Rates for Missouri.
Okay. And that's slightly different than your title that was utilized in your pre-filed testimony, correct?
Correct.
Okay. Have you caused to be prepared for the purposes of this proceeding certain direct testimony, supplemental direct testimony, and rebuttal, surrebuttal, rebuttal testimony?
Yes, I have.
Is it your understanding that that testimony has been marked as Exhibits 12, 13, and 14 for identification?
Yes.
Other than the change in title that we just talked about, do you have any changes to make to that testimony at this time?
I have one very minor correction.
Okay, would you go ahead?
In my rebuttal, surrebuttal testimony on page 16 and line 4, the number at the end of that line, or excuse me, line 3, the number in that line is missing a 0 at the end, so the number should be $1,040,000.
And is that the only change you have?
That is, yes.
If I were to ask you the questions that are contained in Exhibits 12, 13, and 14 today, would your answers with the amendments we've just discussed be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Okay. Your Honor, I would offer Exhibits 12, 13, and 14 into evidence and tender Mr. LeGrand for cross-examination.
Any objection? Exhibits 12, 13, and 14 are admitted. All right, Mr. Graham, do you have cross-examination for the witness? Kleiser?
No, thank you, Your Honor.
Mr. Kaufman?
No, thanks.
Mr. Opitz? Ms. Plesha? Any questions from the commissioners? All right. There is a single question that I have, and it relates to your direct testimony. So, it's page 33 of your direct testimony.
Okay, yes, I'm here.
At the, near the bottom of that page, line 20, and this is answer to the question, if approved, how would this tracker work in practice? You state, after new rates take effect in this case, the company would compare the actual cost, production cost expense recognized on its financial statements to the amount allowed in rates, excluding production costs associated with acquisitions that have not yet been through a general rate case. Would Missouri American adjust the production cost for lost and unaccounted for water?
I don't think that's how I would propose it be designed. I mean, the unaccounted for water is part of the overall production of taking in the water, treating it, and then getting out to the distribution system. So I think that is a cost of producing that water.
All right, thank you.
Sure.
Any recross?
No.
Okay. By any of the other parties? I'll take that as a no. Redirect.
No questions, Your Honor.
All right. Thank you for your testimony, Mr. LeGrand.
Okay, thank you, Your Honor.
And if the hearing schedule is still the same, that would bring us to staff witness Amanda McMillan. Ms. McMillan, do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Graham.
It's Amanda McMillan, AMANDAMCMELLEN.
And Mr. Graham, I'm going to interrupt real quickly. You know where I was going with that. Yes, your microphone.
Thank you, sir.
Thank you.
Ms. McMillan, are you employed by the Public Service Commission?
Yes, I am.
In what capacity?
I'm a utility regulatory audit unit supervisor.
And is your employment information, professional experience, and your qualifications described in your pre-file testimony or its exhibits and attachments?
Yes, my Schedule 1.
Have you caused to be pre-filed in this case as Exhibit 209, your direct rebuttal testimony, and as Exhibit 222, your cross-rebuttal testimony?
Yes.
Do you have any corrections to your testimony?
I have one correction to my direct rebuttal testimony.
Your direct rebuttal testimony is Exhibit 209.
Yes.
And that's the testimony also for the record that contains your investigation, your conclusions, and your recommendation with respect to the production cost tracker that is the issue before the commission today.
Correct.
And what are those corrections, please?
Page 10, line 22, where it states December 31st, 2022, that should be 2024.
And is that your only correction?
Yes.
Okay. Now, as corrected, if I ask you the questions that were posed to you in those exhibits, 209 and 222, that testimony, would your answers be the same today as those recorded in the exhibits?
Yes, they would.
And are all of your answers to those questions true, accurate, and correct?
Yes, they are.
Judge, at this time I'd offer exhibits 209 and 222.
All right, any objection? Exhibit 209 and 222 are admitted.
Thank you, Judge. At this time, I will tender the witness.
All right. Any cross on behalf of the company?
No, Your Honor.
Public counsel?
Good evening, Ms. McMillan.
Good evening.
Are you familiar with the stipulation that was filed in this case?
Yes, I am.
And specifically, I'm referring to the first stipulation, the ones that resolved among other things, select expense items.
Yes.
And would you agree with me that that stipulation included the settlement of select expense items for a lump sum?
Yes, I agree.
And that included settlement of purchased water, fuel and power and chemicals and waste disposal?
Yes, that's correct.
You would agree with me that if the commission accepts that stipulation, there will be no authorized rates for those items because it's settled by this lump sum in the settlement?
I'd object to that question. I think it calls for essentially a legal conclusion that is something for the commission to decide later.
Let me withdraw the question and attempt it another way. How would staff determine the authorized rates in this case if this stipulation, how would staff determine the authorized costs for those items in this case if the commission were to adopt this stipulation?
I don't know that we could.
Would you agree with me that in order to have a tracker, it is necessary to know what number you're tracking something against?
That is my understanding, yes.
All right, thank you. I have no further questions.
Mr. Kaufman, do you have cross?
No cross, thank you.
Mr. Opitz? No, thank you, Your Honor. Ms. Pleasure? Any questions from the commissioners? All right, I have no questions myself, so thank you.
Okay, thank you.
Your Honor, I would like a little redirect.
Yes, redirect. Again.
Kicking me.
Just
Following up on this.
In my defense, I got very, very little sleep last night.
That's all right. I almost let it go for the same reason on my behalf. But then my client prodded me. Ms. McMillan, back to Mr. Kleiser's question, and there was an objection to that question on the basis that it called for a legal opinion. You recall that examination and those objections?
I do.
Okay. Are you familiar with the agreement?
Yes, I am.
Okay. And you're here representing the staff?
I am.
Okay. I'm not asking for your legal opinion. Is the agreement that the expenses that Mr. Kleiser identified will be excluded from rate base increase? Or how did you describe it? Well, it's a black box settlement, but the expenses that are involved, some of them are involved in this tracker issue, are they not?
Yes.
And those have been resolved, that it is the agreement of the staff that those expenses have been resolved by black box.
Correct.
Okay. That's all the questions I have.
All right. Now, Ms. McMillan, you may step down. Thank you.
Judge.
Your Honor,
Yes.
I do not know what your intentions are. I expect that I might have some more extensive cross of staff witness for the last issue for today. I also, however, tentatively think that we might have a little bit more free time in the upcoming. I don't know what other availabilities are, but I'm just going to potentially move the rest of cash working capital further in the schedule and call it a night.
There are
Oh, I'm sorry.
potentially other witnesses.
I forgot that. You know what? I'm going to take the same excuse. I also did not get a lot of sleep last night. I was ready to be done.
Out of here.
All right. Mr. Opitz, would you like to call a witness on this issue?
Your Honor, MECG recalls Ms. Jessica York to the stand.
Go ahead, Mr. Opitz.
Ms. York, your testimony has been submitted and accepted into the record, and I would tender you for cross-examination by the parties.
Any on behalf of Consumers Counsel? Ms. Plesha, it's always awkward for me to ask this question. Is it cross or is it direct? But do you have any questions?
Yes, I do have a question for, I do have a question relating to the issue of single-issue rate making and why the production cost tracker is, in her view, in her testimony, not appropriate in this case. Could you explain for us your concerns with the production cost tracker?
Yes, as you mentioned.
Never mind. Go ahead. I'm sorry.
Okay. I did testify that this represents single issue rate making. And because, I mean, you'd be tracking a certain bucket of costs, you know, without considering potentially offsetting changes in other components of the cost of service. In addition, I mean, when you look at this particular category of costs, like the fuel and power, chemicals, waste disposal, and purchased water, in Mr. McClellan's schedules, MWM1 and MWM2, I mean, they are relatively small portions of the overall revenue requirement. I think it comes out to be about 6% of the total, based on their claimed revenue requirement. So it just does not seem like a volatile, unpredictable, you know, outside of the company's control kind of category of costs. I would also note that in terms of the cost that they wanted to track, fuel and power, I think, was a relatively significant component of that. And I know, you know, Ameren, Missouri is one of the utilities that serves them, and they're in a rate case right now. So presumably those rates will be set, you know, for a couple of years, and they should not be unpredictable. And I think chemicals was another relatively significant component of that. And I mean, I think one of the company witnesses' testimony talked about how they buy those in bulk, you know, through the service company to get better pricing on that. So again, I don't think the production cost tracker is necessary in this case.
No further questions, thank you.
Thank you, Mr. Graham. Do you have cross?
No, Your Honor.
All right. Mr. Cooper.
Yes, Your Honor, thank you. You mentioned a percentage of revenue requirement in regard to the production costs, I believe. Do you know the percentage of the expenses that they would represent?
I did not look at that in terms of just expenses. I was looking at the total.
Okay. Your counsel mentioned, I guess, what I commonly have called the UCCM case in her opening. Is that something you're familiar with?
No.
Okay. In your testimony, you suggest that the production cost tracker allows the company to recover certain components of its requirement on a piecemeal basis outside of a full base rate case. Is that correct?
I did say that.
Do you understand that the production cost tracker proposed by the company would not allow for recovery of expenses between rate cases?
Yes, yes.
Because it's a deferral, correct?
Right.
And so ultimately, you would agree with me that the company proposes that any actual recovery or refunding, I suppose, depending on whether it's an asset or a liability, would be as the result of an amortization of deferred amounts in the next general rate case?
That's how it would work.
And again, so there's no surcharge between cases, correct?
Correct.
So it would be unlike the fuel adjustment clause or the PGA or some other things where there are charges between rate cases, correct?
I would agree with that.
Okay. Do you believe that all trackers constitute unlawful single-issue rate making?
Objection calls for a legal conclusion.
Sustained.
Are you familiar with any trackers that have been commonly used by this commission?
No, no, not.
So like the pensions and OPEBs tracker, that doesn't, not something that you
No.
have any knowledge of?
No.
Okay. That's all the questions I have, Your Honor.
All right, thank you. Mr. Kleiser, I apologize. Did I deprive you of an opportunity for cross?
That's quite okay. I had no questions.
Okay. All right. Are there any questions from the commissioners? All right. I do not have any questions myself. Is there any redirect?
I have none, Your Honor.
Okay. Any on behalf of MECG?
No questions, Your Honor.
All right, thank you. Ms. York, your excuse, thank you.
Thank you.
And that brings us to Ms. Mantle on behalf of Public Counsel. Go ahead.
Ms. Mantle's testimony has been offered and accepted into the record, and she's still under oath. I tender the witness.
All right. Any cross-examination on behalf of Consumers Council of Missouri? Okay. MECG? MIEC? Staff? All right. And the company?
No questions.
Okay. Any questions from the commissioners? All right, hearing none, I have no questions myself, so, thank you. All right, it is 5:40. Mr. Kleiser, you suggested that we put off the remaining witnesses for cash working capital. How do the parties feel about that? Mr. Cooper?
Well, given Mr. Kleiser's representation that he has lengthy cross-examination, I'm in favor.
Okay.
Judge, I would actually be in favor of doing it tonight or potentially moving it to Wednesday since we have an open spot. I think the schedule's pretty busy for tomorrow.
I have no objection to moving it till Wednesday. I just kind of want to get home.
And your witness, can be available that day.
Give me 1 second. You can be available? Yes.
All right. Then if there's nothing further, we'll adjourn for the day.
Judge, just
Sorry.
one other item. While we don't necessarily object to Wednesday, hopefully that's not a decision we're making that's set in stone at this moment, because I suspect we'll have a chance on Tuesday to finish it up. But
For what it's worth, Mr. Riley will be in the building, I think. We'll make him available whenever we need to.
And Judge, I think the same can be said for staff.
Okay. All right.
I don't know if this needs to be on the record.
Okay.
Never mind.
Then if there's nothing further, we will go off the record and adjourn for the day. Going off the record.
Thank you, Judge.
Mm-hmm.